Y'all know I'm not a huge fan of soft sits. They frustrate the poo out of me, but I don't think I've ever seen one in front of Judge Manning, and list's pretty good. Thanks to Mikhail for sending it over to me.
Wimbishi.
Kapuma.
No, your last name.
I am Kapuma.
Okay. What's your last name? Wimbishi?
Kapuma is my last name.
Okay. So what's the first one then?
Wembeshi.
Okay, there you go. They have it reversed. Thank you. Okay.
Yes.
Yeah, okay.
Oh, they have it reversed? Okay.
So it's Wimbishi Kapuma.
So your name is, like, your last name is Kapuma then?
My last name is Kapuma.
Okay. We'll make sure I didn't want to destroy it, too bad with my accent. So I guess they need to know that because they have it reversed.
Yes, and because of that, it's an invalid contract.
Well,
Because
not necessarily. That's just a typo, but
yeah, but according to this,
we're just kind of getting started here, okay? So I'm just trying to pronounce your name right. That's basically all that is, okay? All right, so this is number 122 CP 214772. Here it's Kapuma Wimbishi, but it's actually Wimbishi Kapuma. So I think they could probably modify that at the jail. I guess y'all want to take care of that. Okay, so we got 285 days without indictment. He had a Ferretta hearing and he's representing himself. So it's aggravated battery, willful obstruction of a law enforcement officer with a felony. Officer, if you could raise your right hand for me. You swear affirm testimony about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right. If you state and spell your name into the microphone for the court reporter, please.
Yes, ma'am. My name is Patrick Marsh. First name is spelled Patrick. Last name is spelled Marsh, Marsch.
Okay, Officer Marsh.
Okay, so 1 second. So, sir, what this is a preliminary here. Okay, it's just to establish that there's probable cause. So the DA is going to ask some questions, and then you get to ask follow-up questions. Okay. All right. So go ahead, Ms. Fields. And this is Ms. Kelly Fields. She's one of the assistant district attorneys. Go ahead, Ms. Fields.
Thank you, Judge. Officer Marsh, can you tell us, you already told us your name, but can you tell us where you work and what your title is?
Sure. I work for the City of Atlanta Police Department, and my title is rank as an officer.
Okay, and are you post-certified?
Yes, ma'am, I am.
Were you post-certified on the date in question? On December the 15th of last year?
Yes, ma'am, I was.
And can you tell us what happened on that day?
Sure.
Mr. Kapuma.
Sure. So on that day, I was dispatched to a call at 1776 Peachtree Street. There was a fight going on that apparently was going on the 4th floor at the clubhouse. We had received several calls as well, arriving on scene from a passerby saying that there might be a weapon involved. So I immediately called for backup. Officer Jones and Officer Easton arrived on scene to assist me. We go up to the 4th floor. We go to the right where the clubhouse was, and we found a white male victim named Keith Johnson that had a gash to his forehead. We had asked him what had happened, and he said that he had been knocked out by the defendant.
When you say knocked out, can you tell us what that means?
Sure. So apparently the defendant said that they had noticed, the victim had noticed the defendant acting in a strange manner. And when he went to put his hand on his shoulder to ask if everything was okay, he advised that the defendant hit his upper right eye with a closed fist, causing him to go to the floor and was unconscious.
Okay.
During that time.
So he was unconscious?
He was unconscious, but he was not unconscious when we arrived on scene. But
you were gaining consciousness?
Yes, ma'am.
Okay, now you said that this happened at what address?
1776 Peachtree Street.
Is that in Fulton County?
Yes, ma'am, it is.
And can you identify the defendant and describe what he's wearing and where he is in relation to you?
You can stand if you need to.
Oh, I got it on the screen here, ma'am.
Yeah, that's okay.
Thank you very much. Yes, I can see the defendant. He is wearing a blue Fulton County uniform with a white shirt under it.
Okay. Let the record reflect that the witness has correctly identified the defendant.
All right, noted.
So we talked about that Mr. Kapuma rendered this man, Mr. Hugh, unconscious. And is that the basis of the aggravated battery?
Yes, ma'am. So under the code section of 16524, the elements of the crime for aggravated battery indicate that you render a limb unconscious. And so with the brain being a member of the body, we decided to go ahead and move forward with the aggravated battery because the brain was rendered useless during that time.
During the time that you was unconscious?
Yes, ma'am.
Okay, and did EMS arrive?
I'm sorry?
Did EMS arrive?
Yes, ma'am. Mhm.
And what happened with that?
I'm sorry?
What happened with, excuse me, I was talking
Okay,
about-
all right.
What happened with that?
So during the incident of while we were trying to get the defendant into custody, he was resisting myself and numerous officers. So one of the officers on scene had to deploy a City of Atlanta issued taser in order to try and get him into custody. And during that time, that's why we called EMS to go ahead and have them remove the prongs as well as go ahead and check his vitals because he did appear to be acting in some type of irregulated manner, whether it could be on, just having a mental breakdown or something of some nature, but he clearly needed some medical attention, which is why we go ahead and called EMS as well.
Was EMS called for Mr. Hugh?
Yes.
Okay, did he allow them to treat him?
He did not need EMS. When we got there, we asked him, he said that he did not need it. Some of the witnesses and the friends who were at the event were tending to the victim.
Now, with the charge of willful obstruction, was there any violence or offering of violence or just resistance?
There was no offering of violence. There was just actively resisting when giving verbal commands.
Okay. And you said that Mr. Hugh Johnson was concerned about how Mr. Kapuma was acting.
Yes. So
Can you describe how he was acting and what you were told?
yes. So what I was told by the victim is that at some point this was a company event that was going on. And during the course of the event, at some point, the defendant had put, according to Mr. Johnson, had put his AirPods into his ears, and he started being very incoherent, saying a whole bunch of stuff that Mr. Johnson didn't understand. And according to him and several other people at this event, they had never seen the defendant act in this manner before. And so when Mr. Johnson went to put his hand on the defendant's shoulder, that's when the defendant acted out.
That's when the altercation happened.
Yes, ma'am.
Okay. Do you have any other statements you'd like to make to the court regarding these two charges pertinent to this case?
That's pertinent to this case, no.
Okay. So I have for right now, it's your witness, Mr. Kapuma.
Mr. Kapuma.
Okay, thank you, Your Honor. I have a question, right? Because according to this warrant, first of all, it shows here that he was called for a fight.
Okay, step back. What questions do you have for the officer?
Yes, that's who I'm asking, because I can't see him, so.
Oh,
You
okay.
can't see him on your,
Okay, so he was called in for a fight, right? So according to this statement, Keith Johnson put his hand first on me. Then I reacted to that with a punch. It doesn't show how hard he pushed my shoulder. It was in a hostile situation because I was at a party.
Okay, so stand by. Mr. Kapuma. What is your question?
So
Who, what, where, why, when?
so
how?
in that situation, who was the aggressor in that situation? Because he put his hands
Hold on.
first on me.
Just ask a question.
Mhm.
So, okay, so based on when we spoke to the witness, I had the witness actually show me how he placed his hand on the defendant. And Mr. Johnson said he basically just placed his hand in a almost caring way, just a concerning way on his shoulder to see if everything was okay. And that's when the defendant acted out and hit the victim.
Okay, next question.
So is there a written signed statement from the witness about that incident to describe what you're saying so that they sworn like a
Hold on.
sworn
Who,
affidavit?
what,
I
where,
said-
why,
I'm
when?
gonna have to object, compound question. Can we?
All right. So you ask a question like this. Do you have a written statement from the victim?
Do I have written a statement? No. Do I have it on body camera? Yes.
Okay, next question.
So there's body camera for the entire event from all 5 officers of what happened.
Yes, so my body camera was activated from the time I arrived into the parking deck before I made contact with anybody up until the very end of the incident as well. So there is a full body camera footage from start to finish, including a body camera footage from each of the officers during the interaction as well.
Okay, so from my recollection, right?
Whoa. No. If you want to say something, you have to ask him a question. So she asked him questions, so you ask follow-up questions to what she asked.
Okay. So based on the body cam video that you're saying, does it show that I was tased until I passed out or died and then had to be resuscitated?
So the body camera footage from Mr. Jones, I would appear because Mr. Jones is the one who tased the defendant, but the defendant at no point in time lost any consciousness or at any point in time had to be resuscitated by Grady.
Okay. Next question.
So this, I understand. So when will I be able to see the body cam? Because I haven't had a chance to look at it, see what exactly happened on that event.
Well, all of that gets turned over at discovery, but allegedly you were there. So what's your next question for him?
According to the law, which I'm new to, did I give consent to be arrested? Because according to the
Judge, counsel, or I don't know if I should call him counsel, but
That's actually,
he's been testifying, and so we object to testify.
so did you give consent to be arrested? Did he give you his consent to be arrested?
Your Honor, he did not consent to get arrested, but based on the elements of the crime, we had enough probable cause to make the arrest.
Okay, next question.
because based on my understanding,
No. Next question. If you want to say something later, you can, but what's your next question for him?
okay, so in terms of the resisting arrest, is it not my right not to resist if there's no jurisdiction over me?
Stand by.
You said stand up?
No, I told him to stand by. I didn't know if you had an
Oh.
objection.
Yes, I have a judge, I understand you're giving him leeway and I understand the reason for that. However, counsel has been not asking direct questions on cross and he has been testifying numerous times. So we just have an overall objection to that testifying that's been happening from pretty much from the start of this questioning. So we ask that he ask direct questions, you know, not have this kind of commentary in addition to his questions.
So what you're asking is him to draw a legal conclusion. So
Yes.
what's your next question? What's your next question for him?
Because for me, it's mainly about consent and jurisdiction.
Okay, hold on.
Mhm.
But that's argument. But what question do you have for him?
I don't have any questions for him.
All right,
Okay.
anything else with the officer?
I do have some redirect.
Okay, go ahead.
So officer, I know I was calling this the victim Hugh, that was my mistake. I meant to say the correct, and the correct victim's name is Keith Johnson, is that correct?
Yes, ma'am.
And Mr. Johnson was hit by Mr. Kapuma,
Yes, ma'am.
okay, and that's all I have.
Thank you, ma'am.
All right. Any follow-up based on those questions that she asked?
Basically, not really.
Okay, thank you,
Okay,
officer. Stay safe
thank
out
you.
there.
Thank you very much, Your Honor.
have
Stay
a
safe
good
as
day.
well.
All right, go ahead with the argument. What's here from the state?
So Judge, I believe that we have met our burdens for our probable cause for the first charge, which is aggravated battery. The defendant did render Mr. Keith Johnson's brain useless by, you know, rendering him unconscious for a period of time where he did, you know, fortunately regain consciousness, but he was rendered unconscious for a little while after he was struck by Mr. Kapuma. And as far as the willful obstruction, we understand there was no violence or offering of violence against, you know, the officers and you know, Mr. Marsh and other officers at the party. So we suggest that should be a misdemeanor and not a felony. But other than that, we think there's probable cause for both charges as just stated by myself and the state.
All right. Do you want to respond? Now, this is where you give argument. So now is your chance to give argument.
Okay, so first of all, based on just this warrant, my name is spelled in capital letters. It's in reverse. From my understanding of law, that's a name of a strawman or a corporation. So that does not apply to me because it says the accused is capitalized. That's a corporation, and a strawman, which has no bearing to me. And in this matter, I do not give consent or agree to represent my strawman in this case because I'm a sovereign being. I'm an internationally protected person. But at the same time, from my understanding of the constitutional law, which is the law of the land, I have to give informed consent or sign a contract in order to be judged or in order for the case to move forward in this regard. Because according to the Fifth Amendment, one of the things is before I can be arrested or detained, I have to be indicted. I have not been indicted. One, I did not give consent to be arrested or to be tried under this jurisdiction because I operate under common law. That's my jurisdiction, common law, God's law, and natural law. I do not consent to be tried by the Admiralty law system, which is evident by the gold fringe on the flag and the eagle at the top, which shows this is a maritime law, which is commercial law. And as a sovereign being, I report to God. God is my judge. As it relates to how I interact with other humans, it's only by common law, which is when I injure a human being, and that's also dealt with in the common law court. And based on my international status, because I am a king where I come from, an internationally protected person. So according to Executive Order 143107, which is human rights, this is a violation of human rights. From my understanding of the law and my rights, my unalienable rights, if I have not given consent to be tried or to be held or to be detained by or given jurisdiction authority to the officer, and they arrest me, that's a kidnapping, and I'm being held hostage right now. Because according to the Constitution, I have to be indicted before I can be detained. That's according to the Fifth Amendment rights. And the Constitution, from what I understand, is still the law of the land. Because according to the Supremacy Clause, every case, if I can cite one case, which is the Madison versus Marbury, every case in that situation, which cited that case as into the legality of the constitutional unconstitutionality of any situation, was overturned by the Supreme Court. So in this situation, yes, I did react to Keith Johnson putting his hands on me. Though the witness may have said something, they might have been friends with Keith Johnson. I reacted to a situation. For every action, there's an opposite and equal reaction. He touched me first. I reacted. When the officers came to arrest me, I didn't do anything wrong but defend myself. I've been charged with willful obstruction. According to the Constitution, according to my unalienable rights, according to my human rights, I've got the right to defend myself. If I put up on anyone over here and just touched you on your shoulder without even asking for your consent, some people will tase me. The officer will shoot me. But if the same thing happens to me, he touched me first, I reacted off of that. That's self-defense.
Okay, anything else? All right, so I'll find probable cause on the aggravated battery, and then the misdemeanor, the willful obstruction will be reduced to a misdemeanor. And we'll go ahead and address bond. Let's see, because right now, bond, let's see. Right now, as of June 27th, there is a $30,000 good bond.
The defendant has 3 cycles. The defendant's last arrest was May the 9th, 2021 in Dunwoody, Georgia, for Terroristic Threats Act and possession of a firearm during commission of a felony and criminal attempt to commit a felony. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition, Your Honor.
All right. Go ahead with your bond argument, sir.
First of all, it was just a punch, and I don't see how it can be a felony. And if it was pretty much a misdemeanor at best, because one, it was self-defense, misdemeanor at best, the maximum is 1 year, and I've already done 10 months in jail pretty much for one punch in self-defense, in defense of myself. At the same time, I feel like I have already done the time for this.
Okay, anything else? All right, what says the state?
Judge, the state is inclined to keep the bond as is because severity of the injury that took place. Yes, Mr. Keith Johnson, he rendered unconscious. The punch that, counsel is trying to minimize was very severe. The punch took him out. So because of that, and then him resisting arrest, we do believe that the $30,000 bond is sufficient.
All right, so it'll be no further contact with Keith Johnson. Stay away from 1777 Peachtree Street Northeast. You're gonna have no drugs unless prescribed, no alcohol, no weapons. It's going off my bond order of 627. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. Are you still gonna live in Roswell, sir?
Sandy Springs.
Sandy Springs, okay. All right. So just supply a good address to the jail upon release. So 15,000 count one and count two is reduced to misdemeanor, so that'll be 5,000. So $20,000 good bond. Best of luck to you, sir.
This is another one of those cases where there's not much to look at, but what you hear is pretty interesting. This is Judge McBurney, which most of you have heard of before, and he is quite interesting to listen to. This is supposed to be a bond hearing, but when he goes to call the case, he finds a motion to disqualify him, and the reasons are kind of interesting. Also, the circumstances regarding the bond hearing are a bit much too. So here we go.
Well, new at 6, a rapper who is a member of YSL faces murder charges following a shooting in Southwest Atlanta.
So we have Mr. Moody in court. I need to get a couple things on the record, and then we'll talk about a motion that I just received. Ms. Rivers, are you ready to shift to Mr. Moody's case? Okay, this is 23 CP 219784, State versus Moody. Mr. Moody, good morning. I'm Judge McBurney. Your lawyer, Mr. Arrington, is on the screen. You can see right there. He's not here in court. I need to have you affirm to me on the record that you're comfortable having whatever discussion we're going to have this morning with your lawyer appearing virtually rather than sitting right by your side. Are you okay having a conversation with Mr. Arrington being on the screen? Yes, sir. Okay. So Mr. Moody, in theory, we were going to talk about a bond motion that Mr. Arrington filed on your behalf. You've been arrested for murder and at least a firearms offense, and unindicted murderers get assigned to the elected judge who's presiding rather than going through to be heard by a magistrate. And yours was assigned to the calendar that I happen to have. I received a motion that your lawyer filed today that says that you are a living and self-aware man and that you believe I should be recused because I have deliberately violated other litigants' personal liberties in the past, and I have wantonly refused to provide due process and equal protection to all litigants. So I'm not quite sure what that means, but that's what we need to talk about first, because it may be that we don't get to bond. And if I have to recuse well, I don't know that I have to recuse, but another judge is going to have to hear this recusal motion. And then we'll see if this gets assigned to someone else. But I just want to let you know that we may not get to bond. I'm going to turn it over to your lawyer, Mr. Arrington, and he can let me know how he wants to navigate this, and we'll go from there.
Thank you, Judge. I think Mr. Moody certainly would like to get out and would like to be heard on bond. I think that maybe one of my associates may have filed that motion. Obviously, I think, as you well know, the motion for recusal should have been based upon your previous position that you do not believe that I can represent litigants in Fulton County Court because I am also a Fulton County Commissioner. And to the extent that you don't believe I can represent anyone ever in Fulton County, and included that in an.
The more I dig, the more interesting this case gets. We haven't even got to the good stuff yet. I'm kind of interested to see what Judge McBurney's argument is on this. As you can see from this org chart, the Board of County Commissioners is kind of parallel with the justice agencies where McBurney would be in the Superior Court. So I'm not really seeing an overlap. I mean, I'm sure he has a really good argument for it or else he wouldn't have made it, but it's not really being discussed. And that's kind of interesting to look at the org chart for the county, for Fulton. So there you go.
Order. And so, and you have previously recused on cases, recused yourself on cases where I represent litigants. While I disagree and think that you can hear them, that has been the court's position as it regards me serving as a lawyer for 20 years and then being elected as commissioner after serving as a lawyer in 20 years in Fulton County. And so the language that was contained in that motion to recuse, what I have seen Your Honor do before is to just automatically recuse. And I believe that the previous chief judge entered an order after you entered your previous order, so that I would not have to have cases in front of you. And so I hate that we are in this place, but we are where we are. For purposes of bond today, Mr. Moody is present, his mother, his family members are present. I'm sure that they would prefer to go forward with the bond hearing today, and we could likely deal with the recusal issue later. I guess, however, if you're only going to be hearing it through indictment, then perhaps that issue will resolve itself.
Right. So two things. One, there's now a motion to recuse, so that would have to be withdrawn. But two, I thought about this when I learned that this was a case for which you were representing Mr. Moody. I am comfortable handling a preliminary matter like bond if Mr. Moody gets indicted and you stay on as his attorney, and it were assigned to me. So that's a lot of ifs. I suspect you'll stay on and you'll be his lawyer, but there's only a 1 in 15 chance that this case is assigned to me following an indictment. I would follow my customary practice based on what I think is an appropriate application of the Code of Judicial Conduct, and I would recuse. I don't see that bright line rule applying to something. I don't mean to suggest that bonds aren't substantive, but this is a preliminary or procedural matter. It's not the trial. It's not taking a guilty plea and deciding sentencing, et cetera. So I'm comfortable handling a bond hearing and managing this case until it is indicted. But that doesn't mean you're comfortable with it. And based on this motion, I've engaged in prior unethical and illegal conduct. So I'm not quite sure where that's coming from. I thought you and I had a reasoned disagreement. That's not the language you chose to use. And
But Judge, I think my associate may probably file that. I did not file that and was unaware that it was filed. I think Mr. Moody would like to be heard on bond today. And I think we would withdraw that motion, or I will withdraw that motion for purposes of the bond hearing today. And as you stated, the issue would probably resolve itself as if the case ever gets indicted.
Sure, no, automatically will, because it'll either go to a different judge, or if I get it, I'll recuse, and it will very quickly be reassigned to someone else. It won't hold anyone up come indictment time. Well, if you are withdrawing the motion to recuse that was filed at 8:24 this morning, then we can move forward with bond, and you can share with me what you want to about Mr. Moody and his situation. And if his mother has something she wants to add, or anyone else, I'm happy to hear from them as well. And then I'll hear from Mr. Abate and any members of the victim's family.
Thank you. Thank you so much. Mr. Moody is 20 years old. He does not have any convictions nor any significant criminal history other than minor traffic arrests. His family, all of his family resides in the greater Atlanta area and throughout the state of Georgia. He is a graduate of high school graduate of Life Christian Academy. He is currently has a record deal with Warner Brothers Records, Warner Records.
Okay, I think now's a good time to stop and do a quick fact check. So, Mr. Jacoby Moody is a rap artist out of Atlanta. He records under the name Effin' Da Dealer. F-N-D-A-D-E-A-L-E-R. It's kind of hard to read on the screen. And he is actually signed to the label YSL Records, which I didn't know stands for Young Stoner Life. For some reason, I thought that there was a slime or something in there. I haven't really followed that trial very closely. But apparently, he's one of the few that didn't get caught up in the YSL racketeering trial. And everybody was kind of focused on him because he was still making music and, you know, keeping his nose clean until this incident happened. Interesting that his attorney should say he records for Warner Records because that sounds so wholesome and clean. And you're like, oh, that's nice. No, it's actually YSL, and the parent record label. YSL is an imprint of 300 Entertainment, and 300 Entertainment was founded by the former chairman and chief executive officer of Warner Music, and also the ex-president, I believe, that a lot of the Warner people left Warner and formed 300 Entertainment, which is a subsidy of Warner Music Group. But, you know, there's a lot of degrees of separation between Warner and YSL. I'll tell you that. That's where, you know, facts are facts, but sometimes you have to, you know, lay the facts out a little more specifically in order to understand them. So Mr. Moody has one album that I can tell, and he has also been featured on quite a few of the YSL albums.
Close, you know what I mean? Shit, I wanna see. Take the hood off. I'm gonna be the last thing he seen.
That is a clip from one of his songs that is featured on YouTube. So let's continue.
And so he is employed, gainfully employed. He is a father. He has a 2-year-old daughter. And he is also a lifelong member of Faith Baptist Church. His mother, and other family members are on the call and certainly would like to speak. Judge, we have not, the only thing we have received in this case is an affidavit for arrest that says he was a party to a murder. We do not have any other information. I do not know when and where the preliminary hearing will be decided, but based on the information that we have now, there's not even enough information for probable cause. The state has not shared anything with us outside of the affidavit for arrest, which just says he was a party to a murder. It doesn't describe any facts, any situation. Unlike Attorney Patterson, there's no video that has been made available to us. And so we attempted to get a consent bond because there's just such a lack of any evidence that we don't understand how the state can even proceed. And I guess we would certainly want to be heard at some point in the future on the preliminary hearing calendar, if necessary, to determine if there's even, obviously if he gets a bond, he won't have that opportunity, but we just don't have any information to base anything on.
Let's get back to breaking news we're following in southwest Atlanta this morning, where we just got new information about a deadly shooting at an apartment complex.
At 0205 hours this morning, Zone 3 received a call of a person shot at the location. Zone 3 officers responded and arrived within 2 minutes of the call. Upon arrival, they located the victim unresponsive in his vehicle. Indications are at this time that two males approached this victim while he was in his car and fired multiple rounds. The victim did sustain gunshot wounds, and he succumbed to his wounds at the scene.
So 2 suspects you're looking for?
Well, there were 3 individuals, 2 people were shooting.
2 people were shooting.
They left the scene in a black Dodge Charger, no tag.
So there's actually cameras and images they call of the shooters?
We are reviewing cameras at the scene.
Do you know what led to this? Was it a fight or?
I have no idea.
No clue yet.
No clue.
So let me say one thing in response to that. I suspect you and I will learn more from Mr. Abate about what the state thinks the facts and circumstances are surrounding your client's arrest. If there are materials that seem to be particularly significant, let's say there's a reference to a video or a statement, number one, I'll ask Mr. Abate to make that available to you. And then 2, if I think that that is particularly persuasive, we'll reconvene after you had a chance to look at it and pick at it so that you could try to rebut it or explain it. So it may be that we both, you and I, learn things today that cause me to think, I don't know that bond is a good idea, and cause you to think, I'd like a week to look into this. And of course, you'll get that week, and we don't need to wait till day 90 to revisit it if there is information that I direct the state to give to you. So you're not the first lawyer at these very, very early bond hearings who says, I really don't know why my client got arrested. And so you should tell me more about his situation in terms of what you know, and I'm happy to hear from a few folks on his behalf, and then we'll both learn a little bit from what the state has to say.
Thank you, Your Honor. I'd like to call his mother at this time to speak.
All right, let me get her. Is that Natanya? She's on mute.
Yes, it is. Good morning, Ms. Moody. Will you, Judge, would you like for me to swear her?
Yep, you're good. So no, you don't need to, Mr. Arrington, if Ms. Moody is going to limit what she has to share to character, reasons why bond is appropriate, you can ask her questions, or she's free to just narrate. That's how I typically handle it. If she's going to get into specifics about this case, then she certainly will need to be under oath, but that's typically not what the family members do.
Thank you, Your Honor. Ms. Moody, if you will, please speak to what you know about Jacoby's character and tell the judge why you believe he should receive a bond in this matter.
Sure. Good morning, Judge. First, I would like to say that we were unaware, Jacoby's family, all of us was unaware that we could actually be in person in the courtroom. So we apologize for that. And I would like to apologize to Jacoby for that if he can hear us, but we all are here on Zoom.
Sure. So I'm going to interrupt you. I'm going to interrupt you for 1 second. He can see you and he can hear you. Your son can.
Okay.
So in this day and age, you appearing this way is fine. As long as we can see and hear you, which we can quite clearly, then what's important is what you have to say, not that you are 10 feet away from your son as opposed to on a screen. Okay?
Thank you very much. Jacoby is actually my miracle child, Your Honor. I wasn't supposed to have any kids, and I ended up with Jacoby. Jacoby has been a sweetheart since he was a kid. He never gave me trouble in school, elementary school, middle school, or high school, never suspended, never got into fights. He was the kid that everybody wanted to be around. He was the kid that if he was picking on another kid, he would be the kid to tell you, hey, that's not cool. Jacoby has a 2-year-old daughter. All of his family is here. He goes to church. He works here. He was also baptized at the same church that he attends currently to this day. Me and his father have raised him to be the young man that he is today, which he is an astounding young man. Jacoby has never been in any trouble, school-wise, legal-wise. He doesn't have a record, Your Honor. I'm trying to figure out myself, along with Mr. Arrington, why we are here.
I'm sorry, go ahead, Judge.
No, it sounded like you got cut off. So Ms. Moody, was there anything else you wanted to share?
That's it, Your Honor.
Okay, well, thank you for making yourself available. And again, it's not an issue that you're appearing virtually. In some ways that makes it easier for everyone. Mr. Arrington, was there anyone else?
Yes, Your Honor, 2 more witnesses. Jackson, who is his manager, would like to let him speak to his employment. And Jackson, if you can, please state your name for the record.
Sure. Good morning. My name is Jackson, Jackson. Last name is Weingart, Weingart.
All right, thank you. And can you tell the court about Jacoby's musical career and his record deal with Warner Brothers and his employment?
Sure. I first met Jacoby about 3 or 4 years ago. I believe he was 16 or 17 years old. In that time, we've accomplished a lot together. We've gotten him a record deal. He's been able to put out 2 bodies of music, 2 full-length projects with 300 Entertainment as well as Warner Music Group. But most importantly, in that time, I think I've become somewhat of a mentor, a friend, and certainly a family member of his and the Moody's. And I've had the opportunity to work in music for 10 plus years. I run my own record label. I work with artists big and small. And for me, it's about not just determining what artists to work with, but what artists not to work with. It takes so much more than being talented today to make it. And I knew from the first song and the first time I met with Jacoby that he was obviously extremely talented, but for him, there was so much more than that. He's kind, he's loving, he's dedicated, he's determined. And all of those things are the reason why I have chosen to work with him. And he's hopefully chosen to work with me as well over the last 4 years. And he's just at the beginning of his budding career. Prior to this incident, he had plans to do a full-length album with a multi-platinum and Grammy-nominated producer named Wheezy.
It really sounds like this kid had a lot going for him and he had the potential to have a successful career. So I'm having a hard time with it. So what prompts you? Like, what beef is so, overwhelming that you have to take care of it and risk ruining your entire life? As I was doing background research on this, I actually found where he did a little brief interview with some YouTube channel talking about how to stay safe in Atlanta. Check this out.
Time. They've heard about it, they've researched it, but now they're hearing it from someone who was born, raised, and still resides in ATL.
Yeah, shit. Don't try to pipe up, be gangsta and shit. Your ass get wet. For real. Keep your doors locked on your car.
But generally speaking, how does one stay safe visiting Atlanta?
Shit. Just mind your business. Just goddamn, try to stay out of the way. That's all I can really say.
Which we were in the middle of scheduling. But beyond that, we caught up every week about music, about life, about family. I have been able to watch him, grow from a 17-year-old kid to become a father. And every time we talk about furthering his career, it's never about, oh, I want to get a new car or I want to be rich or famous. It's never anything materialistic or egotistical. It's always about, I want to do this so I can move my family out of my old neighborhood. I want to do this so I can put money in a fund for my baby girl to go to college. I want to do this so that, Jackson, you make enough money that you can take care of your family. And I think that's why we've really bonded, because I do everything I do every day to take care of my girlfriend and my parents, who I'm still taking care of to this day. And I think that's why we really came together. And I've gotten to know him and see him grow from a young kid into a young adult now. And it's been an honor to come be a part of the ride for him. And I know that his family and providing for them is the most important thing. And I don't believe he would ever put himself in a position to ever be unable to do that.
Okay, thank you. That's a helpful perspective.
Sure.
Mr. Arrington, you said you had one more.
Yes, Your Honor. Ms. Cummings. Ms. Cummings, you're on mute. If you could.
Am I unmuted? Am I unmuted?
Yes, ma'am.
Okay.
If you could please tell the judge how you know Jacoby and what you know about his character and why you think he should get a bond.
Yes, Your Honor. I am honored to provide the court with a character letter for Jacoby Moody. I have known Jacoby since birth. I am his auntie, and during his child.
Ms. Cummings, you looks like you froze on us. Judge,
why don't we do this, Mr. Arrington? Ms. Cummings may well be able to reconnect, and we will come back to her. If you have more you want to share, you can. Otherwise, we'll pivot to Mr. Abate.
For his daughter
She's
is
back.
unconditional.
Ms. Cummings, we need you to start over. Looks like we lost her altogether. Judge, before we go on, if I could just ask Mr. Moody's mother, Ms. Cummings, looks like she's back. But Ms. Moody, can you tell us how many other family members are present? Looks like you're on mute, Ms. Moody.
Can you hear me?
Yes.
Yes, ma'am.
What was your question?
How many other family members are present?
We have about, we have 24 here that's actually listening to everything and waiting for an outcome. But the judge said it didn't matter if we're in person or we're doing video. So it's 24 of us that's in here right now, but Jacoby's whole family is here. I'm here, his dad here. He's been with us since birth. So, and all of his family is here.
Okay, thank you. And Ms. Cummings, you froze on us, so if you could please start over. We were not able to hear pretty much anything that you said.
Okay, no problem. Can you hear me now, sir?
Yes, ma'am.
Yes, ma'am.
Oh, okay, Your Honor, I apologize. As I stated, I'm honored to provide the court with a character letter for Jacoby Moody. I have known Jacoby since birth. I am his auntie, and during his childhood and early adult life, I have always known him to be a well-mannered and humble person. The parents of Jacoby Moody have always provided ongoing guidance and support in being involved in the community and church. They made sure he attended summer camp to keep him involved in the community and to stay away from trouble. Jacoby is one of the most respectful people that I know in this family. His heart is genuine when it comes to his family and friends.
The love for his daughter is unconditional, and I have nothing but positive things to say about Jacoby. Over the years, I have witnessed Jacoby being a noticeable example for his other cousins that were getting in trouble and having mischievous behavior. Jacoby has a bright future awaiting him, and I would hate this false accusation to destroy everything his parents worked so hard for and himself worked so hard for. He wants and needs to be a productive citizen with a bright future that awaits him. If the court would please consider my reference letter on his behalf, I would appreciate it.
Thank you, Ms. Cummings.
Yes, sir.
Mr. Arrington, anything else?
Judge, I believe that's all that we have at this time.
Okay, I will come back to you after I hear from Mr. Abate. Sir.
Thank you, Judge. The state would respectfully request that you deny defense counsel's motion for bond for several reasons. The first being the state would submit to the court that the defendant is a significant risk of committing felonies pending trial. He does have two prior pending felony cases out of Clayton County. The first being from May 4th of 2022, and the second being from 14 days later, May 18th of 2022. And in each case, he is charged with the possession of a firearm under the commission of a felony, and he is in the possession of a Schedule II substance, oxycodone. In the second case, he's also charged with tampering with evidence. Both of those cases are still pending in Clayton County, and the defendant is out on bond, or was out on bond at the time of this offense when this occurred. So I'd submit to the court that he's a risk of committing felonies pending trial if released while waiting for his case to be reached by the Superior Court, Your Honor. I'd also submit to the court that the defendant is a threat or danger to the community and the people in it based on the sheer facts and circumstances of this case. What I can tell the court is that this case is, the motive for this case is a revenge shooting, for lack of a better word, Your Honor. A couple days earlier on May 30th, this incident occurred on June 5th, but in the Lakewood area, the defendant was out near a gas station or locally off of the Lakewood Avenue, and there was a shooting in that area. Several of the defendant's friends were struck and injured, but not killed, Your Honor. What the investigators have been able to determine in speaking with witnesses is that was the motive for the killing of Mr. Tremaine Gasper in this case, Your Honor, Glasper in this case, Your Honor. What the investigator has been able to uncover is that in the days after the May 30th shooting, the defendant believed that he was set up by Mr. Glasper and began looking through the city to find him. There are several witnesses who indicated that the defendant called them asking where Mr. Glasper's child mother's, where she lived, and the address was given. And that was ultimately where he was killed inside of his vehicle. What the evidence would show is through LPR video footage, or the cameras throughout our city captured the defendant's license plate in the area of the shooting. But before entering the apartment complex, he covered his license plate with some sort of cover that would not allow you to be able to see his tag. Upon leaving the incident location after shooting Mr. Glasper, he believed he was out of view of the video surveillance, and he uncovered his tag. And his tag is then caught seconds after the shooting, leaving the exit of the apartment complex off of McDaniel Street, where Mr. Glasper was ultimately shot and killed in his vehicle, Your Honor. So based upon all of that, the state would respectfully request that you deny bond. As the defendant laid in wait, waiting for Mr. Glasper to come down from the apartment, and as soon as he entered his vehicle, shot him. Be perfectly candid with the court.
So that last bit that you're adding, that's from surveillance video, that's from witnesses who say that, or?
That's from witnesses, Your Honor, who have described what they saw as when Mr. Glasper got into his vehicle. What they saw the defendant get out of his Charger and run towards the vehicle where the victim was seated with two other individuals.
And it's the Charger that has, while it's at this apartment complex, according to you, the covered up tag, and then it leaves and the cover is removed from the tag.
That's correct.
You described a situation where, when your words, the defendant thought he was far enough away, he removed the cover. Is there video footage of anything like that, or it simply shows some tag readers show, I'm going to make up the color, a red Charger with a covered tag, and then just a few minutes later, there was what looks like the same red Charger going in the other direction, and the tag is uncovered? How do you, as best you understand it, how do you prove up that a tag was covered and uncovered?
So I will be candid with the court. I haven't seen the video, but what's been described to me is it's not an LPR video surveillance, photograph. It is actual video surveillance that is pointed out, that leads out from the apartment complex, and you can actually see the tag be uncovered.
Okay.
It's too far away for them to determine who's actually uncovering it, but it's a car that matches the description of the vehicle owned by Mr. Moody, Your Honor.
Okay.
I'd also bring to the court's attention that through speaking with the detectives and our local gang unit here with APD, it is, I guess, well known that the defendant is a member of the YSL record labeled, gang, whichever one you want to, however you want to describe it.
I try not to say those three letters because that's another judge's problem, not mine.
That was the intel that we were able to uncover as it relates to that. I can, as I continue to gather information, provide Mr. Arrington with what I receive. It's just early, very early in the stages of the criminal prosecution. So
it is. No, it's both early but late. Mr. Moody's been in jail for a while now. And so I'm going to ask you to get to Mr. Arrington, whether it's your team expediting from getting from APD, maybe some of this video footage, whatever you think would be most compelling. If you suddenly had to make a presentation to someone that we think we have the right guy in this case, to get that to Mr. Arrington. So he's in a position to say, well, that's fascinating, but my client has a blue Charger, and this is a red. Here are photos of my client's Charger. It's blue. In all these photos you've got, it's a red car. So there's clearly someone in a Charger, but not my guy's Charger.
Yes, Judge, and we're able to confirm it's his Charger, as his cell phone, the records, they move with the Charger. So wherever the Charger is seen on the LPR camera footage, his phone's
the old cell phone records. And I don't want to say that you've got the wrong Charger. I just want to make sure Mr. Arrington has a chance to have a full-throated response to, because he's in that unenviable position of, look, my client got arrested, and that's about all I know. And it's hard to push back against what you've presented.
Yes, sir.
Okay.
Mr. Glasser's mother would like to make a statement, as well as his fiance, Ms. Glover, when
of course, in whatever order you want to do that. Good morning. You are?
I am the mother of the victim, Tremaine Glasper. My name is LaShawna Glasper.
Ms. Glasper, thank you for being here. Can you spell your first name?
Yes, sir. LASHANAGLASPER.
Okay. First, I'm sorry for your loss. Yes, please.
As a parent, your worst fear is to have to bury your child. And this senseless murder has been a living nightmare, knowing that my child is gone together. I have to constantly remind my granddaughter, who is 8 and truly doesn't fully understand that no one is going to hurt her. We are constantly looking over our shoulders in fear because there's still 2 other accomplices. The home that I raised my kids is now hard for me to be there alone because of fear. We now feel vulnerable and scared at all times. Anyone in this courtroom could have been in that parking lot that night going home. My grandkids could have been in the car with their dad that night. It is our right and responsibility to do everything in our power to protect our families and fight to protect our city and community. Your Honor, I'm requesting on behalf of my family and the community to exercise the power you have to ensure that another mother doesn't have to experience this type of tragedy. I respectfully request that you do everything in your power to deny bond.
Ms. Glasper, how old was your son when he was killed? Okay, and the 8-year-old that you mentioned, that's his daughter?
He has two, 3-year-old and 8-year-old.
Okay, all right, thank you. Good morning, ma'am.
Good morning.
Could you share your name?
Yes, my name is Diamond Glover.
Okay, Diamond as in hearts, spades, and whatever the other one is, diamonds, okay. Glover? All right, thank you.
Good morning, my name is Diamond Glover. I was the fiance of Tremaine. We share a 3-year-old daughter. I'm pleading today that no bond is given to the suspect to provide my family with reassurance, safety, and comfort. The suspect in question came to my home that I share with my 4 children, one of which was Tremaine's. The situation has brought me trauma and a constant reminder of fear that the suspect or the associates could return to my home. I've had to open my life, make uncomfortable changes which affected myself and my children mentally and financially. I also work from home, so it has definitely impacted me financially. Denial of blood will not bring Tremaine back, but it definitely will give my family peace of mind, knowing that the suspect does not have access or opportunity to cause my family or anyone else, as well as my neighbors, to foresee any more danger. Children live below where Tremaine was shot. Anyone could have been hurt or harmed.
So, Ms. Glover, Mr. Glasper was shot right outside your apartment, is what you're, okay.
I heard the gunshot. I can't recall how many. 2 minutes later, he was inside of the home. He walked downstairs. 2 minutes later, I came and I had to find his body.
Okay.
My friends have kids that stay on the first floor, directly where Tremaine was killed.
Right, at the ground level.
Yes, I had to leave my home, go from home to home, because my kids, not only my 3-year-old, but my kids aged 13, 12, and 10, they are afraid. Sometimes we can't even sleep.
Okay, thank you, ma'am. Mr. Abate, anything else?
Nothing better from the state, Your Honor.
All right. Mr. Arrington, as the movement, you get the last word. I'm going to reiterate. I know you are reacting real time to some of what you heard Mr. Abate said, and I think it's only appropriate that as he gets discovery and he needs to, through his team, expedite some of this, we get some of that to you so that you can begin to process it. But you've heard some things. It sounds like cell records, LPRs, et cetera. Tell me if there's anything more you want to add.
Thank you, Your Honor. My understanding is that 3 weeks earlier, Mr. Moody was shot, and while he was with Mr. Glasper, they were both shot at. There was a drive-by shooting, and several people were, potentially shot. And apparently, my understanding, Your Honor, is that there was a hit out for Mr. Glasper. And so they were together 3 weeks earlier. They were friends. Mr. Glasper and Mr. Moody and others were both shot at 3 weeks earlier. Mr. Moody actually got shot. Apparently, Mr. Glasper also called Mr. Moody to check on him after that to see if he was okay. And so the idea that this would have been a revenge shooting against Mr. Glasper, who was also a victim of the drive-by shooting with Mr. Moody, and who called to check on Mr. Moody to see if he was okay, doesn't make any sense. It just defies logic. Certainly, we're sorry that Mr. Glasper was killed in this fashion, but, Your Honor, Mr. Moody was not the one that did it. He and Glasper, again, were both victims of a drive-by shooting 3 weeks earlier. And apparently, there was a hit out on Mr. Glasper. And so we think that Mr. Moody meets the Ayala factors. We do not think he is likely to commit any other crimes. We do not think he is a flight risk. Certainly will show up for court. I'm representing him on the Clayton County matters. Those matters were initially started out in misdemeanor traffic court and apparently were transferred over later, but they started out as traffic offenses in magistrate court.
When I have to export the charges to an Excel spreadsheet to be able to look at them because there's so many, there's a little bit of an issue. Okay, so keep in mind all of these are from 2022 except for one. There are 7 tint violations, all occurring different time periods, some of them on the same date. There's an open container, tampering with evidence, possession of a weapon, and violation of Georgia Controlled Substance Act, and another tint violation that happened back in May, which I think that's what they're talking about. It was bound over to Superior Court. Then there is another violation of Controlled Substance Act, possession of a weapon, tampering with something, open container, and another tent violation from last November. And then the day before that, there's another controlled substance, possession of a weapon, and tent violation. So some of those are pending. Some of them have been disposed, but all of them are from 2022, and there's one in 2023. And that's because he just turned 18 in 2022.
My law partner also represents him in his deal with Warner Brothers Records. And so we have had a long relationship with Mr. Moody as a client. The two charges in Clayton County in May, again, my understanding is they both started out in magistrate court as traffic offenses, and they may have been later upgraded, but none of those cases involve violence. And the gun that he had is registered to his mother. And so we would ask the court to grant a reasonable bond. We think that a $75,000 bond would be reasonable. Certainly would not have any objection to the court imposing an ankle or wrist monitor as the court sees fit. But given the lack of any credible information regarding Mr. Moody, and the warrant says that he was a participant. The warrant doesn't say that he did the shooting. It says he was a participant in the murder of Mr. Glasper. And so if the allegations were in fact that he was the shooter and that he got out and shot Mr. Glasper, I would suspect that that would be included in the warrant, and that the warrant would not say that he was a participant. And so, again, Your Honor, we think that we have met the Ayala factors. We asked the court to grant Mr. Moody a bond. We do not believe that he will commit any crimes while out. He does not have a record of committing crimes. He's gainfully employed. And we asked the court to enter a reasonable bond in this matter.
Okay. I do want to read into the record the language from the warrant. It's sort of in between accusing him directly and the language. You're paraphrasing it pretty well, Mr. Arrington, but what the murder warrant says is that the accused, Mr. Moody, did unlawfully and with malice aforethought cause the death of another human being by taking place in the shooting death of the victim, Tremaine Glasper. Never really seen a warrant worded like that. It is not saying that he did it directly. It sounds more like he was part of a crew. So it is some peculiar wording, and that may fit in with what we heard a little bit, not as evidence, but what a couple of the witnesses said about how there were a few people maybe in or out of this charger that the state is associating with your client, Mr. Moody. So it does sound like there's more to be told about this story. Mr. Moody, at this point, I'm not going to set a bond, but I'm going to leave open the discussion. I have a couple concerns. I appreciate that the cases that you have in Clayton County started out in magistrate court, but in the span of just a few weeks, it sounds like you got picked up twice with a gun. The second time is more of a problem because you were already on bond for the first one if you got picked up for the second one. And now we've got a situation where you are alleged to have been involved with guns actually being used. I appreciate Mr. Arrington's point that the Clayton cases there's nothing violent about them. It's drugs and a gun allegedly associated with them. And Mr. Arrington's telling me it's your mom's gun and it's registered to your mom. Doesn't necessarily mean you should be rolling around with it, allegedly, but those facts are out there. I need Mr. Arrington to get more information from the state about these license plate readers and some of the video footage. And then if we need to, we can revisit this question about whether there is a bond that I could set that would assure not your appearance. I'm less worried about that. I think you wouldn't want to run away from the business opportunities you have, and even more fundamentally to what your mother was saying and your auntie, that you wouldn't run away from family obligations, in particular your daughter. I'm more worried about you being safe and the people around you being safe. By your lawyer's own admission, you got shot at a few weeks before this happened. So you're rolling in some tough spots, and I want to make sure that there's not additional blowback from everything that's happened, whether you getting shot at, Mr. Glasper being killed, et cetera. What I'm going to call the forensic evidence that the state has described. So this wouldn't be a witness saying something, but it's cameras or cell phones or this or that saying things. Those are harder to rebut because there's no bias to those things. They, in my mind, at this early juncture, sufficiently connect you to these very, very serious allegations that I want you to stay right where you are. But Mr. Arrington knows very well how to reach my staff. And if we need to reconvene to revisit this question of bond soon, we'll do that. There's another important checkpoint. At day 91, if you haven't been indicted, you are absolutely entitled to a bond. And I know Mr. Arrington will reach out to my staff saying, hey, it's day 91. And then I'm required to set a bond, even if I have some misgivings about whether you'll be safe or Ms. Glover's family will be safe. The law requires me to set a bond, and I'll do that. If between now and then your case is indicted, then you're going to be in front of a different judge, and Mr. Arrington can make all these same arguments. And more importantly, he'll be entitled to get all this discovery. So he's not sort of shooting in the dark where he's at a bit of a disadvantage. That's not his fault. It's not Mr. Arrington not being prepared. He worked with what he had, which is what he's learned from talking with you and maybe family members. So that's where I am now. Mr. Arrington, now I'm just repeating myself, but as you get information from Mr. Abate, if you think we ought to revisit this because there's new information you want to argue from, or if you're not getting information from Mr. Abate, meaning the DA's office, please reach out to Ms. Nelson about that so that I can get in the mix and say, I appreciate that discovery really hasn't started running yet, but this is a question of your client's liberty pending indictment, and I'm happy to get involved in that way. Anything else, Mr. Arrington, at this time?
Judge, Mrs. Moody would like to say something else if you are okay with that.
I'm okay with it, Ms. Moody. I just want you to know that I've made my initial ruling, so it's not going to advance a whole lot for your son to say, Judge, you made the wrong decision. I bet that's what you think, because I know what you wanted me to do. I heard you clearly, and I heard Mr. Arrington very clearly. I've decided what I've decided for now, but I'm happy to revisit it. But Ms. Moody, if you want to unmute, I'm happy to hear one brief thing from you, and then I need to get to my 11 o'clock calendar. But currently, your video.
Hello?
Hey, who's this?
This is Mrs. Moody.
Okay, I can't see you. Can you turn your video on, Mrs. Moody? There you are. Okay, yes, ma'am. Yes, ma'am.
Yes, Your Honor. I heard everything that you were saying. I wanted to just say, I'm sorry what happened to the victim as well. But I wouldn't think that his mother will want two injustices to be done. And you were saying that you don't want to give Jacoby a bond because you want to make sure he's safe and that they are safe. However, we're the ones that's not safe. They have put out all of our information, my brother information, our address to where we live. All of Jacoby's information has been put out from the clerk office. It has the stamp on it and been sold to blogs with his social security number on it, his address. So in fact, we are the ones that are in danger because all of our information is the information that has been put out. And once again, him and the victim was friends. When the shooting happened in Lakewood, they were running together. He wouldn't call my son to check on my son if him and my son had some kind of problem with each other. And the prosecutor was just saying that my son is in a gang of YSL. Also, that is not true. He has
Ms. Moody, I'm going to stop you now. I don't think your son is in YSL just because he is a recording artist who may be under the YSL label. I appreciate what Mr. Abate said, but I want to promise you, my decision wasn't driven by the fact that your son is a potentially successful musical performer who might have some connection with that record label. That's not it at all. I don't want us to relitigate this, but I do want to say this to everyone in the room. It is very important that the Glasper group go in the Glasper direction and not get the Moody's involved with this at all. If there's something you're concerned about, you work through victim witness support, you work through the prosecutor. And I'm going to ask Mr. Arrington to let me know so that I can let the prosecutor know if there are concerns beyond what Ms. Moody has just shared, because what this cannot become is back and forth, back and forth. It may well be that Mr. Moody, the Moody sitting right in here, and Mr. Glasper were at one time close. They're not close anymore. That is clear. And the families aren't close. They need to maintain a distance. In some ways, it's better that Mr. Moody's family didn't come here today because you'd all be in the same courtroom and I'd have to let the Moody's leave first. And then folks who are here for Mr. Glasper would need to wait to leave. Be smart about how you handle this going forward. It will not benefit Mr. Glasper if folks associated with the Glaspers are picking at the Moody's. And the same goes to the Moody's. You need to stay in your lane. And if you have concerns, Ms. Moody, you share them with Mr. Arrington. He gets them to me. And if I need to find people in contempt, I can do that. I can bring someone into court and say, you need to knock this off. And if they don't knock it off, I have ways of dealing with that will have an impact. So keep papers. If you get text, if you get something, get that to Mr. Arrington. He can get it to me or ultimately the judge to whom the case is assigned. And we can do something about that. I'm not taking sides on this. Well, I'm going right down the middle saying, folks associated with Mr. Glasper, hold your grief and don't direct it in the wrong direction. And folks associated with Mr. Moody, you need to process what you're processing. Don't compound the tragedy. We have one lost life. And it doesn't need to get more complicated than that because that's already something that no one can fix. Okay, I appreciate Ms. Moody, you sharing that first part. The other stuff, I hear you. I've decided what I've decided right now. Mr. Arrington's going to get more information about your son's case. And if we need to revisit it, I will gladly do that. We will make time for that. Okay. All right.
Yes, Your Honor.
Mr. Arrington, anything else?
That's all, Your Honor. Thank you.
All right, thanks for your time. And again, I'm sorry for your family's loss. Mr. Abate, anything else?
No, Judge.
All right, thank you, everyone.
The question of the day is, should the punishment fit the crime or the criminal? Does somebody having remorse and trying to make amends change how much they should be punished? This is a horrific wreck, automobile accident, and this gentleman is being sentenced for causing 3 deaths.
And your case with Chance Craddock.
But first, we will start with breaking news tonight. A deadly crash on Highway 82 in Port Arthur.
Yeah, we're zooming in, showing you this happened around 8 tonight on the highway near the Valero refinery. That road still shut down in both directions as we come on the air here at 10 o'clock tonight. This is new video just in from the scene. We understand one vehicle flipped and ended up right next to the fence at the plant.
Now, police haven't released many details, but they did confirm 3 people have died. Again, the road remains closed. We will have the latest on air and online as we know more.
Three cases, 21-37536, 37537, 37538. The state of Texas versus Chance Glenn Craddock. Mr. Craddock is present with his attorney, Mr. Macon. In each of these cases, the defendant is charged with the second-degree felonies of intoxication manslaughter. As I understand this was one wreck, collision, and 3 lives were lost.
3 lives, yes.
Pre-sentence report has been prepared as the defendant in August pleaded guilty in each of these cases. And the court has reviewed this and other accompanying documents. Are there any additional documents that the parties wish to add before I allow each party to present any additional information? Any paperwork?
We have nothing additional, Your Honor.
Oh,
We furnished the court with everything.
okay. Then the defendant has been charged with second-degree felonies in each of these cases. So he is facing no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 in each case. The plea agreement is that the sentences shall run concurrently. It says open plea, which is actually it's to run the agreement is that all the sentences shall run concurrently, but he is subject to the full term of confinement and fine for each case. But the sentences shall run concurrently. Is that the understanding everybody has?
Yes, Your Honor.
Yes, Your Honor. All right. Pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes? First of all, from the defense?
Your Honor, the only thing I would point out is that only Danny Nichols Jr. was decapitated in the wreck, not all the victims decapitated. I mean.
Okay.
That's correct. Yes, no objection to that. That's correct.
But they were
horribly killed.
Yeah, it's tragic. Anything else?
Nothing at this time.
What about the state? Anything else to add?
No, Your Honor.
All right, go ahead, Mr. Macon. Where to begin?
Your Honor, this.
Well, there's no this is going to be emotional for everybody involved. Everybody.
It is.
But let's
do
our best and move forward, because we're trying to fix a tragedy here.
True. And what makes this case different from all the other cases we've seen is Mr. Craddock's actions after. No, he shouldn't have taken his medication and driven. No, he shouldn't have taken his medication and drank and drove. And he's at fault, and he's accepted that. He blew a 1.10.
Which is intoxication.
Yes, he was intoxicated. From the moment he was released on bond, he sought to work with your permission. He's not driven. And the money he's earned, he's able to put aside. I think it's now a savings account of some $22,000 that he wants to somehow get it to the surviving young man. And under the new law that went into effect in September 23rd, I think some provisions can be made not only for that lump sum, but continuing child support for Mr. Craddock after whatever the judge does. In addition to that, he has set up a scholarship at Lamar University in the names of the deceased and funded it with his own money. And we continue to do that. And if that can be made part of the order, that's fine with us, but he will continue to do that. That in no way, is any salve to the surviving families. They lost loved ones, and they'll mourn them for years. And Mr. Craddock has, on my advice, not contacted any of them to do anything to express his regret and sorrow. That's all I have.
Stay.
The prosecutor is about to describe the accident in pretty gruesome detail. So if you don't want to hear that, then I would suggest turning it off now or skipping ahead to about 20 minutes in. In addition, I forgot some photographs. None of them show anything bad.
Judge, these three who died and the young child that was in the car, and one of them that died was 13 at the time. I really don't know how to describe this because they were just going shopping. That's all they were doing that day. They were minding their own business, driving down a public highway, not bothering anybody. And this man not only hit them, but went over the top of their vehicle, taking Mr. Nichols' head off. I got to tell you that I can't imagine what the family's going through, and I apologize to the family for describing this, but I got to tell it what it is because I think you need to know. I can't imagine what the family's going through. I can't imagine what the first responders were going through when they saw it, because all I've seen is the other photos, Judge. And to see Mr. Nichols' head laying on top of the 14-year-old who's crumpled in the back seat of that car is an image that I'll never be able to get out of my head. And it's something that I'll carry with me. And I don't even come close to what the family has to deal with. Not only was he driving on the wrong side of the roadway, but a witness saw him an hour before driving down the wrong side of the road, stopped, get out of his vehicle, and then got back in his vehicle and drove again. This time on the other side of the highway, driving down the wrong side of the road. He mentioned to the officer that he knew he had double vision while he was driving, so he knew he shouldn't have been safely behind the wheel. He was reckless. He was just about doing what he wanted to do, and his intoxication got the better of him. I don't doubt that all these letters that he's given are nice letters, and they say wonderful things about him. But Judge, that doesn't take away the fact that there's a 13-year-old that's not going to grow up and have a chance to do wonderful things in her life or for other people. There's two 30-year-olds. One was 30, I think 35. One was 32. Mr. Nichols was 32. And Ms. McDaniel was 35 at the time. Young people that still had a lot of life ahead of them, and would have been able to see this young 13-year-old Ariana in the back seat, been able to see her grow up, go to high school, prom, get married, have a life of her own. But it was cut short because this man's selfish decision to drink and take medication and get behind the wheel.
There were 4 people.
There was a 3-year-old that was not injured in the car.
What a miracle.
Yes, it was a miracle, and that's only by grace of God was the 3-year-old not killed. You don't do something like that and walk back out of a courtroom with everybody else. You just don't. There's just no way that he can ever repay what he took that day. There's not. But there is some justice in this world that we can actually make him pay for what he took that day. I gave him a gift by running these concurrent when the statute allows for them to run consecutive, even if they're in the same act. And so I'm asking the court to give him the 20 years. I think he earned it by what he did that day. And I think that was be just and fair under the circumstances and the situation.
New developments tonight on the driver charged with intoxication manslaughter in that crash that killed 3 and injured a child. According to new documents obtained by 12 News, Chance Craddock admitted to police that he had double vision after taking several medications. Police say when they first spoke with Craddock at the scene, his speech was slurred and his breath smelled like alcohol. A test at the scene determined he'd been driving at twice the legal limit.
Any response?
Your Honor, I think Mr. Craddock has a very short statement in that period.
Go ahead, sir.
Your Honor, I'd just like to start by saying my apologies to the family. I know they don't mean anything, and I can't change anything that I've done. I own up to my mistakes. I wish it was me instead of them. I know I can't bring anyone back, but I would like to be able to support them any way I can possibly, for however long it takes.
What else? Anything else? Couple of things. In the pre-sentence report, it was requested that the court look at the photos. Do you have that?
I do, Your Honor. Not printed out. I do have them on this. So.
No. Oh.
Would like for me to put them on my computer so you can look at them.
Let me ask you just a couple of things here. And Mr. Craddock, it's hard to say anything about an accident where it's deemed you're at fault and 3 people are killed. And I've presided over so many of these types of situations, and people take it for granted that those are not much more than 4,000-pound missiles, which do terrible damage to human tissue when they collide. When the officers arrived and spoke to you, your first statement was that you weren't at fault for the wreck, and you believed that the Cadillac swerved into your lane, and you did what you could to minimize the damage. You also denied drinking any alcohol, although your blood alcohol showed that you were intoxicated. You stated you did not consume any alcohol prior to driving. You did drink alcohol the previous night, which would have been over a day before. Can you explain why those came out of your mouth during that period of time when you had everything to lose by not telling the truth? Why would you falsify those statements at that time?
Your Honor, honestly,
Yeah, honestly.
I was scared. I've never been in trouble before.
So the first
And at
thing
the
you came
time-
out was lying?
No, sir. At the time, I wasn't really sure. I was shook up from the wreck.
Okay.
And now I know everything was my fault. I own up to that, but at the time, no, sir, I was not really sure. I don't remember most of that part. To be honest with you.
During the pre-sentence interview to the probation office, you claimed that you had never drank to intoxication. Is that true?
Yes, sir, that's correct.
But you reported drinking to intoxication for approximately 4 years. It states at the time of the substance abuse assessment listed below. Here in this. The defendant reported a 7-year history of alcohol use in the substance abuse assessment. 4 of those years to intoxication. It states that the person who did the substance abuse assessment believed that you are in denial of addiction and you do not see your consumption of alcohol as being a problem. Why would she say that? When you have everything to lose by not being accurate and truthful? Why would you hedge at this time?
Your Honor, at the time, I must have misunderstood the question.
You misunderstood the question?
I'm not really sure. At the time of my drinking, no, sir, I don't think that I had a problem. I didn't see that I had a problem. Now, after what I've created, what I've done, because of my drinking, I see that now.
It says at the time of the substance abuse assessment, you reported drinking to intoxication, to the state of intoxication for approximately 4 years. That's it right here. Why would you say that if it wasn't true? I mean, that's not true, or is that wrong? I mean, that's important here.
What was the question?
During the pre-sentence interview with the probation officer, you said that you had never drank to intoxication. But during the substance abuse assessment in front of Ms. Posey, you stated that you have a 7-year history of alcohol use, with 4 of those years drinking to intoxication.
Yes, sir.
Which was the last reported use approximately May 2021, which would have been on or about the date of this.
Yes, sir, I do believe the last 4 years of my drinking was, I had a problem.
Okay, all right, that's your statement? That you drank to intoxication for about 4 years?
Problem, yes, sir.
Let me see.
Just we tap it. It's
Let me- How many photos on here? Tap it where?
There's a lot
I'm
on
sorry.
the key right there on the pad. Just tap on the middle pad.
What the court is saying is obviously a catastrophic automobile collision between 2 automobiles. One is on its side and it's up against another vehicle, and the Cadillac is where the deceased.
That's correct, John.
The top of the vehicle has been torn off. That's in Port Arthur.
Yes, sir.
There's little chance of survival. Apparently, the the vehicles stopped when they made contact with each other and didn't move very far, which if you're going to even the speed limit there, it's a catastrophic event. There truly is no way to describe decapitation of a human being.
No, sir.
It doesn't have words. At the end of the day, what were your injuries, sir? From this,
Sorry,
what were your injuries from this collision?
my injuries, I believe I had back injuries. Knee injuries and back injuries, yes, sir.
I have received some letters on your behalf written by people who know you. And they all seem to state similarly that you are a good person who is very remorseful for this event. And here, at least on yours, you are taking complete responsibility. You state, I take complete blame and responsibility for my actions. And now you have a family of your own.
Yes, sir.
A child.
Yes, sir.
Well, is there anything else you wish to add before the court renders its decision?
Your Honor, I'm not beneficial to me. I'm not worried about what's beneficial for me. I want to be able to help the family. I want to be able to do for them and provide and to anything that could help is what I'm worried about. And I know time in prison, I wouldn't be able to. I'm not capable of helping. And the main thing I worry about is being able to help and men and show them that I'm not a bad person. I did mess up and I own up to that. I messed up that day. Something that I can never bring back or fix. I would love to trade places with the family. It would be perfect for me to be in their shoes instead of them. I want to be able to help them.
Anything else from anybody? All right. If not, I'm going to find as follows, sir, that in each of these cases, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading true. There was sufficient evidence supporting your pleas of guilty in each of these cases to find you guilty beyond a reasonable doubt. Unfortunately, you can't go back in time. Unfortunately, you cannot bring lives back. And unfortunately, the way the law is based is that when a life is lost because of wrongful acts done, there's really little quid pro quo. There is no equality in administration of a sentence. What ends up happening is that another person becomes punished. And in this type of offense, it really doesn't take an intent to harm anybody, to be guilty of the crime and be punished. And it all goes back to, I'm afraid, something that we take too lightly because we don't even have driver's education as a major rule anymore. Like when I grew up, I had to take driver's ed. But it was, you learn methods of safety that are with you forever. Now it's just a video game. It's like a video game. It's been over 25 years since a day has passed in this state where there hasn't been a fatality on the highway. That long, and probably will never be a day. And unfortunately, people take operating a 4,000-pound missile for granted because it takes sobriety. And when you are intoxicated, it becomes kind of a selfish thing because you're high, you're enjoying life, I guess. Meanwhile, everybody you pass is in harm's way, and the way your responses were all wrong at the time. You apparently were incoherent. It wasn't my fault. I'm not drinking. They must have swerved in front of me. All of those were wrong statements because you put yourself in a position to where other people were not as important, which is the price that they pay and the price you have to pay. I don't like this because these are situations where you don't have to intent to hurt anybody, but it's more of I thought of myself first and others were second. And you're supposed to be third. Others, God, you third. And as a judge, the one thing I wish I could do is somehow have the ability to bring those poor people back. The only thing we can say that has any comfort for the victim's family is that what I see is they were killed instantaneously. There seems to be from what I have become trained with in 43 years of being a lawyer, there was an instant and that was it. And they were with God. I hereby find you guilty beyond a reasonable doubt in each of these cases. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years, which shall run concurrently. It is a terrible price. There is no winning in any of this. Those people want their family back. Your family has lost you for a 20-year sentence. There is no way to fix this except to send a message that actions like this have strong consequences for those who are blameworthy. We've seen what juries do in this court, and they assess the maximum. And everybody's seen because they make the front page. In this court, the jury trials we've had, the maximum has been assessed in each case. I know what juries do. And here, we've never had a case in my experience as a judge where 3 lives were lost, which each has its value that you cannot quantify. And the loss of everyone involved to their being able to share, hug, and enjoy each other's life until a natural life ends, which was taken short by actions which are really different from what you seem to be overall, but on this occasion were quite selfish because it was just about getting high and enjoying drinking, jumping into a 4,000-pound missile, which I just wish somebody would have gotten to you, grabbed you and said, you're about to
Yes, sir.
ruin your life as well as others. This court feels under these circumstances that this court assessment is as close as what is fair and just under these circumstances as can be, since I don't have the ability to bring lives back. And I don't have the ability, minute before this happened, to whisper in your ear, pull over. You're making a big mistake. All right, that is the sentence of this court, and you are hereby taken into custody.
Which we do have an allocation by one of the family members.
Okay. Stand by. All right, the court will allow, which is provided under the law, for a relative or close associate to the victim to make a statement as to the effect that the crime had on the family and the victims in this case. And who are you, ma'am, please?
I'm Alicia McDaniel, the mother and grandmother of the two deceased.
Go ahead.
It's on my favorite chair. It's my babies. This is her 3 surviving boys. This is say the women's in the car. My name is Alicia McDaniel, the mother of Ambria McDaniel and grandmother of Ariana Washington. My daughter, Ambria, was a very loving woman, age 36 at the time of her death. She was loved by everyone. She was an office manager at Best Buy's import cars in Port Arthur. The top saleswoman for the last 2 years of her employment. She was very independent, outgoing, human being, and had the best attitude and smiled right up her room. She loved her children unconditionally. Amber always had her kids with her everywhere she went. You would see them together. They were a team. She took total responsibility of her kids. She was active in their schooling. The boys played t-ball, they played football. She was the mother of the year, received awards in several areas at Toccoa Academy. She was a force to be driven. Anything she put her mind to do, she would full speed ahead. If it came to her mind, she put it into action. As a matter of fact, 10 days before this incident, she had just purchased her first home. I was so proud of her, that young and ambitious with 4 kids. The relationship my daughter and I had was unbreakable until that dreadful day that you destroyed not only her dreams, but mine as well. it was so much more that she would have accomplished because this was the beginning of her future. I lived this every day with her 3 kids for the past 27 months. I had to go through this. It's torture. Today, I'm still nervous about it. I couldn't even drive, and I wasn't even in the car with them. It took me almost a year to actually get behind the wheel and drive myself, and I wasn't even in the car. Ariana Washington, my granddaughter, she was a student at Takor. She was very active in robotic program for stem cells, NASA Center in Houston. She completed in several competitions and came back with several awards. She was very active, high achiever in her classes. She was involved in dancing, volleyball, and drill team. She played t-ball, loved dancing and swimming. She was into fashion, had a big open heart, always was smiling. Really, as we would call it, the family, and her mother were inseparable. God gave 2 of the most deserving people to place into heaven. Our Riri, Ariana Washington, and my daughter, the Ambria McDavid. The things what I feel and what I know I miss the most are will. It's a lot of first things that my granddaughter won't get to do. Prom, graduation, college grads, being a bride, being a mom. I love being a grandmother. You know, I'm gonna miss those things with her. I can only imagine how they felt when they see you, Mr. Credit, coming head on into the lane, going 100 miles per hour. Let's not forget about the 4-year-old that was in a car, who also seen the accident. He tells me, he have told me bits and pieces of what he have seen, and he's 6 now, at 4. He tells me about the big truck. I live with it every day. I do, every day. He vocalized, seeing and hearing the big truck coming fast, and his mommy screaming. Then he said she went to sleep. Traumatizing him. He have dreams. I deal with this. He have dreams all the time. We all have went to therapy. This child is still in therapy. All 3 of our boys are still in therapy. Even when we think of the happy times, they bring some pain, because we will never be able to share those moments with my Amber, with this little Amber, and I call her Am, and my baby Riri. Again, the only thing that I, the mother and grandmother of the 2 deceased people, have this morning, I have faith in God. I'm broken. My heart is in a million pieces. So, Mr. Credit, they did not get another chance to fulfill their future. And I don't feel like you should walk away either. I forgive you, and I pray that God gives you life and strength to carry on like He have been doing me.
I'm Lionel McDaniel. I'm the older brother of Larry McDaniel, which who is my baby sister, and the eldest uncle of Ariana Washington, my niece, whom both I was close to, and they was very dear to me. I'd like to express to the court the devastating impact that has caused my family immeasurable heartbreak, hurt, and loss due to the fact of someone as irresponsible, reckless, and inconsiderable as the guy that stands here today in court. First, let me begin by saying that the reprehensible atrocity that this man has caused by even having the audacity to consider to exhaust the court and my family time by expanding his guilty plea thus far shows how much you are considerable as a human being. I, as well as many others, including you yourself, know you were guilty the day you decided to get behind the wheel of your vehicle intoxicated on May 20, 2021. My little sister was a very beautiful woman with many aspirations and goals. She was an unconditionally loving mother of 4 adorable kids. She didn't miss a beat. But what is missing are 2 of the most impeccable individuals that I truly miss every day of my existence due to the erratic conscious decisions you made has caused a cataclysmic chain of events to unfold without any preparation. Didn't watch my mother afflictions of having to bury her daughter, my sister, and her granddaughter, my niece, which is not the universal order on how it was supposed to happen. In the natural order, parents perish before their offspring. But in this tragedy, Chance, you have reconstructed that very fabric of the defining meaning monstrously. I have deliberated on what to say at this very opportune time to convey absolutely what needs to be professed. Words cannot express the turmoil you have created. Only by strength and God may we stand here steadfast, prolific, profound, and proactive into justice and justified. We didn't ask for this. You did. As your days transpire, may you deemly realize what your actions have caused. And so ironically, with a name like Chance, you didn't give my niece, my baby sister, or her best friend one. So now their retribution is now in God's hands. And in acknowledgement, may you remember their names, Amber McDaniel, Ariana Washington, and Daniel Nichols. That's all I have.
Anything else?
Judge, I did want to ask the court, I did not ask the court about whether or not you did not address the affirmative finding of a deadly weapon, whether you were making that finding.
Well, the indictments, the judgment will reflect what is in each of these indictments, and that the motor vehicle in the manner of its use and intended use was capable of causing serious bodily injury and death. Thus, that's what the defendant pleaded to, and thus the judgment shall reflect an affirmative finding that a deadly weapon, namely a motor vehicle, was used in the commission of each of these 3 offenses.
Thank you, Judge.
Anything else from the defense?
No, Your Honor.
We're in recess on this case. Ryan?
Yesterday's video was a bit of a downer, so let's do something uplifting today, something positive. Generally, Judge Goggins' courtroom looks like a chaotic mess like you're seeing on your screen right now. But yesterday, he actually had a very positive, uplifting story, which we're going to look at in a second. But before we do, let's look at the chaotic mess that he has to deal with on a daily basis. I mean, go through and look at how many people are laying in bed, driving, walking around, not showing their face. And dude needs to clean his room. I mean, what on earth? Show some respect. Driving and showing your beer belly? Like, really? All right. Watch this one.
Giroux.
Yes, Your Honor.
Hey, Mr. Childers?
She's going to plead the false ID, and the companion case of retail fraud would be dismissed. She did 3 days in jail.
Okay. Ma'am, you are being charged with giving false information to a police officer. It does carry a penalty of up to days, 93 days in jail, and a fine of up to $500. It's alleged occurred in Flint Township on June, looks like June 28th. It's kind of smeared here. Oh, I'm sorry, June 25th, 2017 in Flint Township. Do you understand that charge?
Yes, Your Honor.
Okay, and you signed an advice of rights for me as well. Did you read and understand those rights?
Yes, Your Honor.
How do you wish to plead?
I'm pleading guilty on that.
Okay. Is it true that on the said date, time, and location, you're guilty of giving false information to a police officer? Is that
Yes,
true?
Your Honor.
Was it, you knew it was a police officer? Was it he or she in uniform?
So yes, I was in active addiction at that time, sir.
You were what?
I was in active addiction at that time.
Okay.
She said she was using
That's
drugs.
not gonna help me.
She remembers it, but she's clean now, so she.
I'm sorry. Yes, I was a really bad drug addict with a lot of mental issues. And I've completely changed my life.
Okay, no, and I can understand that, but I guess for my sake, for the plea, at some point, you gave some kind of false information to him intentionally. Is that true?
Your Honor, I don't remember this incident. I was using drugs. So yes, I gave.
Let's just do, Mr. Challies, if I could do a no contest, let's just do a no contest.
Yeah, no problem.
My apologies.
All right. That's all right. It's all right. After reviewing the police incident report, do you find there's factual basis to accept a no contest plea to the charge? Do you understand if I accept your no contest plea, you won't have a trial of any kind, give up all the rights that you would have a trial, and you may be faced with those penalties?
Yes, Your Honor.
If I accept a no contest plea, I'll consider a guilty plea for sentencing. Do you understand that?
Yes, Your Honor.
Okay. Has anybody made any threats or promises to cause you to plead no contest other than what we've discussed?
No, Your Honor.
Okay, I'll dismiss the retail fraud matter. Accept no contest plea to giving false information. I'm sorry, Mr. Chalmers, I'm kind of bouncing around. How did she have jail time?
She did 3 days, Your Honor, and again, she says she's totally changed her life. She's not using it anymore, so she did 3 days.
Okay, ma'am, we'll order 3 days jail credit for 3 days and close this file for you, okay?
Can I tell you all of the work that I've done?
Sure. What have you done?
Okay, so I completed inpatient and outpatient therapy.
Okay.
I'm attending counseling for my PTSD. I'm attending a recovery group called RU. I'm going back to school to get my GED. I'm interning at Merle Norman, and I just opened up my own business.
Wow, you're doing quite a bit. When you say your own business, what are you doing?
I do macrame and plants. I sell indoor plants.
Oh, good. Gosh,
Yes,
it sounds
and
like
I'm
you
a
got a pretty good
full-time
handle on
mom.
everything. Okay,
Yes.
that's perfect. That makes me feel better too. I'd rather stay out of trouble, and I'm sure that having that business keeps you out of trouble too.
And having my child, yes.
Yeah, well, yeah, that's probably more than anything else. That's probably true. So,
Yes, sir.
How old's your child?
He's 12.
Oh, 12. Okay. Okay. Well,
Yeah.
And I'm sure he's in school and doing well in school now.
Yes, sir.
Good. Good. Well, you can be a great example for him. Okay. Do that for me, and you'll make me feel better.
No, God bless you.
All right. All right. You can always check in. I mean, let me know how you're doing in another year or so. Okay. I'd love to hear it.
Thank you.
Okay. All right. I'm sure Mr. Childers told you the same thing. If there gets to be an itch for something, boy, just talk to your counselor if you got a counselor still, Okay.
Yes, I plan on after taking care of this, I'm gonna go work with UCAN and help people that struggle through addiction.
Boy, I'm telling you, that's worth everything there too. Really is.
You know, yeah, you got to go back in the fire and help.
I know it. I know a couple people that are doing like online, not like a call service, you know?
Yes, yes.
You call for
Yep.
addiction, you talk. I'm telling you, those are worth everything because I can't do it. I don't have that, I don't have any past history on there, you know?
I
You
was
could sure
on
connect with
life
people on one.
support. I was on life support for 7 days.
Okay.
So I completely, recreated myself.
Yeah, boy, sounds like it. Boy, well, I've closed both these files. Please, check in with me next year. I'd love to hear how you're doing, okay?
Yes, sir.
Okay.
Thank you, Honor.
All right.
Good luck, Mr. Earl.
Thank you. Good luck to you,
Thank
Mr. Earl.
you.
Bye.
Thank you.
Bye now.
Bye.
You're welcome. You're welcome. You made my day.
Thank you. God bless you.
You too. You too. Bye now.
Bye.
You're gonna make me cry. I'm gonna turn you off before I start crying, okay?
I'm sorry.
Okay, bye.
I can't hear now.
Okay, bye. Mr. Childers.
And first thing my understanding is that German Shepherd named Tango is not correct, and we need to correct that. Is that right?
That's correct.
Is it breed or name that's we're corrected?
The name, was Roscoe? Roscoe.
And was that just a mistake, or is there a different dog named Tango?
That I do not know. There's half a dozen German Shepherds in our neighborhood.
Okay.
So
I'm more concerned about, do you own a different German
Nope.
Shepherd? Okay.
Nope.
And how do you choose to spell Roscoe?
Roscoe.
C-O-E. I didn't know I put an E at the end. All right, so that's first thing, is we're now talking about Roscoe's German Shepherd. And then for the plaintiff here, for the people of the state of Michigan, we have
Devontae McCall.
Okay. And it's my understanding that we may be proceeding on this with some sort of understanding. You want to place your understanding on the record, and then we'll sort of formalize it.
Thank you. There's been an agreement between ourselves and the respondent, Mr. Matthews, that he's agreeing to pay $500 in restitution to Matthew Gentry, the owner of the livestock that was killed by this German Shepherd. In exchange for that, we will not be asking the court to declare this dog dangerous at this time.
All right. So it almost makes more sense that essentially that's the agreement, but then we're not proceeding as a show cause, because first part of a show cause is declaring that the animal dangerous. So here is the good news, Mr. Matthews. You got to listen to me talk for a little bit, because I want you to sort of really understand, what we're doing here and how close this came. So the ending is good here. So in other words, when we're done here today, you're going to be able to go over to the shelter and pick Roscoe up, okay? So show cause hearing usually proceeds in one of two ways. One is I hear evidence and I order that Roscoe's no longer your dog and belongs now to the Allegan County Sheriff's Department, which usually, ends poorly for the animal. Or two, that the dog is declared dangerous, and then we still work out some sort of compromise where the dog goes home with you, but then essentially that dog is on dog probation for the rest of its life, all right? We came up short of that, right? That's good news for Roscoe, good news for you, and it seems like as best as we can do, good news for your neighbor, because your neighbor is going to get compensated for their property loss. And then the thing I just want to tell you is, it's never good when I know a dog, right? So we don't want Roscoe coming up in front of here, because it kind of won't be Roscoe's, first strike. It'd be more like Roscoe's second strike, and it'll be all the more easier for me to make some sort of ruling that, is not good for Roscoe. So I want to be sort of clear about that, because really, they call it destroying property. But it sounds to me, from what I can figure out, by property, we mean live animals, probably chickens.
And I'll tell you right now, if when people are being cynical, what they say is, once that dog gets that taste for that fresh blood, they're probably going to keep doing things like that. So now it's kind of on you to make sure that, you know, he doesn't have those opportunities, because if he does it again, then he comes real close to being like what we would call a menace to the neighborhood. And when the dog is a menace, that's where the courts have to step in and do something about the dog, and that, you know, it's not what we want here. So you're sort of good with sort of how close we came here to the danger zone with Roscoe and what's going to happen going forward. All right. I just wanted to get some, just because I'm writing this up, to get a name again. Going to pay $500 restitution. So you're going to actually pay that to the prosecutor's office, who will then so in exchange for those considerations, we're not proceeding on the show cause at this time. All right. So this show cause is going to be dismissed because you're going to follow up on your end of things, which is paying that restitution. I didn't put a time on that because this is going to be in a reasonable time frame. You have that ability.
Yes, sir.
Because the other thing is, we don't really want to drag this out. We're going to stop the show cause. We want to, you know, close it out on your end too. And then the Sheriff's Department will explain it to you, but shortly after this, they're going to make a phone call over to the shelter to explain that Roscoe can be released to you when you show up there. Right? That's the plan. All right. Anything further? Anybody else wants to put on record?
No, sir.
All right.
This one's a little different. The plaintiff bought a decently expensive used truck from Midway Chevy, who makes it worth your drive. However, right after purchasing it, he found out there was quite a few things wrong with it, but he did his due diligence and purchased that extended warranty, you know, that really expensive one. However, it doesn't cover the things that were wrong with it, and it was going to cost him an extra couple $1,000s. So he is actually suing the dealership for not covering these things under his warranty. But is it the dealership's fault or the manufacturer's fault? It's quite a conundrum.
All right, so from what I can tell is going on here is that plaintiff bought an automobile from defendant, and this was back when? What's the date of sale? Or how long ago, I guess is what.
It was probably, what, 8 months, maybe? 6 months? I'm trying to find it here.
So sometime this year?
No, it was last year. Was it last year?
I am looking it up. It was last year.
It was last year because I didn't want to drive it in the winter because I wasn't used to it.
Okay.
Like something signed here December 24th. So,
Yeah, that's the.
oh, delivery date July 12, 2022.
Okay.
All right, for right around 40, we're just shy of 40,000. All right. All right, and then so as part of that, there is some warranty offered up by Midway Chevrolet. It's at least for whatever was left on the original warranty, and then some sort of certified pre-owned. And then we would, so right now, both parties are at least in agreement. We'd still be inside the certified pre-owned at the time the suit was filed. So that's 12 months or 12,000 miles.
That's correct.
Yes, sir.
All right. And then it's my understanding, although I'll let you get more specific here, sir, that your contention is that there was some sort of defective thing going on with the brake lights. You brought it in, you said you expected that that would be covered and that should be replaced, and essentially they were not going to cover that. And so when you say $1,276, that is the amount you were quoted to replace the taillights at a different business.
That is correct. That's correct.
All right, well, that's almost all of it. So that was $1,126.35. I will say this just because I saw it somewhere in there, sort of like, oh, the gas to drive back and forth or time off work. You can't get those in small claims. It's literally out of pocket. So I just want to nail down the amount first. $1,126.35 is what a third party would charge you to rectify this the way that you wish it would be rectified, correct?
That's correct. But it also states, when I brought it in, it even says needs lamps replaced. So, but they didn't cover other things as well that were supposed to be covered.
And it is a contention of Midway Chevrolet that this particular issue would not have been covered by the warranty.
Correct. The warranty is through General Motors. And there's a list of exclusions when he buys it.
So essentially, gentlemen, this is just up to either plaintiff explaining to me why this should be covered, or I guess I'll start with defendant. They probably do this a lot more often than plaintiff does, of explaining to me why this is not covered by the warranty.
The certified pre-owned goes through a 178-point inspection. When they buy it, you get 2 maintenance visits, 12/12 warranty, which covers most everything, but not all the trim. Unfortunately, taillights aren't one of the covered items.
This information is brought to you by the hour of my life that I will never get back. Now I know a lot about warranties. So I need to see some paperwork on this one because what I'm finding online is not really adding up. So this is what's on their website. It basically says, here's the warranty, here's what's covered, here's what's not covered. It's all the basic stuff, fire, misuse, don't drive over curbs, oops, I'd be in trouble, tire damage from wear, bed liners, contamination of fuel, insufficient or improper maintenance, environmental stuff, tampering with the odometer. I mean, that's all the basic stuff. There is nothing here that links it down. And it says download a copy of the warranty guide, which takes you over to this. And this is what he signed. And this is the bumper to bumper warranty. And this is basically, this is your warranty. And it says maintenance, wear and tear, batteries, brake pads, lining shoes, rotors, tires, and any other service part required to be performed or replaced as recommended by GM maintenance schedule. That's it. Nothing. I don't think taillights are on the maintenance schedule. It says see CPO owner's guide for details. I can't find where that exists. But I did find the owner's guide for the new vehicles by going through this link where it says a full list of what's not covered. And I did find this little thing where it says lights and trim are not covered, but that's when they're due to impacts from driving from foreign objects on the road. I also found this, which is the GM protection plan, which actually applies to new vehicles and the full warranty. And what that says is it does say parts of trim aren't covered, but in nowhere does it define what trim is. So I'm a little irritated with GM. It's like, how are you supposed to know if they don't tell you?
And again, it is through General Motors, and they do sign a decree when they purchase the vehicle, understanding that it's not under bumper to bumper warranty.
All right. And I saw some of that in there. So essentially that 172 points, I mean, I get that. And I'm sure that Mr. Malin understands that. That's checking a lot of things, but that's certainly not checking everything. I'm sure there could be a 10,000 point inspection if you wanted it to. And then here's my question for you, Mr. Cottrill. So, I believe what you said is trim is not covered by the warranty, and that taillights being considered trim, that's not your opinion. That's literally
General
where taillights
Motors
fall.
Yep.
All right. And so essentially that's your argument for this what's going on here with the vehicle is actually outside of the warranty, and you would certainly be able to fix it, but it would be fix it and pay to fix it, not fix it and it would be free.
Unfortunately, yes.
All right, that's the long and short of it from defendant. And Mr. Malin, I just need you to explain to me why that's not the explanation that I'm supposed to stay with.
Okay, I did call Todd Wenzel and I was told that
Okay, I'm not sure what you mean by that.
Okay, I called another dealer. When I had called the other
You called
dealer,
a different dealer. Okay.
yes, and I was told the taillights are covered under bumper to bumper under the warranty as long as there isn't damage caused by me. They also said that the update for the check engine light that was on was also covered under warranty. And I gotta believe that a taillight is pretty.
Hold on one second. The problem though, essentially what you're telling me is that one dealership, the one that you bought it from, says it's not covered. You call a different dealership that says they think it is covered.
Yes, but I have something else to add to that. I don't remember who it was, but someone from Midway called me on the phone after this, they got the subpoena, and he said he doesn't understand why the gas door wasn't covered. That should be covered under warranty. So it kind of goes back to how would a gas door be covered under warranty, but not brake lights? It just doesn't add up. I mean, it's.
Okay. Well, we're certainly not asking me that. So you're asking a Chevy dealership to explain to you why one of those would be covered and one of them isn't.
Well, no, this was from Midway. This was a gentleman from Midway who called me and said he would like to rectify this situation. And he said that I have the email. He said that the fuel door should be covered under warranty. So I guess I'm confused why a fuel door would be covered, but not taillights. And this is coming from Midway. So he's admitting that a fuel door would be covered, but not taillights, which doesn't add up very well.
Unless they're saying the fuel door is not considered trim by GM.
Well, that's what I mean. And it doesn't make a lot of sense because you got taillights.
But what I mean is it's not the dealer, and that's why I want to be very clear with Mr. Cottrill. Mr. Cottrill, it is not in your discretion to decide what is considered trim and what is not considered trim. That has been spelled out to you by GM, correct?
That is correct.
And what you're telling me now under oath is taillights are considered trim by GM. Do you happen to know whether the gas tank door is considered trim or not?
The cover over the door would be considered trim, but the hinge is not. And the hinge is what broke. He never brought that to our attention, so we could take care of that for him.
Well, I think he's just saying they seem to be, let's call them, kissing cousins. Why are you saying one would be covered and not the other?
Yep.
But essentially, here's the problem that I have, Mr. Malin. You're asking me to say, hey, the taillight shouldn't be trim, and so it should be covered. But I have the person here from the dealership who's saying, no, that's what the GM, the policy is of the maker of this vehicle, as far as that warranty is concerned, is that taillight is trim. I need, in other words, his experience or his expertise in this would certainly trump yours, and even both of you might trump me. So who is it that's here explaining to me that taillights should be not considered trim and be covered under warranty?
Technically, it wouldn't even be covered under warranty because this was damage caused by someone else. This is not a warranty issue. This was a vehicle sold to me in good faith that it met this inspection. And if the inspection, I tried to look it up on the web and it.
Here's what I could tell you, what I am willing to say. I guarantee you part of the 172-point inspection is them stepping on the brakes and making sure the brake lights come on. But I'm sure the brake lights did come on. Therefore, it passed the inspection.
Well, one of them was cracked and full of water. I poured a cup of water out after their supposed glue repair. So I don't understand. I guess it's difficult for me to accept. I paid this much money for a vehicle and I expected it to be correct. And even per their their paperwork says it needs to be replaced. So I guess, and I consider a tail light to be a safety issue. If the bulb burns out, which it did, it gets full of water. Now the socket's got green corrosion in it. So.
Okay, but I get what you're saying, that this is wrong and it needs to be corrected. But what the dealership is saying is, we agree with you, and if you pay us money, we can fix it. Or you can take it somewhere else and pay money to get it fixed. But it's not covered under your warranty, which is when you get to say, hey, I don't have to pay for these problems because they're covered. So
that's correct. It technically isn't a warranty issue. This is a damage issue that was caused by someone else. When they had the vehicle, they did not look at that. I get it. I mean, I don't know how far they look at, but I just, it's tough for me to swallow a $40,000 vehicle with defective taillights that are going to cost me $1,000 to get them repaired.
all right. So, and now sort of we're moving to something different. Are you, and here's where you would come into small claims. That something the dealership did would be considered negligent that led to now your problem with taillights.
That's correct.
But I tell you right now, you wouldn't come in here as a layperson and tell me that. Essentially what you'd have is your mechanic or your person who is a level of expertise is beyond you and me, who says, oh, okay, what you're currently experiencing now is caused by this action, XYZ, and that XYZ is something the dealership did. Then you'd be where small claims would say, but for something that they did that they shouldn't have done, you wouldn't have this issue, therefore they need to pay for the issue. But essentially what you're telling me, what I'm hearing is, I paid so much money, it's just not fair that this isn't something they take care of. They should just take care of it. And they're telling you no, and you want the court to somehow address that as a legal issue.
Yes, that's correct.
But one more thing that you did say that I don't want to leave it as a loose end. Where is it that you're referring to that it said somewhere that this taillight would need to, I don't know whether you said the taillight needs to be replaced or something. Let's hear.
You should have it. It's a copy.
I think I do.
A quote. Yeah.
Repair taillight, cement, extra bulbs drilled into taillight housing, remove extra bulbs, and seal holes in taillight housing.
So that's the second one. The first one is the one that says diagnose, which is 4/20/23. It says needs lamp replaced.
There it is. Well, okay, but the lamp.
Yeah, I don't know if that was just generalized from the person who was taking the vehicle in and looking at it or what have you. I'm not sure. Because there were several people I talked to. I had 3 different people come out and tell me different things. So the only time that
here's the problem is they're telling you, yeah, lamp needs to be replaced. So it's not covered in warranty. So essentially they're telling you it's like a maintenance or repair that needs to be done. But they didn't do you for you because it wasn't covered by warranty. So they're telling you something that needs to be done. The fact that that wasn't taken care of in April, I mean, that would actually be more on you, that now months later, the problem's exacerbated or gotten worse because this wasn't done, what they recommended you do.
I didn't know that was going to be an issue. I thought they would take care of it, but apparently they weren't going to. They wanted me to pay. And like I said, I had called another dealer and they said that it's not true. They're covered under warranty. However, we're at this impasse where it's really technically not a warranty issue.
Yeah. Well, the other thing I would tell you is this. Essentially, if you're getting information, okay, so the dealers are, let's call them equal, right? and GM is above them because they got to take, you know, the dictates from the mountain there. Well, if you have one dealer saying, hey, this isn't covered because taillights are trim, you have another dealer that tells you, no, taillights should be covered under warranty. But essentially what I would need is you having something from GM saying taillights should be covered and aren't trim. Then I would say, well, then the dealership is the wrong party here. The person that's wrong in this equation is Midway Chevy, because GM says it should be covered. So Midway doesn't get to tell you it's not covered when essentially the boss, the maker of the truck and the designer of the warranty is saying it is covered. But we don't have that here. You're saying that essentially a competitor, really, another dealer said, oh yeah, it should be covered.
Correct. But how would they benefit from, you know, I don't see why they would say something that wasn't true.
I'm not saying that they have necessarily a reason to say that. I'm just saying they're not the right go-to person to tell me that they said that, where I would then overrule what Mr. Cottrell is telling me right now under oath, that as what he knows is that GM has laid this out, that this would not be a warranty issue, and that if it's not a warranty issue, it's simply a repair issue that you chose to not repair now for a while. I'm not sure that's ever going to be on the dealership. That's going to be your choice to not have dealt with it.
I couldn't afford at the time to pay it. That's the $300. It was $550 they were charging me. I don't have that. I bought this truck and it's expensive. The payments are very expensive. I didn't have the money to repair it. What was I to do other than try to rectify it another way, which I didn't know there were holes drilled in it. And that's where it just kind of cascaded. When I had finally looked and saw there were holes in it, that's when I took it back to Midway. And I was told when I showed it to the service manager, he said, yeah, they do this a lot when they trailer these vehicles. So he said, I bet the other one's the same way. We pulled the other one out. The other one had a hole drilled in it too. But it was,
well, essentially, I'm assuming that this truck certainly passed the 172-point inspection, that this is something that is more detailed or farther down the line than something that would be part of that inspection. And therefore, I would not hold the dealership liable for it. So essentially what I'm saying here is my decision is I would find that there would be no cause of action for the defendant to pay you money. That is without prejudice, meaning you could continue to collect information and you might be able to refile this and come back. Essentially, like I said, something from GM would have gone a long way to change my mind that it should be covered by the dealership. But where we stand right now, I don't have enough evidence to rule that, so I would not. All right. Okay. So I will say this to both of you, although I'm not sure why the dealership would be interested in this, but either party has a right to say, I don't agree with what just happened there. I want to appeal this to the general civil in front of the district court judges. To do so, you must do that within 7 days of today's date, and you must come in to do that in writing. Otherwise, your window to appeal what I just decided closes. You understand your rights on appeal, Mr. Merlin?
Yes, I do.
All right. Then, gentlemen, I'm going to thank you and go ahead and dismiss you. We're done for what we needed to do here today.
Thank you, Your Honor.
Thank you.
Thank you.
This is a probable cause conference in Judge Simpson's courtroom. It's not overly interesting as far as the facts of the case. However, it's a good reminder that even though we could be a good person, we could follow the law, we could easily get sucked into something that we don't want to be a part of just because we see it. And the next thing we know, we're on the stand testifying about what we saw against someone who's pretty dangerous. Allegedly, of course. Everyone is innocent until proven guilty in the court of law and at Meg's Crime Watch.
Yes, court, let's call the case, the People State of Michigan versus Martette Robinson.
Jessica Lynch, trying to have people.
Good morning, Your Honor. Good morning to your staff. Honorable Court. My name is Todd Russell Perkins, P 55623, appearing on behalf of Mr. Robinson. Mr. Robinson. Your Honor, at this time, I'd make a mutual sequestration for any and all witnesses. I don't have any in the courtroom. If the prosecution is making a request for the officer in charge to remain, we have no objection.
All right,
Ask for the officer in charge to remain, but
all right. Officer in charge may remain in the courtroom. All the other witnesses are hereby ordered sequestered. All right. All right.
I make that provision to the extent that this is proliferated on YouTube, that any other witnesses out there, if you could say that to the extent that that matters, or that.
Well, my feeling on that is rather simple, and that is that if this were heard without YouTube, without any video whatsoever, and then it adjourned out, then clearly they could read a transcript. But as for today, I would indicate that any witnesses that are out there, I understand we're only having one witness.
correct.
So I'll say it, but I don't know that it really matters that witnesses should not be viewing the testimony.
Thank you.
All right. Any potential witnesses. All right. We're ready to proceed.
Be seated.
Yes, you may. You may.
Is it fair to say you don't want to be here today to testify? Okay, but you are under subpoena, so you are here today. Okay, I'm going to direct your attention to June 18th, 2023 at around 12:57 a.m. Were you living at 150 Stevens Drive on that date and time? Did you call the police that night?
I did.
Okay, and what alerted you to call the police?
I heard couple outside arguing, and it escalated. And I called in to see if they could send an officer to calm down the arguments. But it escalated a lot from there.
Okay, so you said you witnessed an argument. Was it between, you said, a male and a female, or an argument between two people, male and female? Okay, do you remember what the female was wearing that night or earlier morning?
Bright pink, like spandex.
Okay, and how about the male that was arguing with her?
A white or very light grayish colored sweatshirt. Hoodie.
Did it have any type of design on the sweatshirt?
There was a logo on it. Yeah.
Okay. Do you remember what they were arguing over?
Yeah.
Okay. What were they arguing over?
He wanted rings back, and he wanted the keys to her car.
Okay. And then what happened next?
Oh wow.
Did they leave at all?
The gentleman pulled off in the vehicle. I thought they both had pulled off at
Okay.
first.
Sorry, let me slow you down for a second. So the gentleman that was in the argument in the white hooded sweatshirt left. Do you remember what kind of car he was driving?
Like a Cadillac.
Okay, so he left and you thought they both left, and then what happened?
Then I heard her, the woman out there talking, so I seen that she hadn't, left away, that obviously this guy must have pulled off in the car with or without. I didn't know if there was anybody else in the car. And then some minutes later, he pulls back up and they argue a little more.
The woman, the pink spandex and the guy in the white hooded shirt. Okay.
Off in the Cadillac. And then they argued a little more, and I heard her say that she was gonna call the police. And he said, go ahead, I don't care if you call the police. I don't have anything on me or whatever. And they argued a little more again about her wanting keys to the vehicle and him wanting rings and he pulled off again. He was gone for a few minutes, and during that time, a black truck pulled up.
Okay, so you said a black truck pulled up? Okay, and what happened when the black truck pulled up?
The girl with the pink got in the passenger side of the truck.
Okay, did the Cadillac come back?
After she got in the passenger side of the truck a few minutes later, the black Cadillac came back and passed the black truck and parked in a parking spot closer
Closer to what? I'm sorry.
closer to the other end. You know, they were on the right hand side of my building door.
Okay.
And then this is the last time that he pulled in, he passed the black truck and then he was parked on the left hand side of my building door.
Was he by a dumpster? Okay. Did anybody get out of the black truck?
Not at first.
Okay, and who eventually got out of the black truck?
Okay, so first the girl with the pink got out of the passenger side and went over and was talking to the gentleman that had got out of the black Cadillac.
The guy with the white hooded sweatshirt?
Yeah,
okay.
And he again, they were going back and forth about keys and rings. And then the black truck pulled forward across from my building. And he got out and he exited the truck. And he walked towards my building.
How was he walking when he walked towards your building?
He was kind of crouched down, walking across the parking lot.
Do you remember what he was wearing?
I think it was like a light gray hoodie.
Okay, light gray.
And when he got to the rear end of the vehicles that were parked in front of my building, he crouched way down. And when he got to the front of the vehicles, he lifted a gun.
Okay, so you say he lifted a gun. Where did he lift the gun towards?
Where did he point it towards?
Yes.
Towards the gentleman that was by the dumpster that had got out of the
Cadillac.
Okay.
Do you remember what the gun kind of looked like?
It wasn't a pistol or a handgun or anything because he had when he stood up from by the side of the car and raised it, and it was like by his shoulder.
Like shouldering it?
Yeah.
Was he holding with both of his hands?
Yes.
Okay. What kind of gun did it look like to you?
Well, it looked to me like it would have been some type of like shotgun or you know what I mean to hold. It wasn't a handgun.
Was it as long as a shotgun?
I didn't see a barrel.
Okay. So you said he shoulders the gun. You said he's pointing at the guy who got the Cadillac. Did he say anything to the guy?
He said, "Give her those keys, bitch," or "Give her those fucking something like that." But as soon as I seen the gun, I ran to my bathroom.
Okay. At that moment, when you saw him, you said he was kind of crouching between the vehicles, and then he pointed the gun at the guy who got the Cadillac and said, "Give him her effing fucking keys or whatever." Bitch, did you see a gun on anybody else? The girl with the spandex or the guy that got the Cadillac?
No.
And then what happened?
I was on the phone with the police. I had my phone in my hand when I was running to the bathroom, sat on my tub and called 911. About 60 seconds later, there was a gunshot.
Okay, and did you only hear one gunshot that night? Have 1 second, Your Honor.
You may.
No more questions, Your Honor.
All right. Cross-examination.
I thought this might be a good time to stop and tell you about the victim. His name is Jermaine Deshawn McClendon Densmore. He was affectionately known as Maine. And he was born in 1983 in St. Louis, Missouri. And his life was characterized by his creativity, spirited nature, and passion for music. He attended Willow Run Community Schools and later pursued a degree in counseling at Wayne Community College. Through his studies, he developed a strong understanding of the importance of mental health and was committed to helping others overcome their challenges. His empathetic nature and genuine concern for others made him a natural counselor and a trusted friend to many. He was also a talented and passionate musician and spent much of his free time creating rap music and videos.
Yes, thank you. Good morning, Ms. Hendricks. I am going to ask you some questions. If you don't understand them or you can't hear me or anything, just let me know so I can offer you a question you understand. Is that a yes? You just have to say yes for the, okay, thank you. You had the, you were at home back on June 18th, in the early morning hours. Is that fair to say?
Yes.
In fact, prior to, I think the prosecution said approximately 12:57 a.m., you recall looking out your window. Is that correct?
Yes, I have woken up to go get something to drink, and on my way back, when I was on my way back to my bedroom, I heard, an argument, but not like a belligerent argument. They were just going back and forth. They weren't screaming or yelling or, not making a ruckus, really. Just, you know what I mean? Not nothing that was outrageously loud.
Okay. Now, but you could hear it from where you were in your apartment.
Yes.
All right. Or condo, apartment. Okay. And your apartment's on the second floor in this particular location?
Yes.
All right. And now, are your windows open or closed? All right. And at that point in time, your windows are open. Now, let's talk about the makeup of your apartment. You said you have windows in your apartment, and those windows that you're looking from, or that you described you're looking from, look onto the parking lot?
Yes.
All right. And now, if you're looking just flush with your window, you know what I mean by flush with your window, just how you're flush with that desk? Is it a yes?
Yes.
Okay.
Sorry,
Yeah.
sorry.
No, don't worry. As you're flush with your window, if you're looking straight out your window, what do you look at if you're looking straight out your window?
If I look straight ahead, I see woods, like forest, woods,
Okay.
trees.
All right.
I'm going to put these screenshots up during the course of this testimony because it's pretty in-depth and it helps to see. The apartment complex is kind of a figure 8, and the building she lives in is the one that's on the left side. The main road runs, as you can see, down the middle of both of the two sets of buildings. And so her building is the one that's kind of on the south of the U, or not, guys, the bottom over to the left, the bottom corner. So she said when she was looking out, she sees woods. So basically she's looking down, I believe. It's one of these two somewhere around this end of the building. I'm not sure which, but it's this building in this area. And this is the layout of her apartment. So she has these two windows. So she can see out. It may be flipped, reversed, but it's one of those two that she can see out.
You know what I mean? There's no other apartments across from me or nothing. It's
Okay.
woods.
Okay. But the woods are not just up against your window, it's across the parking lot.
Yes.
Okay. So you see the parking lot area, and then across that parking lot area is the woods. Now, let me ask you, in that particular ambit in your window area, are there parking spaces for cars to be parked? Okay. Are there cars parked at that particular time?
There are parked,
Okay.
sporadically parked, you know what I mean?
Okay.
Different spaces.
Okay. So they're not completely filled, but they're cars
Yeah.
sparsed around that parking lot. Okay. Now, you said that you got up. Let me ask you, what time did you go to sleep earlier that day or that night?
It was probably 8:30. I'm on a funny work schedule, so I go to bed rather early, so I try to maintain that even on weekends and, you know what I mean?
Okay.
All of that.
Well, do you recall what day this was, this, June 18th?
No.
Okay.
I'm going, I don't remember the day of the week, no.
The reality is you don't have any specific references to the date. It's just that we use that date and you've come to learn that this is the date that this happened. Is that fair?
Yes,
Okay.
I don't remember the day of the week, yes, I don't remember.
Now, when you go into this, you get up, you said you went to get something to drink. At this point in time, let me ask you, do you take any medication at that time before you go to sleep or?
No.
Okay.
Not
Okay.
that.
All right.
I take sleep medicine occasionally, but not that night, no.
Okay, you did not take, okay. Now, you said you got up to get something to drink. Did you actually get something to drink?
Yes, I went to my refrigerator to get a drink of my soda.
Okay. And at how long did you, so you got up, walked to your kitchen. How far is your bedroom from your kitchen?
My bedroom is all the way in the back of the apartment, so it's, I mean, there's 2 bedrooms and then the living room and then my kitchen, so I don't know how many feet
Okay.
it is, but it's at the opposite ends of the apartment.
Okay. So not to disclose your apartment necessarily, but it's the size of your apartment, whatever it is, it's
Yeah.
from that distance from your bedroom to the kitchen is a fairly decent amount of distance. Okay. So the window that you're looking out of, is that your living room window?
The first window I looked out of, yes, was my living room window.
Okay. Did you ever look out another window?
Yes, my bedroom window.
Okay. So your bedroom window, if you're looking out your living room window, is that the window that you looked out of first, or was it your bedroom window?
Yes, my living room window is the one I looked out first, and that gave me the view of the happenings on the right hand side of my building porch. So, you know what I mean? If I'm looking out my window to the right of my building,
Okay.
you know what I mean? That's how I was able to see what was going on there.
Okay.
But like I tried to explain, it wasn't a belligerent argument or nothing. I didn't think, hey, I should call the police about this or anything. You know what I mean? They were actually kind of maintaining, you know, themselves.
Now let me ask you
So
something.
I went back. I just headed back to my room after I seen, you know, what was going on or whatever. And I didn't I never seen him strike her or grab her or nothing. I figured everything was, you know, at least copacetic enough for me to go back to my room. I didn't need to involve any police.
Okay.
I'm very hesitant to call. I don't know if I should use it. Never mind.
No, no more. So now you said that at some point in time, and when the prosecution was asking you questions, you said this escalated. Is that correct?
I mean, yeah.
Okay, you used the word. I don't know if it was
It escalated, yes.
Yeah, I don't know if it was your word or the prosecution word, but you agreed that it escalated. And when we talk about escalating, you're talking about the aggravation of voices or the anger that you could perceive that you thought was in voices. Was that fair?
I'm talking about escalated as far as drama. Like it evolved very, you know what I mean? Like,
Understood.
Yeah, worse. Progressively worse.
And as it escalated in your mind, as you're seeing things are moving faster as it became more escalated. Is that fair?
Yeah. I mean, it carried on for a bit, but
okay.
The ending was very quick. Once the black Escalade, I mean the black Cadillac pulled up and passed the black truck.
Okay. Well, let me get to that portion because that's sometime later in this particular morning. Is that correct?
Yeah.
Okay. Now you got up. Why was it that 12:57, when the prosecution asked you 12:57, that you recall that particular time as being the time that you got up?
When I woke up, I always look at my phone to see how long I've slept, see if my, I guess, internal clock is like on, you know what I mean? Because I normally get up at 1:45.
Okay.
For work.
Okay.
So, you know what I mean? I knew it was going to be around that time somewhere in that time frame. You know what I mean? So I picked up my phone and looked, and for some reason, I thought it was 12:50, but it might have, 12:57 might have been when the police were, notified. I'm not, I
Okay,
think the clock said 12:50 for some reason.
okay. Now, when you got up, you got up, you looked at your clock, you went to the kitchen, you heard this talking or this conversation, nothing to be concerned with, and you went back to your bedroom. How much would you agree that might have taken approximately 3 to 4 minutes?
Yeah,
All right, less than 5 minutes.
yes, less than 5.
And that less than 5 minutes, you're then in your bedroom, and as you're in your bedroom, this is the point in time in which you hear this escalation as you describe it. Is that correct?
When I'm in my room, I hear it the first time that the black Cadillac pulled off, and I thought that they had both drove away together in the
Okay.
vehicle.
And when you say you thought they had driven away together, because you're not looking at those individuals. Okay. And it got quiet. Okay. And you don't know whether the young lady's out there. You don't know whether she drove the car away. You just know that you heard the car leave out.
Yes.
Okay. And you heard at one point in time, you heard that car leave 2 different occasions, did you not?
Yes, I actually seen the second time.
Okay.
I was looking from my bedroom window down that way.
Okay.
And I heard the argument start up again. That's when I went to the window and looked out, and that, the second time he came back.
Okay. Now, as you're making these observations, let's talk about the first window when you're in your living room. When you're looking out your window, you said you have to look to the right. Is that a yes?
Yes.
Okay. And as you look to the right, you look and you saw those individuals having a conversation at that point. Is that correct?
Yes.
And how far what space or where were they at affixed in that parking lot? If you could remember a point in that.
From my living room window where I was looking, it was probably seven parking spaces down, 6 or 7. It was, it was like in the middle of the 2 apartment building doors.
Okay.
So, it wasn't like directly in front of the building. It was off.
Okay. So from your
Maybe 5, 6, 7, something like that.
So from your window, that living room window, when you look to the right, you're talking about 5 or 6 parking spaces away from your window. Is that fair?
Yeah.
Or 5 to 7 spaces?
Yeah.
Okay. So now at some point in time, you then go to your bedroom. And you said that you looked out your bedroom window and you could make observations of the interior of that parking lot. Is that correct? And when you're from your bedroom window, where is it that do you look to the left or you continue looking to the right?
I'm still looking to the right at first.
Okay.
When the car pulled back up.
Okay.
And I heard them talking again. I looked over to the right again. It was a farther view, and there was a tree there that I couldn't see like the top of their heads and stuff like that. I could see their legs and what I mean from over there. It was a further view, but I still heard them talking about the keys and the ratings and things like that. And that then he pulled up again.
Okay.
I've seen him pull off the side. I've seen him get in the car and pull off the second.
Okay. And you agree that second time that you heard these voices, that's the point in time we would describe as at least the beginning of the escalation. Is that fair?
Yeah.
Okay. And is this the point in time in which when you describe escalation, when you're describing words, they're cussing at each other, are they not, when an escalation occurs?
They weren't actually like being belligerent. They were he was like, I'm gonna need them rings, and she's like, well, I'm gonna need them keys. You know what I mean? It was just back and forth like that. They weren't screaming or hollering or, it was just a back and forth. They weren't.
Okay.
When I say escalation, I'm just talking about the incident in a whole escalated at the end to so much unforeseen outcome.
Okay. Now,
where I initially thought it was just an argument.
Okay. And you said that as you're watching them from your bedroom window, which is the second time that car comes back, you don't see you recognize them by their lower extremities rather than their faces and everything like that. But the voices sound the same.
The voices are the same.
And how, as you saw the voices are the same and you see those bodies, how close are those bodies to each other from where you're watching?
5-7 feet. They're not really close to each other, but like she was standing on the sidewalk and he was more towards the car, like the door of the car.
All right.
They weren't really close to each other.
Now you described that second time, isn't that the time in which you heard the young lady say that I'm gonna call the police? Is that correct? Is that a yes?
Yes.
Okay. And you also heard at some point in time, stop putting your hands on me, did you not?
Yeah, and that was at that time when when she was like, stop putting your hands on me, and on, and then it was I'm gonna call the police, and that's when he said, go ahead.
Okay. And as she's saying, stop putting your hands on me, you're hearing that more so than seeing that, right?
I never seen any visible altercation between those two.
Right. But what I'm saying is when that voice says, stop putting your hands on me, you weren't looking at them at the time that was said. Is that fair? Okay. And so at some point in time, you then said you called the police. Is it fair to say that you called the police twice on that evening?
Yes.
I
called the first time just to try to see if they could come and maybe deter them from arguing and keep carrying on.
Okay.
I was going to say earlier, I am very hesitant to call the police on anybody. You know what I mean? I just don't want to be that person.
I got it.
So it took a lot.
Okay. But it was enough that was going on that you felt, even though you're that person, it was enough going on that you felt the need to call the police at that time, correct?
When the young man said that, go ahead, that he didn't have anything on him, I just figured that I would call, you know what I mean? Nobody was going to get any extra charges put on him or anything if he came up and that guy would have had something in his pocket that didn't belong there, or she had, you know what I mean? I figured that was the clear, for nothing other was going to stem from me calling the police to get them to disperse.
I detect you're the type of person that sees the forest rather than the tree. Is that fair? You know what I mean by that? Just you're looking at the global picture of what the ramifications of a call would be versus just randomly calling.
If I can be frank, I am very hesitant to call the police on any young African American.
Fair.
I don't want any.
I got it.
That's why I hesitated when the argument was just the fact, you know what I mean?
I understand. But again, my question is, understanding you're that individual, God bless you for that. But nonetheless, you saw the need or saw the potential need that you made the 911 call initially.
Yes.
Okay. You made that 911 call. When you made that 911 call, did you make it in your bathroom, you said?
No.
Okay.
The first one was in my room.
Okay.
I didn't go to my bathroom till.
Okay. All right. So then you then made the 911 call. Did you ever see the police come out shortly after that 911 call?
No, the first time I called, they didn't come right away.
Okay.
The lady on the phone, the man on the phone, I can't remember what it was, said that they would send an officer.
Okay.
Then when I had called back because I didn't see anybody coming, I said, did you guys send an officer? And they said, well, we sent somebody, but they didn't see what was going on.
Fair enough. And you didn't see that car. You weren't looking out your window all the time either and didn't see whether or not you couldn't verify that or not. Okay. And then, so would it be fair to say you called them that first time and then you called back to see if they had come out? You got some information from them. Is that a yes? Yes. Okay. And I'm just saying that because we're making a record. Okay. And then after you made that call, you said that the Cadillac comes back. Oh, I'm sorry. A black pickup truck comes into that parking lot. Is that fair?
After the second time the young man pulled up, yes.
Okay. And the black pickup truck, let me ask you about the first time. You're not aware of whether or not that young lady left in the Cadillac the first time either. Is that correct? Right. Okay. You just know the next time you saw them, they were out by that tree and you heard the same voice. So then this black pickup truck comes into this parking lot. you'd agree when you saw that black pickup truck, it wasn't parked, it was pulled into the middle of the parking lot. Is that correct?
Yes.
All right. Are you seeing this black pickup truck from your bedroom window or the living room window? Okay. And if from your bedroom window, let me ask you, and I'm saying because you're the type of person that seems like they don't want to really get involved, but don't want to see anyone get hurt. Are you looking flush out your window? Or are you looking peeking from the side?
No, I'm in my screen, I'm not like over to the side.
Okay. Okay.
I'm looking at what's going on.
Okay.
I'm not like peeking through blinds or.
Yeah, fair enough. So now you're looking into that parking lot area and you see that black pickup truck. Where that black pickup truck comes to rest in the middle of that parking lot. It did come to stop, did it not? Okay. Yes.
Yes.
All right. And it came to stop. How far away were you, or how far away was that black pickup truck from your window where you're making these observations? Approximately. Or if you can remember, here's a better question is, can you remember the spaces of the parking lot spaces where that truck you believe was?
Oh, well, I mean, it was about from my bedroom window, if the space right there, it was probably maybe, it was pulled up to where the nose of the truck would have been maybe like 2 spaces from the parking space directly in front of it. So the tail end of his truck was like at my side view, the tail end of the truck. So it wasn't too far up or whatever.
And you saw that truck sitting there. You didn't know anyone was in the truck until the young lady got out of the truck. Is that correct?
I seen her get into the truck.
Oh, you saw her get in. I'm sorry. Okay.
When the black truck pulled up, I seen her get into the passenger side of the.
Okay. What alerted you to you came back to your window when you heard the door of the truck open and to watch that young lady get in there?
No, I came back to the window when I heard the car pull off the second time.
Oh, the car pulled off the second time? You're talking about the black Cadillac?
The black Cadillac.
Okay. And when that black Cadillac pulled off, did you leave your window anytime from that?
No, I seen her get into the.
Black pickup.
I seen that she obviously hadn't got into the Cadillac that time, but she walked and got into the black truck. I'm watching this from my window, and then I hear another car. I hear a car approaching, and I look, and here comes the black Cadillac back.
Okay. And you'd agree that there's a period of time when that black Cadillac pulls off the second time, it pulls off and it's out of your vision and out of your visual. And then some minutes later, the black pickup truck pulls up.
It was a few minutes. I don't even know if it was minutes. It might have been a couple minutes, maybe.
Okay. But it was enough. I'm sorry, I didn't mean to cut you off.
It wasn't a long period of time, but it was, yeah.
But it was enough time that those two cars, you never saw those two cars interact or cross-section each other. Is that fair?
Not before.
Okay.
He returned.
Okay. And then that car, at one point in time, you heard that black Cadillac leaving that parking lot, and you described it as bottoming out. Is that correct?
Yeah, he pulled up very quickly. He went over we have speed bumps. He went over this speed bump quickly, and that, I heard like the back end of the car, like.
Okay. All right. And that was the first time or the second time?
That was the second time.
Okay. And then when the car comes back the third time, it comes back in a direction opposite that what it left. Is that correct?
Yes, he would have came in from, yeah.
Okay.
He would have been heading south in the parking lot.
So he left north, leaving the parking lot. Yes. Okay. Then he came in south the third time.
Yeah.
And when he came in south, that vehicle didn't stop at that truck. Is that fair?
Yes.
Okay. That truck is still stationary when that car comes in. Is that correct?
Yeah.
And then that black Cadillac then pulls in and goes beyond or south of that truck. Is that correct? And it pulls in south of that truck pulls into a parking space, as the prosecutor asked you, pulled next to a dumpster, did it not?
Yeah, I think there was one space between the car and the dumpster.
Okay. And where's that dumpster if you're looking out? You're still looking out your bedroom window?
If I'm looking at my bedroom window, it's to the left.
Okay. And can you see the dumpster from your bedroom window?
Very clearly.
Okay. And when you see there's no tree blocking that dumpster, is that correct? Okay. All right. And so when that car pulls in, it backs in that space?
Yes.
Okay, the Cadillac backs into that space. And when that car backs in that space, does that person get out of the car? You talk about the young black male, does he get out of that black Cadillac?
I think when the girl opened up, when the lady in the pink opened up the passenger door, I think they were getting out at like right around the same time.
Okay, all right.
They, like, she knew that they had something, because he knew they had something.
I was gonna ask you that. Okay, so approximately the same contemporaneous with her opening the passenger door on the truck, that black Cadillac seemed to open up his door and they both got out. Did the black male, or excuse me, did the young lady, did she walk towards the Cadillac?
Yes.
Did she get close to the Cadillac?
She was, towards the front end of the car.
Okay.
Maybe not right up close to the, like, yeah, close, I mean, close, yes.
Okay, now this black Cadillac that we're talking about, you've seen this before in your parking spots. Okay, and you know to whom that car belongs, is it?
I know that they resided in my building. I've lived in the building for some years, and I can tell you, I don't know any of my neighbors' names. I don't associate, I don't, I don't speak, I don't say hi, I don't, I just kind of go upstairs and go to work and come home and go back to work.
Okay, so at some point in time, but you've seen this young lady drive that car before, have you
I've
not?
seen the car.
Okay.
I actually had my granddaughter with me one day, and somebody that I knew got out of the back seat of the car. So yes, I've seen that car.
Okay, so now when that young lady walks to that car, the continued escalation, or the escalation continues between that young black male and that young lady. The young lady is a black lady too, is that correct?
Yes.
All right, and between that couple, the escalation continues, does it not?
Yes.
Not to the point of what you describe and brings you here today, fair enough? All right.
Yes, no, that's not, okay. They were just still going, her stating that she wants the keys and him stating to give him his rings. That's all I ever heard them argue about.
Keys and rings.
Keys and rings, that's
Okay,
all.
now, you at some point in time, you saw that truck move from its space and it moved from the center of that parking lot a little bit, is that fair?
Yes.
Okay, and now, and you would agree that that truck then moved over and veered to the left a little bit, but not into a parking space, is that fair?
The truck pulled in diagonally facing the woods that are across from me. So it did pull up in like, case corner, diagonal, whatever you want to say, into like 2 spaces, 3 spaces that were open over there.
Okay.
So it didn't like park,
Right, exactly.
Pulled forward and stopped the car out of the middle of the street.
And you would agree that as that car pulled forward, it pulled forward pretty quickly, did it not?
Yeah.
Okay, and when it moved forward pretty quickly, that individual who was in that car jumped out of that car and ran across the parking lot, did they not?
No, they did not run across the parking lot.
Okay, they did not run?
It wasn't running, no.
Okay.
It was a walk, and they were in the process of walking across the park, you reduce the cars in the process of kind of like ducking down.
Okay, but they were doing more than just walking. It was a speedy walk. Was that fair?
I mean, it was faster, but it wasn't a run. It was,
Okay, fair enough.
Yeah, so it was, yeah.
Okay, and so then at that point in time, it was only when you saw a firearm pulled that you then left your window and went into your bathroom and called 911. Is that the 3rd time?
Yes.
Okay, so
I think I probably ended up calling about 3 or 4 times that night total, yeah.
I'm sure, yes. But at least at this point in time, it's the 3rd time. Is that correct? Is that yes?
Yes,
Okay.
sorry, yes.
Don't worry about it. We're good. You're doing fine. And so when you saw that gun being pulled, you left immediately, did you not?
Immediately.
Okay. And when you saw that gun being pulled, you left immediately and you didn't go back to that window until after some point in time afterwards. Is that correct?
Yes.
After you heard this gunshot?
Yes.
After you heard vehicles leaving or vehicle leaving?
Yes.
Okay. So you never saw a vehicle actually leave, that truck, you never saw it leave?
Witnessed it pull out. No.
Okay. And you never saw who got into that truck, is that correct?
Correct.
All right. When you came back to the window, you saw this young lady over that person laying on the ground, is that correct?
Yes.
Okay. All right. I know it's tough. You need a minute? Take a minute.
You all right? You want to take a break, man?
No, I'm okay.
You sure?
I'm good.
All right.
It's just
If you need a break,
I mean, it's bound to spark emotions. you know, I'm okay.
Okay, but if you need a break, you just let me know. Okay, all right, go ahead, Captain.
Now, you said that after you saw the weapon pulled, it was about a minute later or sometime a minute later or more that you heard a gunshot. Is that correct?
Yeah, I would say it was 30 seconds, just 30 to 60 seconds. I was on the phone. I was physically sitting on the edge of my tub in my bathroom, which is directly next to my bedroom, you know, like you know, the doors are almost adjacent.
Mhm.
So I just crossed my bedroom into the bathroom to the tub and sat down, and I'm on the phone, you know, telling them like, please hurry and get somebody here. I just seen a gun.
Okay.
And
Okay.
I'm sitting on the tub, and the person is telling me they're gonna be there in just a second. They're about 30 seconds out. They're about 60, I think 60 seconds out or something like that. I remember them saying, and that's when I heard the person on the phone and myself heard the gunshot.
Okay. So while you're on the 911 call, you heard the shot. Yes. Okay. And so you'd agree it was like you described, it was immediate. Once you saw that gun, you turn and you run to the bathroom.
Absolutely.
Okay. And you would agree that your focus was on your attention was on the individual who got out of that truck because they're moving. Is that fair?
Yeah.
And that's got your focus and your attention as you see that individual, and you described him as crouched down on the rear of that vehicle, right?
Yes.
Okay.
It was like something out of almost out of a video game or something.
You called it Call of Duty, right?
They call it like GTA, Call of Duty, like people cross down, you know what I mean, trying to sneak up on somebody.
But your focus is on that individual. You see the gun, you turn and go make that call. All right. And you'd agree that you moved so quickly that you didn't even pay attention to those other individuals who were arguing, correct? All right. You hadn't paid attention to those individuals who were arguing because your attention was so focused on that individual getting out of the car, the way they got out of the car, how they were moving, and then ultimately them pulling that weapon, which caused you to turn and bolt to your bathroom. All right.
I was not paying any attention to the other two.
Okay. Just one moment. Thank you, Ms. Hendricks. It's been wonderful.
Yeah. Any redirect?
No, Your Honor.
All right, ma'am, you may step down. Thank you.
And Judge, we do have probably 2 or 3 more witnesses we've called, but we're asking you to adjourn the exam for those witnesses, and I believe Mr. Perkins is okay with that as well.
All right. And I think during our bench conference, I had given
2 days.
2 dates. And
The 17th, Your Honor, please.
17th, all right. Preliminary examination will be continued to October 17th, 2023, 9 a.m. That'll be in person.
Thank you so much.
Thank you. Bond will continue. All right. Thank you.
In person. I'm always welcome.
On Zoom, yeah, I'm better on Zoom. Less people in my way. And can Mr. Burke continue to report on something?
Absolutely.
Can I go out?
This is 35-year-old Martez DeAndre Robinson. He is charged with homicide, open murder, and fleeing a police officer 3rd degree, as well as carrying a concealed weapon. As far as I can tell, he doesn't have a criminal history outside of some traffic violations, none of which were severe or criminal in nature. Police responded to the call from the witness as she described, and as they were responding, they thought it was to a disturbance, an argument between a couple. When they arrived, they found 39-year-old Jermaine McClendon Densmore had been shot. So they took him to the nearby hospital where he was ultimately pronounced dead. We know all this. So they obtained a description of Mr. Robinson's vehicle and were able to locate him a short time later, right up the street, ironically, near the Washtenaw County Jail. He was taken into custody without incident and taken to the Washtenaw County Jail. Several days later, he appeared in front of Magistrate Fink, who denied his bond. His attorney, Mr. Perkins, filed a motion for an emergency bond hearing, and the family of the victim posted a petition on change.org seeking to keep Mr. Martez in custody. You can read the full petition with a link in the description. That bond motion was denied, and Mr. Robinson has remained in custody since that time, which was the end of June of 2023. The next hearing in this case, as you just heard, is in a couple weeks. If you'd like me to cover it, it'll be a continuation of this hearing with several other witnesses. Please let me know. Take care. This is a continuation of the prior hearing, the preliminary exam, that took place on August 15th, where we heard about the woman who got up in the middle of the night to get a drink of water, heard a couple arguing outside. That argument escalated to the point she called 911. Before police could arrive, a third party pulled up and fatally shot the man that was involved in the argument. The shooter was Martez DeAndre Robinson, allegedly. The woman who testified at the prior hearing was incredibly reluctant and very emotional throughout the course of the hearing. And if you haven't watched that, I highly suggest you go back and do so. I'll put a link in the description. So this is a continuation of the preliminary examination from August.
Thank you.
Yeah, and I would ask the court to continue the mutual sequestration order that the court entered into last time if the officer in charge of government is here. I don't have an objection to that end.
Yes, Your Honor, and then we'll seek what?
Witnesses are hereby ordered sequestered.
You're going to second call.
I do.
Judge, there's a stipulation to the autopsy protocol. We do not have the ME here today that stipulates the report. People's proposed exhibit 1, we'd like to enter as stating that the death of the gunshot wound to the abdomen and manner of death is homicide.
All right.
May I publish to the court?
Yes.
Want to look at
Is
it?
that a?
I have a copy. You think, Your Honor, for the purposes only of the preliminary examination, we do not have we do stipulate for it, allow the court to move for attention.
Oh, very good. Exhibit 1, based upon that stipulation, is admitted.
And how long have you been employed there?
4.5 years.
I'm going to direct your attention to June 18th, 2023. Were you working that day?
I was.
What shift were you working?
Minutes.
And were you in a marked patrol car in a uniform? Were you dispatched? Actually, who were you working with that night?
Deputy Kelly.
Okay. And were you dispatched to 150 Stevens Drive in Ypsilanti Township?
I was.
Okay. And what was the nature of that dispatch?
It was for some type of disorderly between a male and a female.
Okay. And that location, 150 Stevens Drive, is that an apartment complex?
Yes.
And what time were you dispatched?
1:40 in the morning.
And what time did you arrive there?
Around 1:48.
Okay. And when you're walking through the complex, did you see any vehicles exiting or entering the complex?
Yes, it is.
And what type of vehicle was it?
It was a black pickup truck.
Okay. And what did you do when you saw that black pickup truck?
I radioed that information to other responding units to have them stop the pickup truck because it was leaving the area.
Okay. And when you got closer, or when you started walking towards the apartment buildings, what did you observe besides the black pickup truck?
So the pickup truck was driving away as I continued walking towards the address there. I observed a male laying on the ground, surrounded by blood, and a female kneeling next to him.
Okay. And were you able to get identification of the female?
Yes.
And who was it? Okay. And what was she wearing that night? She was in pink, you said? Okay. And then the injured male's name, you said he had blood surrounding him. Did you see an injury or observe an injury that night?
I did.
Okay. Sorry. Go ahead.
There was a hole on his
right side, and then there's another hole kind of near his back on the left side as well.
Was that consistent with a bullet hole? Okay. And were you able to get an identification of the male, injured male? And who was that?
Jermaine McClendon.
Okay, Densmore? Okay. And then after you're done, you obviously rendered aid to the victim, is that correct?
Correct.
Okay. And then after you guys secured the scene, where did you end up going after that?
I transported Alicia back to our main station to the detective bureau.
Okay. And did you eventually have contact with the Martez Robinson?
Yes.
Is he in court? Can you point to him, identify an article of clothing he's wearing?
He's saying that they were there in green shirt.
Your Honor, please let the record reflect the witness has minute in court identification of the defendant.
Without objection, record shall so reflect.
And how did you have contact with him?
After he was at the detective bureau, interviewed by the detectives, I transported him down to the jail.
Okay. And did you go down and look at the truck or did you go down and look at, did you go look at the truck that was involved in this case?
Yes, I did.
Was when it was in your custody, Washington County's custody?
Yes.
Was it the same truck that you saw leaving the apartment complex that night? Was a gun found in that vehicle that night? May I approach the witness, Your Honor?
You may.
I'm handing you what's been marked as people's proposed exhibit to you. Do you recognize that?
I do.
Is that the same gun that was found located in the black pickup truck that night?
Yeah.
Is that a true and accurate copy of the pictures that were taken or the gun that was located?
Yeah.
Your Honor, people move to admit people's proposed exhibit 2 as exhibit 2.
Any objection or voir dire?
Yeah, I'll want your briefly.
Yes, go ahead.
Officer, was it Deputy Van Duzen? Good morning.
Morning. Yes.
That picture that you're looking at, did you take those photographs, or is that the photograph that's just being presented to you and you recognize where it's from?
I did not take the photograph. It's the one that's presented.
Okay. When you saw this firearm that you're testifying to that you saw, was it in that location where you're seeing it right now in that photograph?
No, it's not.
Okay. And where was it?
It was between the front passenger seat and the front passenger door of the black pickup truck.
So on the opposite side, opposite the driver's side.
Correct.
Okay. How is it? Well, I don't have any further questions, Your Honor.
All right. Any objection to the admission?
I don't have an objection.
All right. Exhibit 2 is admitted. Thank you.
Thank you. He asked my follow-up question, so I have no more questions. Thank you.
All
May I
right.
publish that to the court, Your Honor?
Yes. We can do it ourselves. Don't worry about it. All right. Cross-examination.
Again, good morning. Yep. May it please the court? So Deputy Van Duzen, would you describe yourself as well, first and foremost, I'm going to ask you some questions. If you don't understand them, let me know, and I'll try to rephrase or restate the question so you do understand. Is that fair? All right. Now, when you were involved in this investigation or approaching this scene back on June 18, 2023, that was the date, is it not?
Yeah.
All right. Let me ask you, if you looked at your report briefly, would that refresh your memory to that date? May I approach the witness, Your Honor?
You may.
I'm showing you a document that it appears to be your report. Okay. So as I asked you about June 18, 2023, does that refresh, having looked at that report, does that refresh your memory to that being the date and time that you approached a scene in the area of Ypsilanti Township? All right. I guess I was presumptuous about a scene. You didn't know what you were approaching. You had a dispatch call that took you to that location. Is that fair?
Yeah.
All right. You said that you were working with someone else by the name of Deputy Kelly. Okay. Is that an individual that's in your car or in another car that you're working in conjunction with? Okay. Now, when you come to this location, you said you came to this location as a result of a dispatch call out. Is that fair?
That's fair.
All right. When you received that dispatch call out, were you aware of anyone else who was approaching that scene or going to that scene, working in the similar function as you're working?
Yes,
Okay. Who else?
pretty much the entire shift.
Okay. The entire shift was coming as a result of, you described it as a disorderly with a male on female? Okay. And when you say disorderly with male on female, that represents to you, as you heard it or as you understood it, to be a male assaulting a female or being disorderly towards a female. Is that fair?
I would say no.
Okay. So what does it mean when you say male on female disorderly?
I believe I stated that it was a male and female.
Okay. Fair enough. And I may not have heard it. Okay. Now, you didn't have any information as to who was being disorderly. Is that fair? You had no information as to who or whether or not there was any particular allegations of an assault based upon the dispatch that you had. Is that fair? All right. And based upon that information of a disorderly involving a male and a female, you said the entire department was coming, or the entire shift that's on the road was coming?
So the original was for disorderly. As I was pulling into the complex. So, yes.
Let me ask you, something's changed along the way. All right. Okay, so my question is, initially, when you got the call about a disorderly male and female, is it your testimony that all of the shift was coming to that location?
Okay, not at the original.
Okay.
Once further information.
Okay. At some time you received some additional, at the time when you received the additional information, you were already on the property ultimately where this location became what I would say a scene. Is that fair? All right. You described, you saw a black truck leaving and exiting that location. Is that fair? When you saw that black truck, you had no information about what that black truck or to whom it belonged. Is that fair? Yeah. You had no information as to whether or not that black truck had anything to do with the scene that you were approaching. Is that fair?
In the disorderly, there was mention of a black truck somehow being involved.
Okay. Do you recall what it was that you recall? Do you recall that? Let me ask you. Now, when you come into that location, you're coming in, there's an entrance, there's an ingress and egress to this complex. Is that fair? Would it be fair to characterize the location of these residences as a complex?
Yes.
Okay. There's a point of ingress and egress in which you came in. Is that fair?
There is a singular entrance into the complex.
Okay. And that's the singular exit point too. Is that correct? So you understand when I say ingress, egress, right? Okay. There's an entry point and there's an exit point of a singular entry point and exit point to this location. Fair enough?
Yeah.
Okay. All right. And so when you're coming in that location, as you're coming in that location, you see this black truck leaving out. Do you not?
So I was further into the complex when I observed the black truck.
Okay.
It was not right at the entrance.
Okay.
Or where I would say I was pulling from the main road into the complex.
Okay. And you would agree, as you saw that black truck wasn't driving erratically. Is that fair? Okay. That black truck wasn't speeding. Is that fair? All right. And were you able to make a general description of whether or not that was a male, female, black, or white individual driving that vehicle? Okay. Let me ask you another question. Are you the person in your vehicle? Are you driving or are you passenger?
I was driving.
Okay. Now, after you saw this black truck, would it be fair to say when you saw this black truck and did you pass by each other? Like you're going one direction and the black truck's going the opposite direction in which you were traveling?
I was on foot at the time, and yes, I was headed towards the dispatch location on foot.
Okay.
And the truck was passing.
Okay. And you're at, by that time, when you're on foot, would it be fair to say that you had not received the second dispatch call yet? Let me ask you, I'll just get to the, you heard of disorderly conduct as the initial dispatch, is that fair?
Yeah.
And at some point in time, after you get out of your vehicle, you were alerted that there was a shot fired on a dispatch call, is that correct?
That was as we were entering the complex, the updated information of the shots.
Okay.
Or a singular shot fired.
All right.
We then parked. Because of that new information that we received about the shot fired, we parked down from the location.
Okay.
Approached on foot. Prevent ourselves from being shot.
Okay, fair enough. You took a defensive position as to your approach. Is that a fair statement?
Yeah.
All right. Now, when you were in this location, you indicate throughout your testimony, not only my questions, but through Sister Counsel's questions, you said that we were approaching a specific location. Did you have an address in which you knew that you were going to be approaching?
Yeah.
Okay. Do you recall what that address was? Or would you prefer to look at your report to tell me that? Would that refresh your memory?
Yes.
All right. May I approach again? You may. Thank you. I'm just going to give you a three-page document, which appears to be your report. Okay. When you don't read it out loud, but when you're done reading, just let me know and I'll come back and get it. That's my only comment. Maybe not. Did you get an opportunity to review your report? And did that reviewing your report, did that refresh your memory as to where you were, the dispatch? Let me ask you, not to presume something, it was the dispatch information that led you to a specific location that you were going to. Is that fair?
Yeah.
Having had an opportunity to review your report, did it refresh your memory as to where that location was that you were going to approach?
Yeah.
And for the purpose of the record, what was that location?
150 Stevens Drive.
Okay. And could you describe to the court, well, 150 Stevens Drive, that is a townhouse?
It's a apartment or apartment building.
Okay, it's an apartment building, and that's the specific numbered address, which you understand are apartments within the interior of that.
Correct, there are apartments inside.
Okay. Now, you said that you parked some distance away from 150 Stevens Drive. Have you ever been to that location before?
Yes.
Okay. And did you know where 150 Stevens Drive was?
Yes.
Okay. How far away did you park and then get out of your car from 150 Stevens Drive, an estimate?
That's it, 2 buildings down.
Okay. Would that be more than 200 yards?
Not good at estimating.
Okay. So when you say 2 buildings down, do you recall what area that you parked your vehicle in front of?
It'd be between 120 and 130.
Okay. All right. At the time you're outfitted or accoutred with a body worn camera, is that correct? Was it operable?
Yes.
Okay. And your body worn camera would represent where you were and what location you were when you got out of that vehicle. Is that fair? All right. Now then you get out of that vehicle and you approach. You said you saw that black truck leaving the area and you put out, did you put out on dispatch or did you put a request to be put out on dispatch for someone to stop that vehicle?
Yes.
Okay. And you did that because you had information from a prior dispatch that it was a black truck involved?
Correct.
Okay. Do you know what information or do you know in your mind what led you to believe that there was a truck involved?
Dispatch information.
No, I understand. Was it just merely the mention of a truck or they said that the truck did something? What was it that you had as far as information that would lead you to believe that or lead you to direct others to stop that vehicle?
It was involved in the situation. We had knowledge now that there was a gunshot fired.
Okay.
A gun fired.
Okay. Now, when you approach that scene, or when you approached, you said that you saw 2 individuals outside. Is that correct?
Correct.
All right. When you saw those 2 individuals outside, you saw one was a man and one was a woman. Is that fair?
Fair.
Both black.
Yeah.
All right. And you said you described the woman as wearing some pink clothing.
Correct.
All right. And you saw the male who was laying on the ground. All right, was he face up, face down?
Don't remember.
Okay, you made some indication. Just a moment. You made some indication in your report that you said this individual, you described that individual as Jermaine in your report. Is that correct? All right, and that's who you indicate and you believe to be Mr. McClendon Dinsmore? All right, now you said something about agonal breathing. Can you tell me what you mean by that?
Struggling to get oxygen.
Okay. Now, when you're making that representation, is the person in having answered that question, does that refresh your memory to the effect of whether that person was face up or face down?
So when I got there, I started looking for wounds, so I don't remember exactly where he was at when I started first arrived.
Okay, and so when you're looking for wounds, you're moving the body? Okay, and you're moving him, are you trying to administer aid?
Yes.
What kind of aid did you try to administer?
We applied pressure to both the holes, and then eventually after we lost a pulse, I performed CPR.
Okay, and you say you're talking about your partner, Kelly?
Yeah.
All right. Now, you also described that you found in this area while you were there, you found a firearm in close proximity to this individual who's laying on the ground, did you not? Okay, and you would say, you described this individual who's laying on the ground as approximately 10 feet from a black Cadillac, did you not? And you said sort of in between the 10 feet that was the distance between that individual laying on the ground and that vehicle, there was a firearm in between that, in that ambit of that 10 feet. Is that fair? Okay. And you then, because there was another lay person in that area, you went to that weapon and you made it safe. Is that fair? And by making it safe, you take the weaponry or you take the firearm capability out of it. Is that fair? Or you remove the bullets? Now, when you say that this weapon was within the 10 feet ambit between that individual and the car, it was closer to the individual than it was to the car. Was it not?
I don't remember.
Okay. As you approach this individual, would you agree that if I'm looking at this podium as the young man who lay on the ground, would the vehicle be to the left or to the right or behind him?
You rephrase the question.
If I'm using the podium as the young man who lays on the ground, with respect to the relevant distance and location of that particular vehicle, would that, as you approach him, would the vehicle be to the left, to the right, or behind him?
So if I was walking towards the podium.
And this is the young man right here.
So I'd be walking towards him. The vehicle would be to my right.
Okay.
And the firearm would be between the vehicle and him.
Okay, so it would be to that individual's right. Is that fair?
It'd be to my right as I'm approaching.
Okay, all right. Now, and you would agree that that weapon was closer to the individual than it was to the vehicle. Is that fair?
Again, I don't remember exactly where that.
Okay.
If you review the body camera, you can see exactly where it was placed.
Okay. As you approach that individual, did you see? I understand your focus is on your job as a law enforcement is preservation of life. Fair enough? Your safety, then preservation of life. Now, I understand your focus is on this young man who's laying on the ground, but as you approach, did you see this firearm that was between him and this vehicle? Okay, all right. It was in plain view, in other words. Okay. Now, when you you said at some point in time you conveyed Ms. Chandler to your precinct or to your police station. Is that fair? And when you conveyed her to the police station, was she free to leave or was she going on her own volition?
I'm not sure.
Well, you were the one who was conveying her, right?
Correct.
Under what auspices and under what direction were you conveying her?
Sergeant was not safe.
Okay. So you were told to convey her by someone else who approached the scene. All right. You were not aware of, was she in handcuffs at the time?
That's my recollection. Didn't know.
Okay. And did she, when you told her, I'm assuming, and correct me if I'm wrong, I'm assuming you told her that you were taking her to the police station. Is that correct?
Again, I don't remember, but I would assume.
Okay. All right. And instead of, you would agree that you had some information and you recognized that at the time and prior to leaving that scene with Miss Chancellor, that you believe that her parents arrived at that scene. Is that correct?
Okay.
At the scene where this event happened at 150 South Stevenson Drive.
I know they showed up at our station here.
Okay. All right. Now, you don't have any recollection of parents showing up at the location itself. Is that fair?
Yeah.
Okay. When you escorted or when you took Miss Chancellor to the station, did you pat her down before you put her in? Was she in your vehicle?
Yeah.
When you took her down to the police station, did you pat her down? Did she go willingly? You recall whether or not she refused to go? Okay. After you took her to the station, did you take her in? You took her into the police building, into the detective bureau? Okay. Did you have anything else to do with her at that point? When she was in the detective bureau, when she was in that particular building, do you recall whether or not at that point in time whether she had handcuffs on her? You said that you saw this vehicle, which you believe to be the same black truck that was leaving that location at your police station, did you not? And that vehicle was parked where in your police station parking lot?
Right.
Okay, so you saw it in the evidence garage. You didn't see it in the parking lot. Is that fair? So it's without having been told by someone else, you have no independent recollection of how it got into that evidence garage. Is that fair?
Correct.
All right. You didn't see it sitting out here in the parking lot outside. Is that fair? Okay. How long was it that you were at that scene 150 in the area of 150 Stevenson Drive until you dropped off Miss Chancellor at the detective bureau? Was it more than an hour, if you know? Okay. All right. Fair enough. Just one moment. Yeah. Couple of questions, Deputy Van Duzen. In that vehicle, you said that you saw this firearm in the passenger side area of that vehicle. Is that correct?
Correct.
All right. Were you told when you saw that, and you saw this when this vehicle was in the evidence area garage in your department, is that correct? And when you saw that vehicle, were you given any information as to anything having been unsettled at the time that you went in and looked in that vehicle? Do you know what I mean by that question?
Like if the vehicle was searched prior to?
Correct.
I was not informed of.
Okay. Based upon your position, you would assume it had been by that time. Is that fair? Based upon your experience and training as an officer.
It depends on the situation. Sometimes it's not searched on.
Okay. All right. Now, when you looked into that particular vehicle, you also saw a lunch bag, a plastic bag, a lunch bag in that vehicle, did you not? Okay. And going back to that scene, when you approached that scene, were there other officers already on scene when you approached? Yes, I'm sorry, I jumped back to that. I'm sorry. Let me ask you. So when you initially got the dispatch call, you went to the area of 150, or you were driving in the area of 150 Stevens Drive, correct? And when you got to that location, were there other officers there, or were you and your partner the first to arrive? How long after you arrived did the other cars start coming? Okay, but it would be displayed on your body cam. All right. Thank you. I don't have anything further.
Any redirect?
I have no more questions, Your Honor.
All right, thank you, Deputy. Appreciate it. Bless you.
Oh, thank you.
You may call your next witness.
Yeah, thank you. Jonathan Emmons on behalf of people. Good afternoon. I'm going to call Deputy Frank Barabbas.
Take your first and last name, spell it for the record.
F-A-R-A-K, last name Barabbas, G is in boy, A-R-A, G is in boy, A-S.
Got it. All right. May inquire.
Thank you. Deputy Barabbas, thank you for being here today. We've got your name, your current employment. Your current employment.
Deputy Sheriff for the Washington County Sheriff's Office.
And how long have you been so employed?
2 years in January.
Okay. And what was your assignment on June 18th of 2023?
I was a single man unit for Ypsilanti Township from midnight to 04.
Okay. I want to turn your attention specifically to about 1:45 in the morning. You were working that shift. That was part of your patrol shift on June 18th.
Correct.
Did you, on or about that date and time, did you have a dispatch to go to the 150 Stevens Drive area?
Correct.
Can you tell us a little bit about what the nature of that dispatch was?
The nature of the dispatch was a disorderly group of people standing out in the parking lot or in the parking lot. And they just, callers just saying they're disorderly, it's a male and female arguing outside.
And at some point in time, while en route, did the nature of that dispatch change?
Yes.
In what way?
While en route to the call, the caller was, the person who called 911 to report the disorderly event had called back again and said that the female.
I'm going to object. That would assume not an evidence, and it would be hearsay if he's describing the same caller as having made that call. I mean, he can describe what he got from the dispatch, but for him to represent the same caller.
I'll sustain that objection.
Thank you.
We can clarify.
Yep. If I may direct him.
Go ahead.
So just tell me what dispatch was telling you. What information was dispatch giving you about?
Dispatch told me that the female was sitting in the black truck, that the male got out of the black truck with a sawed-off shotgun.
Okay.
And then shortly after, dispatch advised again that the male that got out of the truck fired a shot.
Okay. So now shots are fired, and you're on your way to that scene.
Correct. That was on my way.
Okay. While you're still on your way to that location, did you get some information about a particular vehicle of interest?
Yes. So on the way to the call, 2 deputies already had been arrival. They advised that there was a man down and a black Silverado or black truck leaving the scene.
Okay. When you get this information, do you recall about where you're located or how far away you are from that Stevens Drive?
I believe I was northbound Mansfield at the intersection of Congress.
Okay.
Information came out.
And what street does Stevens Drive intersect with?
Congress.
Okay. All right. And so do you turn onto Congress?
Correct. I start going westbound or southwest on Congress.
Okay. What kind of vehicle are you driving?
I'm driving a fully marked Washington County Patrol vehicle Ford Explorer.
Okay. At this point in time, given the nature of the dispatch, are your lights and sirens activated?
Correct. They were activated.
Is you've got a dashboard camera?
Correct.
Is that operational?
Yes.
Have you had an opportunity to review that dash cam footage or at least the relevant portion of it prior to your testimony today?
Yes.
Do you believe that the dash cam video that you reviewed is a fair and accurate recording of the incident that you were involved in that during that shift?
Yes, sir.
As you come down Congress, do you encounter a black or a dark colored Chevy Silverado?
Yes.
Okay, explain to me those circumstances.
I was going southwestbound on Congress, approaching the Stevens Drive. As I was approaching Stevens Drive, I observed a black newer model Chevy Silverado exiting the apartment complex.
Okay. In what direction was that vehicle heading in relation to you?
The vehicle started going northeastbound.
Okay.
The opposite direction of my car.
All right. And so how did you pursue the vehicle?
I pursued the vehicle by it was in a spot where I saw it close enough to where I was close enough to the entrance of Stevens Drive. So I used this entrance of Stevens Drive to turn around and get behind the vehicle.
Okay. Your Honor, with the well, at this point in time, I'm going to move to publish. It's a 26-minute long video. I'm going to skip through the relevant portions of it. I'm going to move to publish the first part of that video as Exhibit 3.
It comes in, Your Honor.
Yeah, okay, thank you.
I'm sorry for not standing.
No, that's fine.
And if I should be plugged in. Oh, great.
Thank you. Yours is working.
It's going to be 113 on the video marker for the record. Okay. Oh, I'm sorry.
No, that's good.
149. Stephanie Van Duzen, we see here, right here on this video, you're able to see that on the monitor in front of you? Is this that vehicle that you're speaking about, that dark pickup truck?
Yes, sir. That's okay.
That's the same vehicle that you spotted? Okay. And for the record, I've stopped it at 221. You're on Congress right now, and you've just turned right onto what street?
We are on Mansfield.
Okay. So now tell me what your obviously at this point in time your license sirens are activated. Okay. Were you able to get the license plate of the vehicle?
Yes.
Do you recall what it is off the top of your head?
Edward Frank 8550.
Okay. And did you give that information to dispatch? Okay. And did dispatch, were they able to give you who the registered owner of that vehicle was? Do you recall the name of that individual?
They advised it was to Martez Robinson off of Mary Catherine in Sullivan Township.
All right. Tell me about the next little bit of travel here from Congress moving forward.
Okay, so we leave Congress here. This is now we're going southbound on Mansfield, approaching Michigan.
Mm-hmm.
We approach Michigan and go make a right to go westbound. That's correct. We go westbound Michigan.
Okay. I'm gonna pause you right there. You've now turned westbound Michigan.
Right.
At this point in time, are any we've obviously seen that there's a number of different patrols involved. Any countermeasures being employed to try to stop this vehicle?
Yes.
What's that?
There was a deputy off to the right side of the road attempting to deploy stop sticks.
Okay. And you're behind the vehicle when that is employed?
Right.
And do you know whether those stop sticks were successful? Okay. All right.
They were deployed on Michigan.
Correct.
Okay, thank you. Go ahead.
All right. Turns right westbound on Michigan. What's the next series of travel?
And then it makes a right turn onto Ellsworth.
Okay.
It also makes another turn to go back eastbound, I believe, or northbound on Hewitt after it turns off Ellsworth.
And then where does he take Hewitt northbound to? If that would refresh your recollection.
Yes, you're asking after Hewitt?
Yeah. Well, he takes northbound Hewitt to where?
Okay, he takes it to Washington Ave.
Okay. When you get to northbound Washtenaw at this point in time, you're familiar with this area?
Washington Hewitt, yes, sir.
And then kind of the surrounding area at large. Is that a yes?
Yes.
Are there any businesses or of any kind open at this hour? We're looking at about 1:49 in the morning.
Yes, there are several gas stations, and if I'm not mistaken, I believe Happy's Pizza is still open on the side, and it is also on Washington Ave.
Okay. Important for you to know. Okay. He gets to Washtenaw and Hewitt. What happens at Washtenaw and Hewitt? Or Hewitt and Washtenaw, however where does he go from there?
Subject that, so he goes eastbound on Washtenaw, and then he makes a right turn to go southbound on Summit.
Okay. Thank you for that. Taking me to Summit.
Objection, is just looking at the detective's eyes, he looks like he's looking at his report. If he needs to refresh his memory, just do that, and that, I don't have a problem. I just want the report, the record to reflect when he does that.
Thank you. I didn't notice that, but I just remind him.
Yeah.
If you could do that, sir. All right. You can turn your report over. If you need to refresh your recollection, that's fine.
Just let me know if you need to refresh your recollection. I recognize.
You asked me a question.
Yes. So he turns eastbound onto Washtenaw or westbound off of Hewitt?
I believe he turns on eastbound Washtenaw.
Okay. And so then what's the next street of travel that he heads down?
He goes down Summit.
Okay. And is it northbound or southbound?
Southbound.
Okay. Southbound on Summit. Summit, you get on this street, you familiar with this street?
No.
Okay. Did you happen to notice as you were driving down it what the speed limit was?
Yes, it was 25.
Okay. And then if you could just give us the next few streets of travel as you best can remember it. And if you need to refresh your recollection, just let me know.
Can I refresh my recollection?
Sure. And so we're southbound Summit.
So southbound Summit, that means we started going eastbound on Michigan. And then we made another turn to go southbound on Hawkins and westbound on Harriet and northbound on First, eastbound on Michigan, northbound on Normal, westbound on Congress.
I'm going to stop you right there. Those streets that you've just listed off, other than Michigan, you've got Hawkins, Harriet, First, Normal, and Congress. Those streets. Do you recall whether any of those streets have a speed limit of 35 miles an hour or less?
I believe all streets have a speed limit of less than 35 miles per hour or less.
All of those streets? Okay, thank you. All right. Then I'm sorry, after Congress, what's the path of travel?
After Congress?
Yes.
I believe the subject goes back down south on Summit again.
Okay. And then what's he do when he gets to Summit? Where does he turn?
I believe he makes a right turn to go westbound on Woods.
Okay. Now you have some kind of navigation device in your car, is that right? Anything uniquely remarkable about this neighborhood of Woods Drive?
Yes. When I came up to the area and I got into the Woods Drive, I could observe on my GPS is mounted on my glass that it was essentially a dead end with only one entry and one exit.
Okay. And so what is that informing you of now that he's turned into this neighborhood?
Then he has to go back out the same way that he came.
Okay. Ultimately, how many times? It's just the two roads, right?
Correct.
Did you name the second road? It's Woods and
Pleasant.
And Pleasant. And how many times does he ultimately go around this loop?
He does 2 circles.
Any countermeasure is going to be employed while he's in this neighborhood?
Not on the first loop, but on the second, yes.
And what are those?
Stop sticks are deployed at the corner of Woods and Pleasant.
Okay.
And I believe there's another stop stick set up at Woods and Summit.
Okay. And are these the second use of these pair of stop sticks? Are they effective?
I can confirm that the first set in the circle.
The Woods and Pleasant?
Woods and Pleasant was a good hit. Were effective.
And whether or not, you don't know whether the second set was?
No.
Okay. I'm going to play the video. For the record, 1319 is where I'm at. And this is, you're paying attention to the monitor? This is you entering or within that Woods neighborhood? Does that look correct?
Yes, it looks correct.
And now doing the second loop. That right there, what we see in the middle of the frame, is that the stop stick?
Yes, the long black thing in the road is the traffic.
Thank you. And on the left side, you see like on the easement there in the grass, that's the employing deputy?
Correct.
Okay. All right. And then you said that this was effective?
Yes.
Okay. After this stop stick is employed and hits, what does the vehicle do?
He exits Woods Drive back on Summit.
Okay. And where does he go from Summit?
He goes northbound Summit to Washtenaw.
Okay. And how long at this point in time does it take before you notice that the vehicle starts to have some difficulty?
Off the top, I'm not sure exactly the distance, but from the time that we exited the Woods Drive on Summit, I noticed that the subject had was starting to get a flat rear left tire just after Pearl Street.
Okay. And describe the vehicle as driving. Well, does the vehicle turn, I think, westbound onto Washtenaw? So this is like right by the water tower?
Yes, this is right by Eastern's campus.
Okay. Describe that turn, that westbound turn.
The turn was very wide. At that point, the subject was pretty much on flats. There wasn't the tires didn't have air in them. That's what they figured. It did not have any air in them. It was rolling really rough. It was a very slow and wide turn, almost to the point where it hit the far side curve, almost, I believe. And then it kind of brought it back. But during that turn, it was also braking and slowing itself down.
Okay. And then what does the vehicle do as it goes down, once it's on Washtenaw?
It just continues to drive straight.
Describe that, and it goes down Washtenaw for a while, correct? Describe that drive down Washtenaw. How is the vehicle maintaining?
Not well.
Okay.
If I'm not mistaken, it was on almost, if not all four flats at that point. So it wasn't traveling very fast. It was really slow. There wasn't a lot of maneuvering at all. Just very slow, straight vehicle.
In the video that we just watched, as the vehicle proceeded down Pleasant, we saw the vehicle accelerate away, and then you quickly catch up on the turn. Would you say that through?
That's really leading. It's video is what it is, but
Are your objections leading?
Yes.
Yes, sustained.
Okay. How far would you say that? I just want to know what the distance is during the course of this travel. How much distance did the vehicle get away from you?
In this
Throughout the entirety.
For this point?
Yes. After you turn around.
I would say the furthest point would be from my initial turnaround to when the vehicle starts to make its right turn onto Mansfield.
Okay. Again, now taking us back to it, we're on Washtenaw Avenue. Any businesses that are open along Washtenaw Avenue at this hour?
Yes, there is The new gas station at Shell and Hewitt, I believe, is still open and well lit up. If I'm not, I guess I'm not mistaken, I believe Happy's Pizza was still open until 4 in the morning or 2 in the morning, I believe, one of those two. Not 100% sure, but I believe that was still open. Along with several other gas stations.
And then finally, as the vehicle heads along westbound on Washtenaw, any other countermeasures employed upon Washtenaw?
Yes, there is another set of stop sticks deployed at Washtenaw and Gulfside.
Now, fast forward to 2231. Play that repeat video. Yeah.
It's coming up.
It's coming up. What? And is that rear tire that you were talking about that we're looking at right now? See, how would you describe it?
A tire that's completely flat and it's starting to rip because of the weight on the road.
That's the stop stick I think that he just went over.
Third set of stop sticks hit.
Ultimately, where does the vehicle finally get off Washtenaw Avenue? Stop at 2342.
It takes a right turn into the Station 1 parking lot, and then it comes to a final rest outside of the Juvenile Detention Center on the right side.
So right out here in the rear parking lot of the courthouse. How would you describe the vehicle's condition as it turned into that parking lot?
No, absolutely no air in the tires at all, almost completely on the rims.
And you describe where the vehicle came to rest. Does the driver ultimately get out of the car?
Yes.
Okay. Did you maintain, at least for the majority of this until maybe the very end, the primary or lead position in the pursuit? Obviously, there are multiple other units engaged. Do you approach the driver at all once the vehicle comes to rest?
Yes, I begin my approach to the driver.
Okay. And you get relatively close to him?
Yes.
And is that somebody, the driver of that vehicle, is that somebody who you see in the courtroom today? I just need you to tell us and point to him what he's wearing.
He is sitting over there on the desk. He's a black male wearing all green with a white t-shirt and a goatee.
And ultimately, that individual is then taken into custody by other officers.
Right.
Thank you. I'm going to play the last little bit of the video, moving to 2614. For the record, the witness has identified the defendant.
Record shall so reflect without objection.
And this is just outside 14A1, is that right? That's the person that you've identified as the defendant.
Yes, sir.
Nothing further, Your Honor.
Good afternoon, Deputy Barabbas. I'm gonna ask you some questions. If you don't understand them, let me know, and I'll offer you a question you understand. Is that fair?
Sounds good.
Now, you indicated, or you testified that you were approaching a location based upon some dispatch communication. Is that fair?
Yes.
All right. Would it be fair to say that the initial dispatch was not what called you to that scene, but the second dispatch, or were you coming on the first dispatch?
I went to the scene on.
Okay, so you were coming on the first as a result of hearing a dispatch of a disorderly, is that correct? Were you aware that there was another car en route to that location as it relates to that disorderly, or were not?
A police car?
Yeah, police car.
To the first call or the second?
The first call.
Was I aware? I'm just confirming. Was I aware of a second unit coming?
Yes.
Yes.
Okay, what unit was that?
I don't know the number, but I believe it was Deputy Vandervoos. No, Deputy Van Dusen and Deputy Kelly.
All right. Now, in this particular situation, you said that you were relying upon dispatch information in order to, as to how you approached and how you did things that evening or early morning. Is that fair?
I don't say relied on them for how I did things.
Yes. Well, let me ask you. You relied upon dispatch information as to the reason why you didn't enter into that complex and you turned around and followed that vehicle. Is that fair?
I went off information based off information given by deputies on scene.
Okay, so when I say dispatch, is it the difference between dispatch and information that you receive from deputies on scene?
Correct.
Okay, it doesn't go through any central mechanism that we all call, that I might just generally term dispatch?
It goes over the air.
Okay, over the air. Okay.
From dispatch.
Now, the dispatch information you had was that there was a disorderly involving a man and a woman initially. Is that fair?
Right.
Then you said that there was a second dispatch in which, the first dispatch indicated that the woman was in a black truck. Is that correct?
In the first incident?
Yes, in the first. Now, you indicated in your report, there's two areas in your report where you talk about two different areas of dispatch information you have. Is that fair?
Can you elaborate, Mike?
Right. In your report, in your initial portion and in your first paragraph of your report, you would agree that you indicated that dispatch advised that parties were back on scene and arguing in the parking lot again, and that the female involved is now sitting in a black truck in the lot.
Right.
Okay.
Second call.
Okay. Does it reference that it's the second call in this particular report that you wrote? Would reviewing your report refresh your memory? Yes, please do. And anytime, as the judge indicated, I just read, when I say, and I sort of stop you, all I'm trying to do is make the record reflect that you're reviewing a report. That's fair enough. Okay.
I wrote in my thing that I was dispatched to an area of Stephen Giles for a return trip to the area, indicating that it was my second time going.
Okay, so you had been out there earlier.
Right.
Oh, okay. When you came out there earlier, there was another. So would it be fair to say that you received, would it be 3 dispatch calls?
No, 2.
Okay. Now, would you agree in the second paragraph of your report, it indicates while en route. Is that fair? And you would agree that as you've been trained to write reports, you write in the best you can in a chronological fashion, do you not? Sort of as things progress, that's how I write and memorialize what transpired. Is that fair?
Yeah.
All right. And you would agree that in this second paragraph, which would lead us to believe, based upon if you wrote this in a chronological fashion, that you got another dispatch call while en route. Is that fair? Would looking at your report refresh your memory? Please do.
Are you asking about my second paragraph?
Yes, please.
Okay. So what's your question again?
So now you'd agree that while en route, you as you indicate, while on my way to call dispatch advised, that is a second dispatch call. Is that fair?
No. So when you say dispatch call,
Can I just stop?
Yeah.
Because I want to make sure I'm not getting confused. There, as I understand the testimony, there are dispatch calls and then there's over the air,
Correct.
right?
I haven't gotten to over the air yet.
Well, I think you may have without knowing, because I think you're asking about a dispatch call, but you're calling it a dispatch call. I think it's information he's receiving over the air. And that's why I want to make sure I'm not confused.
Okay.
Counsel, I don't mean to interrupt your cross.
No,
I'm just
that's fine.
saying, I just want to make sure.
All right. So now, were you in that second paragraph when you indicate while on my way to the call? So that's a call dispatch that you have. You're referencing that are in the first paragraph. Is that fair?
that I was just dispatched to Stevens Drive.
Okay, fair enough. And that information came out about a mail. This is over the air that you received. A mail came out of the black truck. Is that correct?
Correct.
Okay. You would agree that that information didn't say whether or not that female was in that truck or not. Is that fair?
At that time, yes.
Okay. All right. Now, did you memorialize the initial run that you had in that particular, when I say run, you got to, let me strike that question. In your report, in that first paragraph, that would be fairly to characterize that as the second dispatch call that you received on that particular tour of duty you were on. Is that fair?
Yes, it was the second dispatch call to 150 Stevens.
Correct. Do you have, or did you memorialize in a report the initial dispatch call that you received to that location?
The first one?
Yes.
Yes, I believe I got a CFS report.
Okay. Do you have that with you today? Okay. That's not part of this right here.
No, it was
Okay.
a separate call.
All right. All right. So when you came out to that location the first time, you saw nothing. Is that fair?
No.
That's a fair statement?
No.
You saw someone? Yes. Who did you encounter at the first dispatch?
I saw a female wearing pink.
Okay. And you saw her. Did you encounter her? Did you interact with her?
Yes, I talked.
Okay. And at the time, you didn't see a black male with her?
No, sir. She was standing alone.
Okay. You didn't see a black or a Cadillac vehicle in any proximity to her?
No, sir.
All right. And as a result of the communication you had with her, you left that area, did you not? All right. Did you make any notifications about what you did at that particular location to dispatch?
I believe, if I'm not mistaken, that I made contact with the female on scene.
Okay. At the time, were you operating and outfitted with the body worn camera?
Yes.
All right. Was it operable that evening?
During that first encounter with the female?
Yeah.
No, sir.
Okay, it was not operable. You have the ability as a law enforcement officer to be able to disengage or engage your body worn camera?
Sir.
How is that done? Is it just a button you press?
There's several ways. If I just want to turn my body cam, yeah, I just double press my chest.
Okay.
Now, if I do click on my lights in the vehicle, it turns on all the cameras.
Okay. Now, as you and it was that information that you received over the air that caused you to turn around rather than going into the interior of that complex and follow that vehicle. Is that correct?
Correct.
All right. Now, you took a circuitous route, ultimately winding up at this facility here, or this property here, correct?
Correct.
All right. And when I say here, I mean the Washtenaw County law enforcement facilities. Yeah.
Service center.
Service center area. Yeah. Okay. Now, along the route, would it be fair to say, now in your report, you had information and you understand that at no point in time during this traveling of circuitous route, that this vehicle ever went faster than 50 miles an hour during the course of you following this vehicle. Is that fair?
I would say that's fair to say, yes.
All right. And at the time that it was going 50 miles an hour, it'd be best described that that vehicle was driving on Washtenaw, which is a 45 mile an hour area. Is that fair? Okay. And you would agree initially when you encountered this vehicle, the first time on the westbound West Michigan, that vehicle was doing 22 miles an hour in a 45-mile-an-hour zone. Is that fair?
Where it was going, that
When the initial time you described a route in which that vehicle went from northbound Congress to southbound Mansfield and then westbound Michigan. Is that fair? The first time it got on westbound Michigan, you'd agree that that vehicle at the time when, and you understood westbound Michigan Avenue at that area to be a 45-mile-an-hour zone. Is that fair?
I believe it's 30 on Michigan Avenue there. If I'm not mistaken, sir.
Okay, but you would agree that that vehicle at that point in time was traveling at approximately 22 miles an hour.
Yes, sir.
Okay. It would be fair to describe this vehicle as not using excessive speeds. Is that fair? Okay.
Are you talking about it during the whole incident?
During the entire transaction, and when I say transaction, from you turning at the lip of Congress and following that vehicle until that vehicle comes to rest at the service center area. Is that fair?
Yes, that's it.
Okay. And it would, in fair characterization, your words, or if I'm able to do so, you tell me that it was not using excessive speeds. Is that?
I would say it was not using excessive speed.
Okay. Is that good?
Okay, that's fine.
All right.
That's fine.
I get confusing, Your Honor, so I want to correct it. Now, were you aware you encountered Mr. Robinson when he got to this location and that vehicle came to rest? Fair enough?
Correct.
You understood that individual, Mr. Robinson, that you described as being Mr. Robinson, got out of that vehicle with his hands up, and he complied with the commands that you had? Did that individual tell you at the time when you were encountering him that he was on the phone with his mother?
No, I didn't observe that he was on the phone with his mother. I observed that the person driving that vehicle, later identified subject here, was on the phone.
Okay, and that's fair enough. And that's during the course of the travel that this vehicle was taking. Is that fair?
Correct.
Okay. Did you find out during the course of time that that individual described himself as being scared of law enforcement?
I would not say law enforcement. I remember encountering him advising he was scared.
Okay. Oh, when that vehicle approached, and I believe it was the first, let me ask you a general question and correct me if I'm wrong. That vehicle did obey various traffic control devices throughout this travel. Is that fair?
To a point.
Yeah. Okay. And there are points when it did not. Is that?
Yes, sir.
Okay. Throughout the course of travel of this vehicle from that point of Congress ultimately to the service center, that vehicle didn't cut off any other passenger vehicles. Is that fair?
Did you ask me?
Yeah. Yes.
I do not believe so.
All right. Although disobeying what you believe to be other multiple scout cars and vehicles that other law enforcement vehicles with their lights oscillating and their sirens blaring. Is that fair?
Yeah.
It disregarded.
Oh, yes, sir.
All right. You only, as it relates to when you described a fired shot, you're talking about information that was conveyed to you, not that something that you recognized heard.
That
Okay.
information is conveyed to me.
And so if that were correct, because I got off on the wrong foot also, there were 2 dispatch calls and 1 over the air in your initial approach to that location of 150 Stevens Drive.
So there was.
I take it back. Let me ask you a better question. On your second approach, there was a second dispatch call and an over-the-air communication from law enforcement as you approached going to
I
156?
was initially dispatched back to the location,
Right.
and while en route to that location, information kept coming over the radio.
Okay. And when we say over the air, it continued to be over the air communication as you're driving throughout the area of it. Okay. Just one moment. Were you, when Mr. Robinson expressed to you that he was scared, did he indicate to you that he had previously been injured by law enforcement in Ypsilanti?
I do not recall.
Counsel, you may want to mute the mic if you're talking to your client. Just, it has to remain green. Yes.
Did he indicate to you at any point in time about a lawsuit against Ypsilanti police officers? Okay, thank you so much. I don't have anything for you.
Any redirect?
Just a moment, Your Honor. No further questions.
All right, you may step down. Thank you, sir. Any additional witnesses for the people?
No, Your Honor, we rest.
All right, any witnesses for the defense?
No, we do not intend to call the witness.
Do I have a motion?
Thank you, Your Honor. I believe it's a question of fact for the trier of facts. I believe by probable cause standard, we have proven counts 1 through 3. And we ask you to bind the circuit court report. Is there any further argument for rebuttal?
All right. Mr. Perkins.
I am looking for my face sheet.
All right.
Well, let me say this, Your Honor, if I may it please the court. Your Honor, I do believe the only thing that has been proven is that there was a shot. There's an individual, a young man who I believe expired as a result of being shot. There is Mr. Robinson's vehicle that is ultimately searched, and a firearm is found in that vehicle. I don't recall any testimony that there's any relationship to that weapon in that scene. Although as an officer of the court, I'm not here to represent something that doesn't exist. I'm just saying that the proofs that you have before you, although they may align themselves, I just don't think that there's enough evidence to say that they've satisfied that a homicide has been committed. We understand that a death has occurred. That's it. Now, as it relates to the other elements or the other counts in this particular case, given the nature and given the more clear testimony than some of my questions from Officer Barabbas, this is not a person who's fleeing and eluding. This is not a person that is trying to evade. This is a person who is leaving an area in which I think there's information, at least sufficient information, that a death occurred, but not a person who was trying to escape law enforcement. Where did this vehicle ultimately come to rest? This vehicle came to rest at the service center. This vehicle came to rest in an individual, as we have on the record at the very least, an individual who described themselves as being scared based upon the testimony of Officer Barabbas. So I think this is a conundrum of sorts, Your Honor. This is not a homicide that I believe has been proven or established even by probable cause standard. We have the information, as you may recall, from the lay witness who described, as you recall, this lay witness did not see and did not testify that she saw the shooting occur. All she described, albeit dispatch information that we have from officers, they're only relying upon that, and I'd ask the court to only rely upon it as to accepting that information as to why they did what they did, not as substantive evidence as to what transpired at that particular location. So based upon all of those things, I don't believe that the government has established by probable cause standard count 1 of an open homicide. I think that they have a very serious problem. That doesn't mean that they can't try to rewrite this, but at this point in time, they have not established that. Nor do I believe that they have established the fleeing and eluding in this particular matter. I will remain silent as to the other count. So again, and allow them, I'm not saying I agree with it, and I'm not saying that it's a question of fact, I'm just remaining silent. So thank you so much. I have any questions of the court?
No,
Thank
no,
you.
not at this point. Any response from the people?
Obviously, who was the first witness that testified was at a different time in front of the court. She did say she saw this defendant exit from a black truck. He was crouched down between cars, had what she appeared to be some type of shotgun or sawed-off shotgun in his possession. The same similar type of gun was found in his car after he fled in the loop from police. I mean, if you want to say that he was driving to turn himself in and he was going slow, he took a ginormous parade route to get there, went over stop sticks. Literally, his car was disabled by the time he got into the Washtenaw County Sheriff's area. So I believe by probable cause standard, based on the prior testimony from our lay witness and the two officers that were here today, that there's a probable cause that this defendant did in fact shoot Mr. McClendon Sizemore. So I'm asking to bind it over.
Anything additional, Mr. President?
Again, there's no testimony from that lay witness who testified that she, because of the fear of what she saw, she went and extricated herself or removed herself, went into her bathroom. She was very afraid, and she was, as you could see, it was palpable in her testimony. But again, I don't come here in the court in bad faith and say, they didn't bring in someone and didn't test it, and that's not the weapon or anything like that. I just remain silent as to those issues. As it relates to it being described as a shotgun, I think it's more accurately described as a longer pistol, but the court can make out from the exhibit that's been presented as to what it is.
Well, so we can clarify that. I believe Ms. Hendricks, regardless of how you characterize it, had indicated that it was a firearm of some type that she saw. So I'll leave it at that. And I think that it might be a question of fact as to what kind of firearm, but doesn't really matter from this court standpoint. Certainly there are cases where one might have more direct connection, but that doesn't mean that the court doesn't or ignores those logical inferences that flow. The individual black truck firearm, some point, and then going back to Ms. Hendricks then testifies she heard the shot. At some point, officers arrive. There's an individual who is indeed shot, who is indeed then killed, or at least is deceased at that point. The black truck, as described and had been reported to the officers, then is pursued in that black vehicle. Ultimately, it's found the defendant as well as a firearm. Now, there may be other explanations, but given the entire circumstances as the court sees it, with reference to count one could certainly make that connection that the individual who was in that black vehicle with that firearm indeed shot the decedent in this case. I don't think that's a huge logical leap, particularly given that one can also take into account the defendant's actions after the officer Barabbas is behind them. Taking all of that into account, as to count one, the court does believe that the people have indeed sustained their burden of showing that the crime of homicide has occurred and would bind the defendant over on count one. As to count two, the fleeing and eluding, and I appreciate Mr. Perkins' argument that maybe he wasn't trying to get away. I don't think that it's really an element. It may be an argument as to some type of mitigating factor, but what is clear is that the element of that offense is that there was an officer lawfully exercising their duties who lights and sirens directing an individual to stop, and they did not. That is clear from the video. It is clear also from the testimony. And so on that count, the court would find that the people have sustained their burden and would bind the defendant over on count 2. As to the carrying a concealed weapon, there was no counter to that motion being made. The court also does believe that the people have sustained their burden as to count 3. So the court would bind the defendant over on all 3 counts to stand trial.
Your Honor, may I?
You may.
I'd ask at this time, I know the court is making a ruling. I'd ask to renew the issue of bond at this time. And we filed a motion and then we refiled it. Court denied it initially at our PCC hearing. Courts had an opportunity to review this and hear the testimony in this particular matter. I don't think bond is appropriate for this individual. It is a homicide. It is a very serious case. But we have an individual who has minimal prior record. He has a prior, I believe it's an alcohol-related misdemeanor that he had in his background. He's employed and was so employed by the University of Michigan up until this day. And he has a plethora of letters, including supervisors and his family who's been present in court. I believe that there are certain circumstances as it relates to bond. I mean, whether you take it from the federal perspective or from the state perspective, you want an individual to return to court and not be a danger to society. That's essentially what you want. This individual has a microcosm or a snapshot of his life that unfortunately plays out, that has to play itself out in the circuit court in Washington now. But at the end of the day, you do have an individual or you see an individual and you know that there's evidence that there's a firearm that was, there's clearly, and I think that the court, understanding how this is gonna go, it's a clear argument and a sufficient argument of a self-defense claim in this particular matter. And based upon all of the factors, I think in this case, I do believe, and I don't believe that the presumption is great or proofs are great and the presumption is evident, or however, if I'm transposing it inappropriately, but nonetheless, my argument is this individual should be afforded a bond. There are set circumstances that the court put in place to give him a bond. He doesn't have to just waste away without being able to provide for his family, go back to work and defend in this particular case. He has no habeas history. He has a history, and I think most relevant as it relates to the issue of flight. And I think that was what the prosecution said. And as we argued at the initial hearing, or bond hearing at the PCC, the court didn't have any information about this case other than the charges. And I understood, and I explained that to my client, why the court, under those circumstances, wouldn't upset what the magistrate had done. But I did present to the court, he sued the township for serious injuries that he had resulted in. And it didn't turn into a trial because they settled. But again, those are the effects that you have from an individual who described himself as being scared, per the words of Deputy Barabbas. But this is not a situation where they were, as he described, no excessive speeds. I understand that may not be standard, but it is a mitigating factor. And I think that that factor should mitigate itself as it relates to the court's determination of bond at this point. So that's my argument, Your Honor. Rather than rehashing the whole thing, I wanted to bring out the salient points that matter. And I'd ask the court to consider that. Thank you.
Responses to the bond issue.
Judge, this is obviously a homicide case. I believe the defendant is a danger to society based on the fact that he shot and killed another human being. And instead of staying there, he left the scene. He didn't even render aid, did nothing. He left the scene and then took off on a 27-minute fleeing and elude from police. And you can say he was driving slow and he was abiding by laws, but they had a disabled stop sticks. He was a danger to society at that point. I believe he's a flight risk based on that. He had 5 prior police contacts other than the Ypsilanti lawsuit, and he didn't flee in any of those circumstances, Judge. So to say that now is disingenuous. I use that as an argument, besides the fact that he was scared. I'd be scared too if I killed somebody. So that using that as an argument that he's scared of police because he had a prior lawsuit is not true, given the fact he has been pulled over by police 5 times and didn't flee in those circumstances. So I ask you to keep on the same.
Yeah. Well, Your Honor, the prosecution wants it both ways. She said, I would be scared if I just shot somebody. Well, if that's consistent, then being afraid, and then you couple that with an individual who has the circumstances under this versus an operating while impaired is completely different. And to say that these things, one shoe fits the other would be preposterous. This is a set of circumstances in which he did not, from a colloquial perspective, albeit not legal, but again, that mitigating issue, did not flee. He drove ultimately to the police station. The officer is describing this individual.
Counsel, I'll let you go on, but
yeah,
I mean, as I was watching, and I haven't seen the whole video, but just those portions. How many police vehicles with their lights activated and stop sticks can an individual go over and pass before the court concludes that, albeit slowly, is trying to avoid law enforcement?
I understand that, but at the same, and I'm not asking the court to abandon your common sense, but what I am saying is looking at the totality of the factors. It's on the phone, and I can make this as an issue of bond, just as I made the issue of this lawsuit, but he's on the phone with his mom, talking about what he needs to do, where he should do, where he should go. He ultimately finds himself and navigates himself back to where we are today, into this particular location. And I think that those things, notwithstanding the seriousness of the offenses, to say that he's not eligible for a bond is just, I just think it's, in this day and age, as we look at how we do criminal prosecutions, it is draconian.
I think, however it occurred, and the courts listened to the testimony, and while it might be from a, there might be self-defense issues or other issues that come forth, but from what the court sees in this case, the only thing that's draconian is the slaying of Mr. McClellan Densmore. That's the only thing that I see that is draconian in this entire thing. I don't see this defendant's bond, if he's denied bond, as being draconian at all. In fact, our laws are set to certainly give individuals a reasonable bond, but in certain circumstances, individuals should be denied bond. I believe that despite what has been presented to this court, that indeed this is a circumstance where a bond should be denied. I have an individual where I have a death. He is leaving the scene of that death. There is a firearm in his vehicle. And regardless of talking to mom, regardless of what might have been a prior loss, regardless of that, it is inexcusable that others were then continued to be placed at risk, including law enforcement officers, as they were going after this individual, and at each location that he passes, because he went past locations that just people are out doing whatever they're going to do. Happy's Pizza, the gas station, all of those places with law enforcement behind him. Past that location of Washington Golf Site twice. And while it didn't happen, that does place people at that location at risk. I see that given that that's what the defendant ultimately was doing that night, I think that the defendant does pose a significant risk to the public and poses a danger to the public. So therefore, respectfully, I will deny the defendant's request for a bond reduction. Bond will remain as denied. Defendant is bound over. Counsel, on the information, do you waive formal?
At this time, Your Honor, we waive any formal reading. Stand Mr. Robinson mute and respect the escort to enter not guilty plea.
Defendant having waived formal reading, standing mute to all three counts. Court will enter a not guilty plea. Pretrial will be set for
December 6th at 1:30 p.m. with Judge Conlon.
December 6th, 2023, 1:30 before Judge Conlon.
Thank you.
Thank you.
Pleasure.
Yes, it was, counsel. Counsel, and may I just say this? And while I have certainly ruled against you on these matters, I think Mr. Perkins, and I will just say this out loud, I think if younger attorneys were in the courtroom watching how you handled yourself during these matters, they'd be well served.
Thank you.
You've done well done. Well done, sir. Thank you.
plaintiff's motion for continuance. I'll hear from you briefly.
Your Honor, and I apologize to the court. I realized this morning that we forgot to file Ms. Caithness's agreement on the continuance. We can supplement that. I had a trial previously set in Wichita Falls, and we're on a 2-week docket, and we're supposed to be ready 24 hours and watching the case ahead of us, et cetera, et cetera. But more importantly than that, that's not in our motion, is that Ms. Caithness is in Germany right now. And so that should have been put in the motion.
How long has she been in Germany?
She just, she just left a few days ago.
Was she not aware? Was she not aware of the trial setting?
Yes, she was, but she had already told us she couldn't have the trial in October. And my main focus was when the setting came in, I was already set in the Wichita Falls case for a long time. And so I wasn't sure what to do. And so it seemed like since she was going to be gone, this would be the one we would ask for the continuance in.
Well, counsel, if this court granted continuances every time a lawyer said they were set somewhere else, we might try 2 cases a year. Every lawyer's got multiple settings that I'm aware of.
Sure, Your Honor, I agree with that.
I wasn't through speaking. And that has never been a basis to continue a case in this court. Now, the good news is, I don't expect you to be in 2 places at once. And so if you are in trial in another court, all you have to do is call the coordinator and say, Judge Jones has got me over here and I can't get there, and your case will be moved. As for your client deciding she's going to leave and not try the case, it's not my problem.
That's not really how it happened, though, Your Honor. She didn't just decide to leave. She's been there all 4 times. She appeared 4 times before when she was asked to appear. Every one of those 4 times she appeared. And it happened that she had a family reunion in Germany. And so she had asked that I seek any continuance if it got reset in October, which is what I'm doing. So I apologize to the court if I've acted unethically in some way towards the court, but these are the facts that I'm dealing with.
I've not suggested that, and I've not heard anybody else ever suggest that of you, counsel. Give me just a second, please. More good news for you is you will not be reached on the 17th. I'm certain of that, but I'm denying the continuance.
May we be excused, Your Honor?
I beg your pardon?
I was asking if we could be excused.
Yes, ma'am, you may. Have a nice day. Number 22-02598, Anderson versus De La Garza.
This is Dan Martin, the lawyer for the plaintiff.
I'm sorry, whoever that is, I cannot hear you.
Well, let's see, you have technical problems.
Your Honor, can you hear me? This is Jennifer Covington, and I'm here
Ms.
with Dan
Covington,
Martin.
yes, I hear you. Yes, ma'am.
And this is Mr. Martins. He is plaintiff's counsel. Let me try and move the computer closer to him.
Your Honor, can you hear me now?
I just heard you, sir.
Good morning.
Good morning.
I've sought this continuance because I closed my law office in September of 2022. And this is, I closed it for medical reasons.
Okay.
And this is the last piece of litigation that I had on my docket that I haven't been able to find another lawyer to take it over. And my plaintiff and myself have been trying for the last year and a half to find a new counsel for her, but we have not been able to do that so far. And I'm bedridden.
Okay, I'm going to grant the motion for continuance. Tell me, do you want to withdraw from this case?
Well, I do, but I don't want to leave my client without representation.
Okay, well, it seems to me, I mean, if your law practice is closed for the reasons you identify, obviously you're not going to try this case. She's going to need to get herself a new lawyer. My experience is that people tend to move with a little bit more alacrity when there's some urgency. So what I'd like for you to do is to file a motion to withdraw. And set forth your reasons. We'll give her time to get a new lawyer, but also make her understand that she's going to have to do something with this case.
Okay.
Take care of yourself, sir. And Ms. Covington,
Thank you, Your Honor.
thank you for your assistance in getting this done.
Thank you, Your Honor. May we be Honor?
You all have a great day. Take
Thank
care.
you. Thank you.
Thank you, Judge.
So to answer the age-old question of what does it take to get a continuance? Family vacation in Germany? Attending Zoom court from your hospital bed? And there you have it, folks.
Your case, from my reading of the probable cause affidavits, this would be State of Kansas versus Christina Rivera. It's an unfollowed criminal case, 23 MR 344. Announced appearances.
May it please the court, the state of Kansas appears through Assistant Ellis County Attorney James Rutherford. Ms. Christina Rivera also appears pro se and by Zoom. Ashton Taylor, the alleged victim in this case, is also on.
Okay. Mr. Taylor, I don't know where you're at. Is that you up? Am I? Yeah.
Yes.
Do you have any objection to the lifting of the no contact order?
I do not. Like, he's fine coming back.
So Mr. Clayton at the bottom has nothing to do with this case at all. But I was developing a story in my head as I was watching this where he hit his snooze on his alarm a couple times, woke up and went, oh shit, I have court. So he opens up his phone and just, is waking up while he's walking around waiting for his court hearing. Because that's the only thing I could come up with is he's not completely awake on why he's walking around without a shirt and smoking a cigarette. Right?
Mr. Rutherford, do you have any objection to lifting it?
No objection, Your Honor.
I don't either.
Okay.
All right. I reviewed the affidavit. I think Ms. Rivera saved Mr. Taylor potentially from some unfortunate potential consequences. So my reading of it is, but Ms. Taylor or Ms. Rivera, I want to mention to you that, and I want to explain this. Under Kansas law, a battery is any offensive touching done in a rude, insolent, or angry manner without the consent of the other party. And under the law, police officers have no discretion. In the old days, police officers on the street had a lot of discretion as to what they could do in these kinds of situations, but now they do not. If there's any evidence of a potential battery, which is offensive touching, it can be, I've described it, it's as simple as this. If you get in a political argument with somebody and you're angry with them and you poke them in the chest to make a point, you've committed a battery under Kansas law. It doesn't require a slugging or a hitting. So while you may have been doing a very good thing on behalf of Mr. Taylor, the officers presented with the evidence I saw in the affidavit really had no discretion but to make a custodial arrest. That's the way it works. All right?
Yeah, I didn't know that. That's why I was wondering.
We discussed this briefly in a past stream, but we didn't really dig into it. there are certain states that have mandatory arrest laws as it relates to domestic violence. So I thought maybe let's look it up. And the American Bar Association actually has a chart that lists each state and what the rules are. It's a couple years old, so I highly suggest you look up your individual state's law before you poke someone that you are in a domestic relationship with in the chest. However, you need to define domestic relationship for your state because some people consider domestic relationship as someone that you're currently living with, someone you're related to by blood, or someone who you have previously lived with. There's lots of different terminology that can be applied to that, and it's not always just your significant other. So, the states that have mandatory arrest are Alaska, Colorado, Connecticut, District of Columbia, Iowa, Kansas, as he just said, Louisiana, Maine, Mississippi, Nevada, New Jersey, New York. Now, New York has a little different. An officer may arrest a person if there's probable cause to believe they committed the offense, but they shall arrest them when they've committed a felony against someone of the same household. So some of these states have things that are a little more specific. Ohio, Oregon, Rhode Island, South Carolina has a mandatory arrest when there's physical injury. If not, then it's up to the officer's discretion. South Dakota, Utah, Washington, and Wisconsin. The next group decided to get a little more in depth in their lawmaking. They mostly require probable cause. And in Arkansas, it's the preferred action. In California, arrest is encouraged where there's probable cause. And it's mandatory when claiming a violation of domestic violence protective order. I thought that would be, yeah. Massachusetts, arrest is preferred, but mandatory when there is probable cause to believe the person has violated the protective order. Montana, arrest is preferred when there is probable cause. It is mandatory when there is use of a weapon or violation of a restraining order. North Dakota, probable cause is required when the person is committing domestic violence. Tennessee, arrest is the preferred response. Mutual arrest is discretionary. So it's up to the officer's discretion in these other states, Alabama, Arizona, Delaware, Florida. Most people believe in Florida that arrest is mandatory because generally that's what happened. But the law actually reads the officer may arrest whenever the officer determines upon probable cause that an act of domestic violence has been committed. Mutual accusations must be evaluated separately, and mutual arrests are strongly discouraged. The policy of determination is of the primary aggressor. I thought that was a little interesting. Georgia, Hawaii, Idaho, Illinois, Indiana, Kentucky, Michigan, Minnesota, Missouri, Nebraska, New Hampshire, North Carolina, Oklahoma, Pennsylvania, Texas, Vermont, Virginia, West Virginia, and Wyoming. So if you live in one of those states and you have questions about what's going on, do a quick Google and it'll tell you the law in your state.
Okay, so that's kind of why they had to do that. And that's why we have these hearings today so that in review, we can then make an appropriate order. And so we're going to lift a no contact order today. Two, you can have as much contact as you want. Mr. Taylor, I think you owe Ms. Rivera possibly a thank you based on what I read, and good luck to both of you. Okay.
All right. Thank you, sir.
You're welcome. You can stay or go. This is a public hearing. It's up to you.
Okay. Thank you.
All right. Have a nice day.
Thank you.
Okay. Next, we have a little different circumstance. This would be State of Kansas versus Tyler Parker, unfiled criminal case, 23 MR 292. Mr. Rutherford appears for the state, and Tyler Parker's here. And I believe I'm looking at a ceiling, but I know now I'm looking at this could be Mr. Clayton Hullett. Is it pronounced Hullett?
Yes, Your Honor.
All right. Mr. Hullett, do you have any objection lifting no contact order between you and Mr. Parker?
No.
Okay. Mr. Rutherford.
Well, Your Honor, I'm sure you read the affidavit, and it seems, at least concerning the domestic battery with Mr. Parker, that this may have been somewhat mutual physical altercation. I believe, and Mr. Hullett can correct me if I'm wrong, that he was also arrested on charges.
So I don't know the relationship between these two, but say, for example, they were brothers and they got into a fight in the backyard. Brothers do that all the time, especially when they're teenagers, early 20s, whatever. If somebody calls the cops, even if neither of them want to press charges, neither of them want to go to jail, if they're in one of those states that's listed as a mandatory arrest, one of them is going to jail no matter what. So when things like that happen, you need to evaluate the situation. Is this something that happens all the time? It's not really a big deal. They're going to shake hands and be okay in 5 minutes. Think about that before you call the cops on little situations like that, but make sure you are calling the cops when it's like something important and vital and, you know, really needs to be handled.
That evening, I don't know if the no contact order has been lifted in that case or not. There might be reciprocal ones. But if both parties at this time want this one lifted, I have no objection. But for Mr. Holick's information, if that still is in place, he's going to need to get that lifted too.
Mr. Holick, do you know what the status is of your no contact order?
I called the state, or I called somebody, and I had them try to lift it, and they told me that I had this court hearing. So I'm here today on trying to get this no contact order lifted, just so I can see my brother again.
So Mr. Parker is your brother?
Yeah, we're non-biological brother, Your Honor. I've helped him through some really hardships.
Oh, okay.
So,
you mean brother in the close friend situation. Okay. All
correct.
Right. Okay. Well, what Mr. Rutherford pointed out is, Mr. Hollett, you were also arrested.
Correct, Your Honor.
This incident, and you have to file a separate request to lift that order.
Okay.
And you haven't done that. So we're going to lift it as to Mr. Parker, but the two of you still can't have any contact.
Okay. I will
you have to come to the court and file a written request.
Okay. I can do that today, Your Honor.
Okay. Now, Ms. Rutherford, do we want to have to reschedule him for a hearing? If he comes and files an order, do you have any objection to me lifting it if he actually shows up and does it?
No, Your Honor, that'd be fine.
Mr. Hollett, if you come to the court and you file the paperwork, they'll give me an order and I'll lift it at that time. But until that time, the order's still in effect. Understood?
Understood, Your Honor.
All right. So it's up to you to get here and get that filed. Now,
sorry to keep interrupting. They keep making important points that we don't usually talk about or think about. When there's a mutual arrest for domestic violence, there are mutual restraining orders put in place, and you can't just get one lifted. You have to get both of them lifted on both sides in order to resume contact with that other person.
Mr. Parker, I read the affidavit. There may be some far more serious charges against you arising out of this incident that occurred at the residence, from my reading of the affidavit. So I don't want you to get any misconception that somehow this whole thing is blown over and is gone. It can be far from that, okay? And that's up to the county attorney's office whether they file or not. But I can tell you that from what I read, if they file, you could be looking at least one, if not more, felonies. So you may want to contact the county attorney's office and visit with them. But as to Mr. Hullett, you can have contact with him. He can't have contact with you. And as soon as he files his motion, the two of you can have contact. Understood?
Yes, Your Honor.
All right. Mr. Rutherford, anything further from the state?
No, Your Honor.
All right. With that, we'll be adjourned, gentlemen.
I got one question, Your Honor.
Sure.
So the domestic battery that is against me, that's being dropped, correct?
No. We're dropping the condition of bond that you can't have contact with Mr. Parker.
Okay. So we
Just
still have
Mr. Parker's potential domestic battery charge against you is not dropped either. It just means that is a bond condition as part of your arrest. That's being lifted.
Okay.
But
so
charges could still be filed. That's up to the county attorney's office.
Okay. So okay.
Your Honor, I have a question too.
Sure.
I filed a motion so I can try to get this no contact order. That's why I have this paper right here for everything for this court hearing today.
Yeah.
Okay. I just wanted to verify that.
And I lifted it.
Okay. I appreciate that.
But Mr. Hullett has a no contact with you from his arrest, and he did not file the paperwork, and that order is still in effect. If he comes to the courthouse today and files the paperwork, I'll lift it based on the conversation today. But until he does that, it's still in effect.
Okay, I got you.
But it's not as to you. You can contact Mr. Hullett, but if he contacts you and the police find out, they could arrest Mr. Hullett because he still has an order.
Okay, that makes sense.
Okay, very good. But if he gets up here to the courthouse and gets the motion filed, it'll be taken care of today.
Okay, thank you, Your Honor.
But like I said, that doesn't mean that there's going to be no criminal charges out of this.
Yeah.
Okay. The county attorney can still file a criminal charge. This just lifts the no contact condition of the bond.
Okay.
Okay, very good. Good luck to both of you.
Court calls the case, People versus Leon Freeman.
Nimish Ganatra, First Assistant Prosecuting Attorney for the people.
Good afternoon, Your Honor. Michael Vincent on behalf of Leon Freeman, who is in my conference room. Mr. Freeman, state your name for the judge. My name is Leon Freeman.
Okay, hello. All right, what are we doing?
Your Honor, we just got some discovery on this case. Is this the zip drive one?
No, it is not.
No, but we just got into the case and I need more time. Just simply adjourn the PCC and maybe Mr. Ganatra and I can have another telephone call.
Okay,
Mr.
probable
Ganatra,
cause conference.
Your Honor, no
October
objection.
26th. Did I say this last one's for what day? 19th, I think so. Drummer. Okay, I'm gonna set this one for the 26th, 2023, 9 a.m. Or as your Zoom invite indicates, bond in this matter will continue. All right,
thank you.
Thank you. Court calls the case, People versus Marvin Holland.
Alec Chabalowski for the people.
Good afternoon, Your Honor. Michael Vincent on behalf of Mr. Holland, who is sitting next to me in my conference room. Mr. Holland, state your name for the judge.
Marvin Holland.
Right, what are we doing on these cases?
Your Honor, we just were informed that there's a zip drive and
Your Honor, we just need to drop off a zip drive to have evidence copied on that. So if we could just get an adjournment of the PCC, that would be appreciated.
All right.
in Your Honor, full confession, I don't know what a zip drive is.
I know, Mr. Vincent. Mr. Vincent, you don't understand what you look like on camera. I knew you had no clue what you were talking about. From the previous case, when you said, is this the one about the zip drive? And then when you got here, this one was all something about the zip drive. And you're like, no, you say something because I don't.
Exactly.
Since not everyone's old like me, let me give you a quick lesson in the history of technology. While Mr. Vincent's most likely talking about what we commonly refer to today as a flash drive, thumb drive, USB drive, the term zip drive actually comes from something that was widely used in businesses and especially for attorneys and things like that to store large amounts of data. It looked like an oversized disk drive, which most of you don't know what that is either, but take my word for it, it's what we had to use to store things back in the day. It came out in around 1994 and the capacity was 100 megabytes. To put that into perspective, most pics stored on your phone right now are around 5 megabytes, so you could put about 20 on there. But back then, documents were very small and attorneys could put loads of paper scanned documents onto the zip drive. But then, 6 years later, the USB flash drive came out, and that was a huge revelation because you didn't have to carry around this huge disk, a bunch of disks, and also you didn't have to have the reader for it. When it first came out, the USB flash drive was $30 for 128 megabytes. Slightly bigger than what we were looking at before, which to compare to today, you can get 1 terabyte for $30. Technology is great.
Exactly.
Probable cause conference will be adjourned October 26, 2023, 9 a.m. Or as your Zoom invite indicates, bond will continue. Thank you.
Thank you, Your Honor.
All right. Mr. Drummer's cases. All right, court does recall the cases of the People versus Drummer.
Nimish Ganatra for the people.
Michael Vincent for Mr. Drummer. Your Honor, we on these two cases, we should go ahead with the prelim exam.
You want the prelims? Okay.
Two cases we have are over 4 years old. This apparently is a relatively new case.
So, Your Honor,
All right.
I'm gonna ask the court to reconsider his bond. These are
Okay.
4-year-old cases, and he's alleged to have committed a new delivery of cocaine in the city of Ann Arbor on May 14th of this year.
Mr. Vincent, any response?
I know nothing about whatever the police have other than what I've been told right now. And these two cases are over 4.5 years old. If Mr. Ganatra wants to address bond, my client shows up all the time. The Ann Arbor police hasn't signed the warrant yet, but I'm operating blind with the accusation, Your Honor. I don't know if this is another true narc test or it's a test by the Michigan State Police Crime Lab. I'm in unknown territory. But if Mr. Ganatra thinks it's best that we adjourn all this, so as not to get into a bond argument, I would have to go along with him.
You don't have to go along with him. I mean, I don't know. I mean, he's asking me to reconsider his bond because there's a new case that is pending.
Yes. Not authorized.
Your Honor, Mr. Vincent, usually we talk before court. This is one of the few times that it didn't happen. But I can't go into court without sharing this information because it's meaningful for the court to know what individuals that are under your supervision are up to. Yeah. And Mr. Vincent needs to know and take stock of all the charges that our office are bringing against his client. Yeah. So if he wants to adjourn it, that's fine with me. If he wants to set it for exam, I'll make sure that I get the officers there. But I think we shouldn't ignore this fact.
Mr. Ganatra, I understand. I agree with you. Let's adjourn the prelim exam and let you and I talk on the phone.
Your Honor, I would ask at a minimum that perhaps community corrections step up testing for him. I know that they've had progress reports, but I just want to make sure that if he's around drugs, that we're notified of this.
Okay.
And it's not so much the use, right? Because the allegations are delivery. It's not the use.
And right now, as I see it, I see him on standard testing on this.
I don't think there's been a single violation that I'm aware of.
Well, I don't think you wanted to say that. Because in July there was, but he's been proceeding through negative, but every once in a while is popping in with in September he was positive for THC and then went back to being negative. So it's not as though he doesn't have any violations.
Where were some reports that I know? Your Honor, we never got a report on that.
Okay, I understand that, but I'm telling you that September 26th, there's a report that indicates that he was from August 1st through the end of August, he was negative, but then September 6th, September 12th, he tested positive for THC. And then he went back on September 21st, September 25th to being negative again on his testing. So here's what I'm going to do so that the other case, if they get it torn out in time, they can catch it up. You guys can decide what you want to do. I'll adjourn the probable cause conference in this matter as opposed to set it for preliminary examination at the request of both parties. I will set preliminary examination for October 9th, or probable cause for October 19th, 2023 at 9 a.m. We could send a note that Mr. Drummer's new case comes through. They could set it for that day.
Mr. Ganatra, I will be calling you.
And then
this
I will
afternoon
have
or
defendant
tomorrow.
bond at this time continue. However, in both cases, I'm going to be increasing his frequency to intermediate day reporting. Mr. Vincent, I'll take a look at that if necessary at the next hearing to see if it should continue once you at least have a handle on the report and we can see exactly how he's done with testing between now and then. All right, but I'm going to step it up at this time. Okay.
We'll step up so I can tell my client what he has to do.
Well, he'll have more frequency of testing because he's gone from a standard level to an intermediate level of supervision at community corrections.
He understands. So be called more often.
Yes. All right. Thank you. Court calls the case, People versus Aaron Porter.
Caitlin Kirby on behalf of the people.
Good morning, Your Honor. Michael Vincent on behalf of Aaron Porter. Mr. Porter, check in, state your name for the judge.
This is Aaron Porter.
All right, very good. All right, we have him there. Okay, what are we doing?
Your Honor, I would like another adjourned pretrial. Hopefully we'll be able to work something out with the prosecutor's office, whoever is going to take over this case.
We have a couple of problems. I don't mind giving you the adjournment. However, Mr. Porter has a bond violation.
That is correct, Your Honor.
There are a number of missed tests, but outside of his missed test on the 2nd, he tested positive for alcohol and didn't do his retest. What does he want to do?
Beg for mercy.
Pardon?
Beg for mercy. Mr. Porter.
Does he admit to the violation? Because he initially indicates to community corrections he didn't consume alcohol.
He has informed me, Your Honor, that just prior to the test, apparently he used Listerine. Now, if the Listerine was
okay, all right. So how much Listerine did he use? Before Mr. Vincent, you go ahead with this argument. He was a 0.14.
This was a fun little rabbit hole. I found dozens of websites like this one from affordablerapidtesting.com that says that your blood alcohol can read up to 0.75 immediately after using mouthwash products such as Listerine. Interestingly, though, all of the websites that were saying that Listerine and other mouthwash products will affect your blood alcohol test were all from attorneys and testing sites. When you go to look for the regular sites, any kind of credible medical sites or anything like that, all of those, like this study that I found on the National Institute of Health site, says that any kind of increase in your blood alcohol level caused by mouthwash dissipates almost immediately. So if you do a follow-up test, it would be negative. Within 30 minutes, it's out of your system. So all he had to do was take a second test if he was in fact positive for mouthwash.
I have the report in front of me, Your Honor.
Yeah, I know. That's a lot of Listerine.
Well, if I may respond briefly.
Okay, go for it. I'm anticipating. I'm sitting here in breathless anticipation.
I'll go fast then.
Okay, go for it.
When I went to breathalyzer school, one of the things I was trained to do is wait. If somebody had alcohol in their mouth, wait 15 minutes before you test. Why? Because even though the alcohol may have been swallowed, it'll still be in his mouth, which will give you a high, sometimes a very high breathalyzer reading. The only explanation I can give this court is that he must have washed his mouth off with Listerine and then immediately did the test.
I did some math. He tested at 7 p.m. Excuse me. He had the times just really don't add up as far as elimination, because on 12:50, he tested 0, and you lose 0.015 an hour. If that 0.14 was accurate, he should have been at 0.06 at that time, assuming a 0.015 elimination rate, which everyone has the same elimination rate. So that is my argument. I'm going to talk with my client.
Does he want a hearing?
I think, what do I think?
Hold it, Mr. Vincent. I'll have a hearing on it, but he tested positive and then missed this next 6 retests.
And Your Honor, regardless of the elimination rates, I appreciate Mr. Vincent's argument, but Mr. Porter signed a form that every person who gets a sober link signs at community corrections. They initial their initials next to each line. One of the lines, I think it's line 4 or 5, says that you may not consume anything with alcohol in it, and that includes NyQuil and Listerine. So regardless, it's a violation, even if it was a 0.01. So if he's sticking to the Listerine story, it's still a violation.
That's also true.
Your Honor, could we try a scram tether on him? And I will sit down.
Violation?
Yeah, and I will. Well, he clearly violated the don't drink Listerine, don't use Listerine. I mean, that's clear. I would like for him, he works as a medical assistant at U of M. I'm familiar with the procedure at U of M. If they think you got any kind of substance in you that you shouldn't have, they'll send security up there. You'll be checked out.
Right now he's using a SoberLink device, which looks like this. It's kind of a portable breathalyzer machine that connects wirelessly to send the data back to the monitoring company. And what they're trying to switch him to is a scram tether, which is pretty much like what we see, the normal ankle monitor that is actually continuously testing his blood through his perspiration to determine if he has any alcohol consumption.
Perhaps a scram tether would work better on him, and I will have him in my office, and I will enunciate, stay the hell away from Listerine and NyQuil and all the other stuff.
So I'll indicate in here that the defendant admits to a violation. Defendant is to be switched to a scram tether. He must report within 24 hours of today to be fitted with that. I'll then adjourn this matter to October 18th, 2023, 9 a.m. I should also place on the record that the defendant was also given the opportunity to come in and submit to an ETG test, and he did not do so.
Mr. Porter, get yourself in to see me as soon as possible. You have no idea how close you came to spending several days in the Washington County Jail. Come in to see me as soon as possible. Thank you, Your Honor.
Thank you. Court does call the case of the people versus Stephanie Julian.
Caitlin Kirby on behalf of the people.
What do I need to do? Can you guys hear me?
Yes.
Yes, I can hear you, ma'am.
Okay.
The believe this is a public defender case, is it not, or did we
It's
not
an arraignment,
adjourn?
Your Honor.
Right, we adjourned it for, okay. All right, Ms. Julian?
Yes.
All right, you are before the court on a 2-count complaint that alleges that on or about January 24th, 2023, at the location of 2736 Meadow Hills Drive in Pittsfield Township, Washtenaw County, state of Michigan, count 1 alleges that you did commit the offense of larceny less than $200. Do you understand the nature of that charge, ma'am?
Yes. But I
That
didn't
is a
steal any,
misdemeanor.
that was mine.
Hold on. I don't want you saying anything about the offense. I just need you to understand what you're charged with. Do you understand what you're charged with, ma'am?
Yes.
That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $500, then that would become the maximum fine. You understand that, ma'am?
Yes.
Count 2 on that complaint, that it alleges that at that same time and at that same location, that you did commit the offense of malicious destruction of personal property less than $200. You understand that charge, ma'am?
Yes.
That is also a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would, or property destroyed, that would become the maximum fine. You understand that, ma'am?
Yes.
All right. The first question that I have for you, ma'am, is do you wish to be represented by an attorney?
No. Can I ask you a question real quick? Was I supposed to swear?
Well, what are you going to ask me, ma'am?
Oh, no, I thought I had to swear in before you started. That's all I'm asking.
No, you don't have to swear in.
Okay.
All right. You don't want to be represented by an attorney, ma'am?
No.
Okay. What do you intend upon doing in this case?
What do you mean?
Pardon?
I'm gonna take what I got. I mean, the thing on his porch was not his.
Hold on, ma'am. I'm going to stop you.
Okay.
Right to be you. Anything you say to me or say at this proceeding can be used against you in this offense.
Okay.
And so I don't want you saying anything that might prejudice your case or any defenses you have. You understand that, ma'am?
Yes, I do.
All right. Now, ma'am, I'm going to ask you again, do you want to be represented by an attorney to, at least to help get you through this process, explain the process to you?
No.
Okay, so then, ma'am, what are you going to do on this case?
I'm gonna tell you what happened because
No, you're all right. That's not how the process works. All right. Are you telling me you want to plead guilty to these offenses?
I mean, the thing is, it's not.
Well, hold on. I don't want you saying anything about it. I asked a question. Do you want to plead guilty to these offenses? Is that what you're telling me?
Yes, I did. He has it on camera. Yes.
What? Okay. Ma'am, I get the sense that you don't understand exactly what you're doing.
No, I don't.
All right. So if you don't understand what you're doing, why wouldn't you want an attorney to help you through this?
Well,
To
okay.
explain all the process, go through and make sure all of your rights are protected. Why would you not want that to happen?
Okay, then I will.
Okay, so I'll ask you again. Do you wish to be represented by an attorney on this case?
Yes.
Thank you. This is a public defender case.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Julian. We will waive any further reading, stand mute to those charges, and we'd request another pretrial date.
Okay, I'm confused. Why?
Okay, hold on, Miss Julian. Just hold on a moment, okay? We'll get you through some of that confusion. Defendant having waived formal reading, standing mute, court will enter a not guilty plea on her behalf at this time. I will because I think there's going to be some extensive explanation. Pretrial in this matter will be adjourned then to November 1st, 2023 at 9 a.m. All right.
Can I ask a question?
Go ahead,
I'm
ma'am.
asking if I can. Is David or the cop here?
Okay, they would not be required to be here at this time, ma'am.
Well, the paperwork that I had said that it
Miss-
would be dropped if neither one of them showed up.
Miss Julian, I'll
Okay,
give you
okay.
a call and explain everything to you
Okay.
after today.
Okay, you got my number and everything?
Bond will be set in the amount of a $5,000 personal recognizance bond. I'm going to order standard conditions, including no assaultive behavior or possession of any weapons or firearms. There's to be no use of alcohol, recreational marijuana, or any illegal drug. I'm going to also order, okay, I almost hate to ask, but I have to ask. Who is David Julian?
He's my brother.
Okay. At this time, do you need to have or think that you need to have contact with David?
No, we've tried and his wife tells him he can't talk to me.
Okay, so here's what I'm gonna do, ma'am. I'm gonna indicate there's to be no contact with David Julian.
Okay.
Okay. And the Meadow Hills Drive address, is that his address?
I'm assuming he moved there a couple of years ago. I don't,
Okay, all
It's
right, so I'm just gonna indicate there's you're not to go to the 2736 Meadow Hills Drive, okay?
mhm.
All right. Anything else, counsel?
Nothing further, Your Honor. Thank you.
All righty, thank you. Miss Julian, make sure to talk to your attorney. It'll all become clearer for you, okay?
Yep.
Okay, thank you, ma'am.
Thank you.
I need Mr. Lawson's file, please.
All right, anyone else? So before I turn it over to the state, I'm going to tell you all two stories and both of them are true. So the first one, I know that jury duty is a hassle. I always tell people jury duty is an inconvenience, and I'll explain to you why I say it's an inconvenience. Your country only asks two things of you. One, pay taxes, and two, report to jury duty. And I say it's an inconvenience because you have to come downtown for jury duty. There are so many one-ways that somebody who designed the city thinks that one-ways will make traffic go quicker, and it doesn't. It just gets everybody frustrated when you're coming downtown for the first time because you're saying, the building's right there. If I could turn right, and then we got construction, and then you have to pay for parking, and you're probably saying, I'm doing a service by coming down for jury duty. Why am I being made to pay for parking? I don't write the rules, so I'm not in charge of why you have to pay for parking. But I will tell you, it's an inconvenience. We cannot have jury trials unless we have jurors. There does no good to complain about the television about why did they do this or why did they do that if you're not a part of the process. My mother and my family grew up in this small town in Louisiana called Grand Cane, Louisiana. Population in its heyday, maybe 2,400 people, possibly. So all the teachers knew everybody. My uncle, extremely intelligent, and my mom would always say how intelligent he was. And the teachers knew them, and the teachers knew all their students. So with my uncle, he kept getting passed up a grade because he was so intelligent. I remember when computers were coming out, he knew everything there was to know about a computer, and people were always trying to hire him. So lo and behold, my uncle is going through school at rapid pace because he's super intelligent. Then his sisters and his brother come in behind him, and the teachers are saying, you all had better show us something because your brother is super intelligent and we're expecting this from you all too. So of course, that made it difficult on his siblings. So my uncle graduates from high school. The Vietnam War starts. My uncle goes to my grandmother and he says, there's nothing for me here in Grand Cane. The way the society is, I'm not going to be able to get to do things that I want to do. So I want to sign up and just go ahead and go to Vietnam because they're drafting all of the boys here anyway. So my grandmother had to sign for him and she signed for him. So imagine that's her firstborn child. It's not like you have today where you have a computer and you can sit down at your computer and send emails to each other. It's not where you can pick up the phone and call, because during their time frame, when you wanted to make a phone call, you picked up the phone, the operator picked it up, and you gave them the 4 numbers that you wanted to connect to. It wasn't a situation where you have stations that are on TV 24 hours. They had 3 stations, NBC, ABC, and CBS. And NBC, it was pretty dicey on whether you were going to get that to work or not, because you have the rabbit ears, right? And then your programming would shut off, and then, you know, they play the national anthem. I know some of the young people are like, what did you guys do when the TV went off? It just went off. Everybody goes to bed. So if you can imagine her sending her underage child off to Vietnam, nobody really knew where Vietnam was. And you're sending them off. You don't know when they're going to arrive because you're getting the snail mail. Then you got to figure out where you're supposed to write to deliver their mail. And then you don't know if they're going to come back home or not. You realize they've been sent to Vietnam, and you learn months later, 6 months. My grandmother would always say, it was 6 to 8 months before I knew, yes, he's in Vietnam. And then you're trying to send letters there. And you only got a letter from Vietnam because, you know, the higher ups make you write a letter to your parent to say, I've arrived safely. That's all they know. And then you're waiting to get letters back, and it's months and months before you get letters. So you don't know if your child is all right or not. So that's a sacrifice. That's why I say jury duty is an inconvenience. And sometimes we forget the true definition of sacrifice and the true definition of inconvenience. Just so you know, my uncle made it back from Vietnam. He has since passed. We miss him dearly. But I always tell that story so people can realize that in the big scheme of things, this is all an inconvenience.
Thank you. You have to take your hands out your pocket. Hands out your pocket. Thank you. All right, where are we on this?
The balance that's owed on this case is $3,997. I contacted Ms. Brown. Ms. Brownlick received a call from Alicia at SOS on Friday, September 29th. I spoke to Kara, the supervisor at SOS, yesterday. They are committed to paying $3,000. But, and I, you know, they're going to pay it. So it's not a matter of, oh, when they get to them, they'll pay it. They'll pay it, provided we resolve the other $997. Ms. Brown.
Go ahead.
I went to Ms. Brownlick and I made the suggestion that because they don't have much money, and if we don't get this resolved, they may pass him over and give the money to someone else. So what I suggested was waiving the $997 in exchange for him dismissing the counterclaim, which we believe is meritless anyway. So I prepared a conditional dismissal that says balance 3997, SOS to pay $3,000 by the end of October. Upon receipt of the $3,000, we'll waive the $997, and meaning that his balance going into November will be zero. And we asked that the counterclaim be dismissed. He wanted to talk to the court.
Sir.
I believe that the amount is in error because I owe $460 for I think it's July and August and September. And it can come anywhere near, my rent was around $800, originally advertised at $800. So that would have been $2,800, not $3,900. I have no idea where they got that, how they added that up. And I think that's an error.
Because you haven't made a payment since July. So we've added August, September, and October onto that balance.
$800 a month.
Right.
So how does that, $460 for July, and then $800 for 3 months only makes $2,800.
So my client has an accounting. I don't even know why we're talking about this because we're agreeing to zero his account out. I have an accounting that goes back to February. It has every charge, which his rent was $800 in February, $850 from March till now. It has late fees for every month from June till now. It has $30 in water bills every month. And then it applies all of his payments. It adds the court costs on of $217. It totals to all the charges. And then you subtract the payments he's made. And in fact, they've given him $500 of rent credits. And the difference is $39.97. I'm more than happy to give this to him. But again, we're talking about doing this in a way that gets this done so that SLS does not give his money to somebody else. We can get this done and we're done. He doesn't owe us.
Sir, have you looked at that?
I have looked at it. I understand what they're talking about. Originally, in the first 6 months, I paid $800 and there was no additional water fee. And
Okay, but sir,
and also it doesn't take any consideration into the fact that the electric was for the hallways is being billed in my name. As soon as I mentioned that, then all the other charges came up.
okay, so what would you like me to do?
I'm interested, I'm going to have to move soon and I have very little money. When I rented the apartment, I was on the street and he needed to rent an apartment because he was leaving town. I believe he took advantage of me. I got an apartment that was not in livable condition.
Okay, so you want to have a trial? You want to have a trial on this?
I would rather have the matter settled, but they're not coming anywhere near. I would need a letter saying that I paid all my bills because already I've been refused public housing because of the proceedings.
Well, but this gets you there, doesn't it? I mean, the conditional order dismissal gets you there to where everything's paid.
Well, yeah, I would like to have it paid. Yes.
Okay, so if it gets you there to where everything's paid so that you can get other housing and make the representation that all your bills are paid, why wouldn't we do what's being suggested here?
First of all, it doesn't take into consideration a number of things that were wrong with the apartment.
Okay,
Injustices
okay,
that have been done.
but it does.
What's that?
But it does. Because if they're ultimately waiving about $1,000, basically 1/4 of what they're claiming is owed, they seem to be taking that into account without including liability.
If for the first 6 months, everything was fine. He seemed to be very kind. Everything was working out. He gave me $500 off the rent because I had mentioned the cleaning and everything.
Okay, but sir, we're here now.
Yes.
So what do you want me to do?
I'm interested in, I believe I was unfairly treated from the very beginning.
Okay. So let's say that's true. I'm
Let's
interested
just,
in
I
getting,
mean, I'm not saying it is, but let's say that that's true.
I don't,
What do you want to come out of this?
I would like to get my deposit back, which I don't think that he will ever do.
That's not before the,
Yeah, I mean, but your security deposit is taken, that's separate and apart from what this action is. That's something different.
Uh-huh. I need the money from the security deposit to get a new place, but because I'm giving him trouble, he'll, not,
Sir, if you want to have a trial on this, you can, but it seems to me that what's being proposed here is a way to have your account zeroed out going into November. Okay. They're waiving basically a quarter of what they're claiming is owed. So that then that's so that, and then you have a zero balance going into November.
I agree that,
Okay, but here's the problem. If the agreement's not made, and it's what Mr. Fantera was indicating, it may be that then you get passed over with the funding.
I understand that.
You get passed over with the funding, and let's say we have a trial on this. And let's say the judgment comes out, let's say even in your favor, where I say you only owe 50% of it, so you owe $2,000. Do you have the 2,000 to pay it?
No, I don't.
Then what would end up happening is they would be issuing, there'd be a judgment. Then ultimately, they would file their order of eviction, and then you'd be put out on the street.
and also, Your Honor, there's a money judgment request in this case, so there would be a money judgment in that same amount.
Thank you, Mr. Chair.
I apologize.
I got it. And then you couldn't make the representation that you want to make to a future landlord that everything's paid in full because there's this judgment. So if that were the case, where does that get you? Plus, by the way, with that judgment, they then take your security deposit to pay off the judgment. So then you don't have that.
With this
You've
agreement,
got-
I can't get a security deposit. They'll agree to return the security deposit to me or part of it in advance.
because you're not out of the apartment.
You know, they had mentioned $3,900. And, you know, I was saying that I can't understand how he can go back and charge me.
Sir, the 3,900, of which they're only claiming 3,000. They're trying to wait, they found a way to have that paid. And I don't understand why you want to fight it. I'm trying to figure out what you're trying to get to.
What I'm saying is that I was grotesquely wronged by renting the apartment to me. And this, if I agree to this, it takes in no consideration at all of what the landlord has done to me.
It absolutely does.
What?
It absolutely does. Because it's taking into account $997.
I would be, if he would allow give me the 10 days in November.
10 days in November
would be at the official end of the lease.
When does the lease end now?
11/10/22.
Started 11/10.
Yeah, and it's
So
11/10 to
so it ends at the end of November. I mean, at the 10th of November?
The 10th of November. And
So the lease already ends.
what's that?
The lease already ends November 10th.
Yeah.
So what are you asking?
Well, he's saying that I would be paid up until November 1st. And then I would still owe for the 10 days in November. If he would allow me to stay until November 10th, then I would accept that.
So you want a waiver of the 10 days, 1/3 of a month's rent, basically.
Right.
May I? I think what I'm hearing, and I asked my client, some of these leases, even though the last 10 days, you still have to pay a full month's rent because that's not the case here. You would only have to pay 10 days worth of rent. So I think I actually brought a conditional dismissal, which I had Ms. Brownlick sign. And what it says is that SOS to pay $3,000 by October 31st upon receipt of $3,000. Plaintiff shall waive remaining $997, meaning that defendant's rent will be paid in full through October 31st. Counterclaim dismissed with prejudice. So I think if I cross off October 31st and I write in that he will be paid through November 10th, and then I put another line in that says defendant must vacate the property by November 10th and make those two changes and initial them, I think I'm now, and my clients approved this. We're not saying he's going to get a security deposit back because, of course, we haven't done the walkthrough to see the damages, but he will owe no rent as long as he's out by November 10th. So I think I'm giving you what you want.
I don't believe it's fair, but I would agree because.
What don't you believe is fair about this?
I said a few times, so I don't think that you understand the amount.
No, I understand. If you'd articulate it to me, I'm pretty good at understanding things. You
okay.
keep saying it's unfair. They're giving 1/4 of the rent in plus more now. And you think that that's not fair. So my only other option is to set it for trial, which the problem for you, sir, so that you understand, I'll set it for trial. If they sustain their claim and your counterclaims don't get anything, you're going to end up owing the 4,000 plus whatever. I mean, I don't get what's unfair about this.
I said I would agree to that, but I would need a letter saying, that's fine, I'm agreeing to it, but I would need a letter saying that all my bills from obligations to YC Asset Management were paid in full.
He can get a copy of this, which is, I think, pretty close to what it says.
I need that to show, when I go and try to rent a place.
I got it. And what you'll see is that once the conditional order of dismissal is there, that's going to be as good as showing that everything to them was paid.
When I go and apply for a place,
I understand.
I give the reference for the landlord where I was, I have to. And if they ever call them, he's not happy with me, so he's gonna,
I'll talk.
He's not happy with you, but can you put in there, landlord will give a neutral reference?
Sure.
All right, then we got it.
Okay.
So I'm going to make 3 changes. I want to talk this through before I write on this document. I'm going to change October 31st to November 10th.
Okay.
Number 2, I'm going to put a line in that says defendant must vacate property by on or before November 10th.
Okay.
And I'm going to say plaintiff to give defendant a neutral landlord reference.
Okay.
With those 3 changes, will you then sign?
And can I get something in writing, from them saying that I paid all my bills?
You're going to get this, which I think is probably what you want, because he's not going to lie and a neutral, I mean, he's not gonna tell them, oh, you paid your rent every month. This will show that you have no balance. That's the best you're gonna get.
But this also shows that there was a court proceeding.
But they're gonna know that anyway. They're gonna go online and see that there's a court proceeding online. There's nothing, you can't undo that. He's gonna give you a neutral reference, means if he can't say something good, he's not gonna say anything at all. That's the best you're gonna get. And that's a lot better than having a trial which has a judgment against you, because then all their judgments are just gonna pop up.
Okay.
If I make those changes, will you sign this?
Yeah.
Okay, what this says now, and actually I'm gonna put, above in line 2 where it says through the time period ending, right now it says October 31st. I'm gonna change that to 11/10 also, because he will now be paid through the period ending November 10th. So what this says, Mr. McNulty, and I've initialed this, is SOS to pay $3,000 by October 31st. Upon receipt of the $3,000, plaintiff shall waive the remaining $997, meaning that defendant's rent will be paid in full through 11/10/23. Counterclaim dismissed with prejudice. Defendant to vacate premises by November 10th, 2023. Plaintiff to give defendant a neutral landlord reference. And I'm going to ask you to sign right here. I should ask them to initial the paragraphs where I made the change also. So, Mr. McNulty, would you initial right here, please, and right here, where I made the handwritten changes, please? And then down there.
I have before me the conditional order of dismissal. So you have any other questions regarding this? Got it now?
No.
I will advise you, this is a consent judgment or consent order. You do have 3 business days to think about it. If in those 3 days you have some legal confusion or some legal right you did not believe that you asserted, you would have to file a motion with the court within that time frame. I will, however, indicate to you, you can file the motion. That doesn't mean that I would set the consent.
How long is that?
You have 3 business days to do that. But you can file that motion, but I'm going to tell you, that doesn't mean that I will set it aside.
Yeah.
You understand that? All right. Thank you.
May I say something?
If you must.
No, we're good.
Thank you. Thank you.
I've got a fun one for you today, thanks to my friend Saul Goodman. Judge Webster is facing a similar situation that Judge Simpson faced not too long ago. A grandmother wants to evict the granddaughter out of one of her properties, but she doesn't want to evict the mother and the other children that are staying there. Can she do this? It gets interesting.
All right, we are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas, case number 2023 LM78. Christopher Hamrick versus Denisha Pogue. Denisha Pogue. Am I by chance getting either one of those names right?
Denisha Pogue.
Okay, Denisha Pogue. That's what I was trying to say, but it wasn't coming out very well. This matter comes on for hearing on a petition for eviction. Mr. Hamrick, in his petition, alleges that he is owner of a certain property in Madison, Greenwood County, Kansas, that it has been rented to the defendant, Ms. Pogue, on a month-to-month basis, starting March 26, 2023. In a concise statement, Mr. Hamrick, what is the basis of your action to evict Ms. Pogue from this property?
Your Honor, first I want to say that I'm not the owner. I'm actually the property manager. My mom owns the property.
All right. Let me see,
And
let me see if that's what your petition alleges.
okay.
Says you're the owner, plaintiff, and the only plaintiff shown is Christopher Hemrick is the owner, or the agent of the property. That works. Go ahead.
Correct. And the basis is on, there was a 30-day notice given on August 6th, 2023 to terminate the month-to-month lease. And as of September 6th, Ms. Pogue was still at the property.
Okay, so you said the 30-day notice was given August 26th, the 23.
August 6th.
Oh,
Yeah.
August 6th.
Correct.
August 6th, the 23 30-day notice. What was the reason for giving this notice?
To terminate the month-to-month lease.
Was she behind or in violation or?
No, there was no payment per month.
Okay, so she did not pay.
Just to get possession of the property.
And how much was she to pay each month? Oh, okay. Okay, I think I've got it. So she was allowed to live there without payment?
Correct.
And then you decided you wanted her out of the property. Was this a relationship that ended or what happened here?
Well, no, her and her mom said that they would be gone August 1st. And they were still in the property August 6th. So a 30-day notice was given. And this was told to my mother.
All right, so your mother owns the property on 2nd Street in Madison. You are an agent for her concerning this property.
Correct.
It says in paragraph 2 of your petition that there was a rental agreement entered into on March 26, 2023. Is that correct?
That is when she occupied the property.
All right, so she really wasn't renting it. She was staying there just,
Correct.
okay, just staying there, no rental agreement. All right, so we'll clarify number 1, that you are here as an agent. And number 2, we'll clarify that there was not a rental agreement as alleged, that she and her mother moved into the property with your permission without expectation of rent on March 26, 2023, right?
Correct.
Okay. So what happened that made you decide you wanted her out of the property? I mean, when she went in, was it open-ended? She could just stay there as long as she wanted, or were there terms on it?
No, Your Honor. According to my mother, the terms were they were leaving August 1st, 2023.
Well, why did your mother not bring this action? Why is your mother not here?
My mother lives in Maryland.
Okay. So say that again. They were supposed to be out by when?
My mother asked when they would be out, and they said August 1st, 2023.
Are these folks friends of your mom's?
Well, her mom and myself were married.
Okay, so Denisha's mom and you were married.
Correct.
Okay, and now you're not married?
We're legally separated.
Okay. And so when your relationship ended, you and your mom decided maybe they ought to find some other place to live?
Well, no, they stayed. Our relationship ended, and we actually signed the separation agreement April 2022. They stayed until August 2022, and they left, and then they came back in September 2022. They left again in January 2023 and came back in March 2023.
But they had permission to come back in March of 2023.
Correct. That was between them and my mother, though.
Okay. So right now, other than just the goodness of your mother's heart, they have no legal reason to be there. Is that
Correct.
correct? Okay.
Correct. Yeah. Well, we were trying to help. Every time they came back, it was because they needed assistance. So we were trying to help, but I mean, the help has gone on for a year and a half now.
All right. Okay, so why did you not bring this action against Denisha Pogue's mother?
Well, my ex and our kids also live there. And so it is my desire and my hope that my kids can still stay there with their mom, but Denisha is an adult who also doesn't contribute. And it's my opinion and my mother's opinion that she should work or go to school or something, and that we should not take care of someone else's adult.
Okay, let's see if I've got this straight. What is Denisha's mother's name?
Marcia.
Marcia, and her last name?
Menifee.
Menifee. And you and Marcia Menifee have children together?
Yes, Your Honor.
And how many do you have?
2.
Okay, so you're not trying to evict Marcia Menifee and the 2 children you have with her. You're literally trying to evict only her adult daughter, Denisha Pogue, and she's apparently from another father, is that right?
Correct.
Okay, but she is 18 or older.
Yes, she's 20, Your Honor.
She doesn't contribute to the home, and so you're thinking get her out. Yeah, but would her mother not have, if she is legitimately in the home, would she not be entitled to have whoever she wants in there, or is it strictly do you have anything in writing?
No, Your Honor. I actually requested and encouraged her mother to sign a lease. I actually requested both of them to do that last year. They refused to sign a lease, and I told them that would be for their own benefit. They refused to sign a lease because neither my mother nor myself want them there just free. I mean, we can't keep just paying for their living forever. So, but no, they refused to sign the lease.
But in fact, you are just letting them live there for free, are you not?
This last go about them coming back in March was not my doing.
You had nothing to do with that.
No, that was my mother who called, I don't know how it happened, but they discussed them staying there. I was against it.
All right, well, I think I have an understanding now of what's going on and what you're asking for. So, Ms. Pogue, you're how old?
I'm 20.
You're 20, and are you a high school graduate?
Yes, ma'am.
Are you employed?
Not currently, no.
Have you ever been employed?
Yes.
Where did you work?
My last job, I worked for Chris.
Okay, for the plaintiff, Mr. Hamrick. And what kind of work did you do for him?
He had a at-home t-shirt business, and I designed shirts and pretty much ran the business on my own.
Apparently that didn't work out between the 2 of you.
He fired me. He didn't want me to continue working for him.
Okay.
And,
how long ago was that, Ms. Pogue?
I worked for him. He fired me on around April 23rd of 2021.
So you've been unemployed for about 2.5 years?
2022, I'm sorry.
All right, about 1.5 years you've been unemployed.
Yes, ma'am.
And you live with your mother?
Yes, ma'am.
Okay, and why are you not working?
Well, I'm doing at-home stuff, trying to get it started, and I've applied.
What are you trying to do?
Pretty much the same thing, just on my
own. Okay, so the reason you're not working is because you're trying to start a home business of your own, making t-shirt designs?
Yes, ma'am.
And how long have you been trying to do that?
For a few months now.
Do you offer any legal reason why I should not order you to be evicted from this residence?
Well, his mom gave us permission to stay here as long as we needed. We didn't agree to leaving on August the 1st. She said we could stay as long as we needed to.
She said you both could stay there.
Yes, ma'am.
Have you talked to her recently to see why we're in court if she gave you permission and she's the owner?
No, ma'am.
Do you believe she has asked Mr. Hamrick to bring this action and remove you from the property?
No, ma'am. He's evicted me. He's given me a 30-day notice once before. And that time she said she was unaware of him kicking me out. Because when we left the first time, he just was constantly harassing us, saying he didn't want us to be here. So we left and went to an Airbnb. And then he gave us permission and said we could move back. So we moved back in. And then I guess he didn't want us to be here again. So he gave me and my mom a 30-day notice. We left again. And then we were staying at an Airbnb. And we asked, could we rent it out? And he said no, which I have message proof of. Okay. And he said a lot of rude things. He said, no, we cannot move back. But his mom called and said that we could stay at the house for as long as we needed. Because it was ridiculous that he had 2 houses, 1 vacant, and we had nowhere to stay.
So what does your mom do for a living?
She's a stay-at-home mom.
She's a stay-at-home mom who supports her and the children.
She supports herself. Like,
how can she support herself staying at home watching the children full time? Does she have a job? Does she have money coming in to pay the bills? I mean, somebody's got to pay the electricity, the water, the food, the diapers. I don't know how old these kids are. How old are your siblings?
8 and 9.
Okay, so they're past diaper age. And they're half siblings to you, is that right?
Yes, ma'am.
Okay. But you don't know who pays her bills or who pays for you?
His mom was paying the bills.
She was sending money for you guys to get groceries and gasoline and things like that?
No, we already had, she had money saved up, and we do have a little bit of income to get groceries and things like that.
What kind of income do you have for that? Is that through state assistance or through Mr. Hamrick? Who gives you that money?
We do have assistance, like food assistance. And yeah.
Mr. Hamrick, do you know how these women and children are surviving? Who's paying their bills?
Yes, Your Honor, I pay them.
Okay. And is that part of your separation agreement that you?
No, Your Honor.
You just do it?
Yep.
There is a document in the court file entered 9/19. It's called an exhibit. It's a copy of it says 30-day notice to quit, terminate tenancy to Denisha Pogue from Sandra Hamrick. That's your mom?
Yes,
Mr.
yes, Your
Hamrick?
Honor.
It was a property description there in Madison. Giving notice that tenancy will be terminated, this says on the 5th of September, 2023. But it is not signed by her. It is signed by Christopher Hamrick, property manager. Okay. Well, this is an unusual situation where the property owner is not here, and I would say that if you verify that you were her property manager, that would not be a problem, other than you both attributed comments out of court declarations allegedly made by her that are in contradiction. Generally, out of court declarations by a party not present aren't even admissible. Neither of you objected when the others brought it up, but it leaves me with the problem of I don't know what the landowner's position is. So what I'm going to have to do is set this over so that you can get the landowner here, so she can speak for herself, so she can verify, one or the other of you, what you're saying here. But I don't want to set it over too far, because notice was given to be out on the 5th, or at least 6th, the next day, if not on the 5th. So let's see what, and she can't appear by Zoom. You said she's where in New York, Mr. Hamrick?
She's in Maryland, Your Honor.
Maryland, yes, Maryland. She can appear by Zoom. It's not a problem, as long as she and I can see and hear each other, and you all can too. So if you could have her, please, Mr. Hamrick, attend, that will help me make the right decision in this case.
Yes, Your Honor.
All right, Ms. Pogue, I trust you can be here as well?
Yes.
And Ms. Pogue, it might not hurt to have your mother here as well, since in case something comes up that we need. I'm not sure that we would need her, but it wouldn't hurt. Okay. Thank you all. I'll see you back here, absent something unforeseen, 10:10 at 9 o'clock our time.
Okay, thank you.
Good morning, Denasia.
Good morning.
Good morning.
All right.
Hi.
Good morning, Chris.
Hold on. Watch Dad shake his head when she says good morning. And doesn't Judge Webster look adorable with her little pink lipstick? Let's watch that again. Watch Dad. Stepdad, ex-dad, ex-stepdad.
Good morning, Denasia.
Good morning.
Good morning.
All right.
Hi.
Good morning, Chris.
We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 LM78, Christopher Hamrick versus Denasia Pogue. Please announce appearances, starting with the plaintiff.
Sandra Hamrick is here.
Chris Hamrick is here.
All right, and you two appear as plaintiffs, and then for defendant is?
Denasia Pogue.
Thank you. This case is a continuation of one that was started on September 28, 2023, an eviction case. And it was continued because the actual property owner was not here, and I was hearing conflicting opinions about her stance on this. Christopher Hamrick was here as property manager and son of Sandra Hamrick, property owner. He was saying that Ms. Hamrick was seeking an eviction of Ms. Pogue. Ms. Pogue being his former stepdaughter, his former wife, and 2 children still residing in the property. He's not seeking eviction of them, only Ms. Pogue. And Ms. Pogue, as I recall, you're about a 20-year-old, is that right?
Yes, Your Honor.
Okay, Mr. Hamrick said that you're not working, going to school, or contributing, and you said you're trying to start up a shirt business, some kind of shirt business that you learned the trade from Mr. Hamrick himself. And you were telling me, Ms. Pogue, at the last hearing that you had permission to be there, that Ms. Hamrick told you you and your mother and half siblings could stay in the house rent-free as long as they wanted. So Ms. Hamrick, Sandra Hamrick, I adjourned the hearing and said, I need you here. Apparently you are the owner of this property, is that correct?
Yes, I am.
Okay. And have I stated your relationship correctly with Chris Hamrick? You're his mother?
Yes, he's my son.
And have you given him permission to manage that property that is in question?
Yes, ma'am. Yes, Your Honor.
All right. Trying to get the call up the address of that property. I understand it is at is that correct?
Yes, Madison, Kansas.
All right.
66860. Mm-hmm.
Okay, and you allowed Miss Pogue's mother, Miss Pogue, and two of your grandchildren to stay on that property. All right, and Miss Pogue is half sister to those two grandchildren, is that right?
That is correct.
Okay, so the question for you, Miss Hamrick, is just pretty simple and straightforward. Are you wanting to evict Denisha Pogue, or have you given her unlimited rights to stay in your property, or somewhere in between those two positions?
Well, I am ready to evict because I've gave them her plenty of time from March to August to get herself together, either go to school or get a job, because I can't, continue to pay for her to stay there.
All right, so you are seeking eviction. All right, well, Ms. Pogue, I'll give you any last to say on this matter before I make a ruling.
Can I speak? My mom asked if she could speak.
Okay, now your mom is staying in the house rent-free with the two children she shares with Mr. Hamrick and you, is that right?
Yes, ma'am.
And Ms. Hamrick, you're not apparently seeking to evict anyone but Ms. Pogue out of that household, is that right?
At this time, yes.
All right, well, let's see. Let's talk to Ms. Pogue's mother that's there.
Hello, Your Honor.
Hello, and what is your name, please?
I'm Marcia.
What is it?
Marcia.
Marcia Pogue?
It's Hamrick, but I'm changing it back to Menifee, of course.
Okay, all right. So you were married to Mr. Hamrick or in a relationship with him, have two children. You have Denisha from a prior relationship. And you're staying rent-free, basically, as a somewhat of a guest of Miss Hamrick, is that right, since March?
Since the end of March, yes. Not necessarily rent-free, no. Miss Hamrick said help us out, and she did. And Chris Hamrick owed me some money, and he said that he would take that out of us staying here. So technically, we're not staying here rent-free. And the reason I have not put him on child support is because I said I would never do that. We staying here, I won't put him on child support. I won't go for alimony. I won't even get half of the stuff. I would just work on building up. My daughter's helping me because she helped with online. I'm working back on my licensing because I worked at the hospital in cardiology for 10 years before I met him. So we're not just staying here like rent-free, not doing anything. No, we're working. We're working on working because around here, we're 30 minutes from anything. So we have to apply for jobs. We're working online right now. We're trying to get back to the city so that we could get better access to jobs. So
when you say the city, what city do you mean?
We're planning on moving to Dallas.
Dallas, okay. And when do you plan to do that?
I'm sorry, I didn't know.
When do you plan to move to Dallas?
As soon as I get enough money to move to Dallas. We've been working on saving up because here, you know, inflation with everything. So it's going to take thousands of dollars to even get over there. And that is what the money that I was expecting from Chris Hamrick was going to help me get over there, the thousands of dollars to help me get over there. But since that was a setback, and he said, well, that's to pay for you guys staying there. So that's why we're here. And right now, without Denasia being here, that will be a disservice to me because I need the help. You know, she's the only one that's really helped me when it comes to like household things and helping me online business. So yeah, it seems like he's trying to move Denasia out the way so I can be dependent back up on, you know, him. But, you know, I'm working on it. You know, I just, it's like I've been taken out and put in the middle of the ocean and left there. So I'm working on building myself back up. I'm not trying to stay and live forever off him. I'm not trying to even get half of the things we had together. I wasn't trying to do any of those things. I wasn't trying to put him on child support. I said, okay, we're staying here. So, you know, because the child support will be more than what it is staying here, the child support alimony. So, you know, I said, okay, we'll do that. I won't put him on child support. I won't do any of those things. So, you know, until I get myself together. So that is why my daughter is here. And Ms. Hamrick said that she will help, and she did help, you know, so I'm not expecting her to pay anything else. It is his responsibility because he owed me my money, the thousands of dollars that he owed me. So, you know, at this point, you know, I have his 2 kids. I haven't put him on child support. I haven't took alimony. I haven't took half of the stuff we own together. So that's why I'm working on it. I'm not just sitting here doing anything. I am working on it. I'm working on my licensing right now, my EKG and telemetry to get back into cardiology and move to Dallas because they have better jobs there. I have looked at the jobs in Dallas and they have much better opportunities. We're in the middle of nowhere right now. So we have tried to apply for jobs, but they're few and far between. So, and we tried remote, you know, remote jobs aren't really, you know, hiring like that. So then my next best thing is a hospital job again, because I'm familiar with it.
All right, so what are your qualifications? You have some certification or degree or?
I have some certifications, EKG. I worked in cardiology in the hospital in Auburn, Alabama for over, you know, about 10 years. So.
And you gave that up to be with Mr. Hamrick in Kansas?
Well, it's a long story. We've been everywhere. In Kansas, I don't know anyone here either. And that's the thing too. Like I'm starting, you know, I don't know anyone. I'm in the middle of nowhere. So yes, we've moved around a lot. So when we were together.
I'm not sure that a lot of folks that agree you're in the middle of nowhere, although I think it's perspective. I can see compared to Dallas, it might be, but you are like what, half an hour or less from Eureka, and that's got some opportunities. There's a hospital. Emporia. You're in between Emporia and Eureka, right?
Yeah.
And Emporia is pretty fair size.
I'm Emporia, yes. And that's what we were filling out for the job applications at, yes. In Emporia.
All right, well, you folks certainly have a complicated relationship and present a unusual issue for the court today, because you're telling me that you need your daughter Denasia to help with the younger children and to help with the household while you do some kind of online business. What kind of business is that?
I'm starting by getting my licensing right now. I have to work on that. I'm working on that. And she's working on the online business with her art and doing, you know, because she did artwork for Chris, you know, and, you know, that's another story. But yeah, she did artwork for him. She's an artist, yes. And she does her art, you know, online.
And you say, well, you're not paying cash under a formal contract for rent. You've made some kind of rental agreement in lieu of child support and maintenance or alimony. Mr. Hamrick, what do you say about that?
I actually object to that, Your Honor. The money she's claiming that I owe her is from my tax return from working. I paid taxes and I got a tax return. She didn't work last year, so I'm not sure what tax refund she's expecting from not working. Also, we have a separation agreement, which she did receive half of all the cash. She received the car paid off, and she also As far as the tax return stuff goes, whoever benefited the most got to claim the children. I also pay for everything concerning the kids, and I still maintain the house. Ms. Pogue mentioned in the initial hearing that the house is vacant. It's not vacant. I was living there. So yeah, I object to those things.
Okay.
Can I say something, y'all?
Is it still your position that they are there as guests more than renters, or? I know you're going through an eviction process because that's what you need to do, but what is your official position, Mr. Hamrick, as manager of the property? And as you're tied into all of the defendant, to the defendant and her family. What's your final position on that? As it relates to eviction?
As far as the eviction goes, I would like to move forward. As far as Marcia goes being there, I was trying to just make sure that the kids had access to both of their parents. She never sent me any 30-day requests to move from the state or anything like that. So I'm trying to make sure that the kids maintain the same lifestyle that they're used to. It's a fairly large house with 4 bedrooms. So I would like to keep that same thing. I don't want them cooped up in some small studio like they were in before. So that's my thing. That's why we've been trying to, help, but it's, we've been helping for a year and a half. Also,
they had lived there before, as I recall.
yes, and they left the very first time. I didn't put them out. They left and moved to Kansas City. And then I don't know what happened with the money that she received, but it was gone in like 5 weeks. So I allowed them to come back. But there was no rent, no lease. And I actually tried to submit that into evidence, that whole conversation. But
well, I'm not stopping you from if you have evidence that you want to present, you're sure welcome to do that. I don't want you to think I'm stopping you from presenting evidence.
Okay, well, yeah, I actually emailed it to Judy yesterday, but I saw she was out of the office.
Judy,
but she asked for 2 months.
Someone else in the office. Go ahead.
Oh, it was someone else in the office? Hey, I didn't hear anything back. She just told me last week to email everything, so I emailed it to her yesterday. But Marcia asked for 2 months.
Go ahead. I'm sorry.
Yeah, she asked for 2 months. I allowed her to stay there for 3 months.
When you say she, who do you mean?
Marcia. This was last September. She came back and asked to stay for 2 months. That 2 months was supposed to be up in November. They ended up leaving January 6th. And then the next time they moved back in March, that was something between her and my mom because I didn't want them back in there. But I did learn that they were living in like a studio apartment. I don't want my kids living like that because they didn't enjoy it. That's what they told me. But, if it's going to be this back and forth, I don't want a toxic situation for our children. So that's why I wasn't seeking anything towards Marcia at this time.
All right. Well, did you hear Marcia say that Denisha is helping her maintain the household responsibilities and watch the children and things like that?
Yeah, I go to the house and I fix stuff and I go over there and I clean. So I don't go over there as much because the environment is hostile, and I don't want my kids to see that either. My hope is once Denisha's gone, it calms down and I'll maintain that. But yeah, most of everything in there is mine, except for their clothes. But yeah, I go over there and I maintain the property.
How old are these other 2 children that you have?
They're 8 and 9.
8 and 9. Okay. And they go to school there in Madison?
They're homeschooled.
Oh, they're homeschooled. Who homeschools them?
Marcia.
Okay. All right. You did file as evidence a 30-day notice. It's 30-day notice to quit, terminate tenancy to Denise Pogue. It says from Sandra Hamrick, but it is signed by Christopher's property manager. And that was dated August 6th, 2023. with notice to be out by September 5th of 2023. It is now October 10th of 2023. Ms. Hamrick, property owner, you've heard Ms. Marcia say that, Marcia's Hamrick say that she needs her daughter, her 20-year-old daughter, to help while she's trying to get back on her feet. Your response to that?
Well, Your Honor, in March, I did suggest Marcia to go back home, back to Madison. And once I told her I would help her out until she get herself together, because she said she wanted to go to Dallas, Texas. So I allowed her to stay there. By May, we spoke again, and I asked her when would she be able to leave the property, because I don't want to put anyone out in the cold or anything like that. So she said August. I said, okay, great. August will be a good time, for her to go to Dallas. So that was when I gave her to August to stay there. And now it's September. But Your Honor, the thing is, for me, my children, and I'm not really sort of comparing, but I did not allow my children to stay with me to 2021. After high school, my daughter went to Job Corps and Christopher went to Morehouse. I feel at some point a child needs to get out and find themselves of, what are you going to do in your life? And she has not, as far as I know, Denasia has not been working or going to school or anything like that. So I'm just concerned that what her future is going to look like.
Okay, well, it sounds like that's a parenting issue, and as you said, a difference of opinion. A lot of people would agree with you. A lot of people wouldn't. They'd agree with Miss Marcia's. But what I think I'm hearing is you want to evict the daughter, but not the mother, because you haven't taken any action to evict the mother. Is that right? Is that your position?
Well, for my grandkids' sake, no, not at this time, because I have been paying for the utilities, and Chris, as far as I know, has been paying the rent. And I also sent money to Marcia, but I don't know her status at this time. So I have been helping her. I don't know when she is going to decide to go to Dallas. So
you're not in any hurry to you're not in any hurry to move Marcia's and the other two grandchildren out. Is that right?
Yes, my grandchildren, yes.
All right. I lost part of the folks there. So we're going to have to take a break until we get them back. We'll take a brief recess and see if we come back. I don't know if they lost their connection. Well, obviously they lost their connection, but whether their phone went dead or something happened in Madison there. So we'll take a recess till we see if we get them. See if they had come back yet. I was going to ask my assistant, but I can hear her talking to someone on the line. I don't know if it is the defendant or not.
I have not heard from him, Judge.
Well, give them a few more minutes. We may just have to continue this, but I don't want to keep continuing it. That's not fair to anyone. Do we have an email where you can email them, Missy, and see what they're doing?
I can try.
All right. I would think between the two of them, they'd have at least one phone or internet connection, but maybe not.
I do pay for the internet there, Your Honor, so it should
There you
be
go.
fine.
There you
Yeah.
go. Now, do you live in Madison yourself, Mr. Hamrick?
Yes, that is my main address. It's just, you know.
Okay.
when
Well, I
the
was
envi-
just wondering if you've had any experience with the internet being unreliable.
No, it's excellent over there.
Well, that's what
It's
I
actually
thought.
better than where I am now. Yeah.
Yeah, I thought they had a very good service over there.
I got a hold of her by phone and she said her internet service went out.
Okay, so what is she going to do about it?
She said she could run. She said she could run to the library and see if she could get on there.
I presume that's only about a 5-minute drive or walk.
Yeah, it's like
I assume.
And I hope they both go, but at least the named defendant. Okay, well, we'll give them 5 more minutes in and see what happens. Thank you, folks, for your patience. All right, back on the record in Greenwood County 2023 LM78 Hamrick versus Pogue. All parties as before. Ms. Pogue, is your mother back with us?
No, ma'am.
She stayed at home?
Yes, ma'am. She's
Okay.
coming, but she had to get the kids.
Okay. Well, she was really here more as a witness because she was not named in the eviction action. I've asked a lot of detailed questions because I was trying to determine if there really was a landlord-tenant action as Marcia's Hamrick proposed. And if not, was she a guest along with Denise Pogue as the other Hamricks have suggested? And at this point, I think I've gotten plenty of information to help me determine whether we're looking at guests or tenants. Tenants certainly having different rights than guests in the home would have. There was no written contract, no rental agreement that I found offered in this case. And after a lengthy questioning period, I believe that's because Ms. Pogue and her mother are in Sandra Hamrick's property as guests, not tenants. It appears to this court that Sandra Hamrick is a good person concerned about her grandchildren and trying to help the mother of the grandchildren get on her feet. And that she took into consideration that Denisha Pogue was an adult daughter also without a home. And Sandra Hamrick offered them the use of this home for a period of time to, as she said, get on their feet. And she's been in, and Miss Macias and Hamrick and her daughter and children have been in and out of the house a couple of times over the years, or at least the last year, the most recent time being since March 2023, with the belief that they'd probably be out and on their way to Dallas with a new job by this time, but it didn't happen. So again, I find that Ms. Pogue and her half-siblings and mother are guests in this house. That Ms. Pogue is a 20-year-old adult who has no right to be in the house. She doesn't pay rent. She didn't sign a contract. Her mother says, well, she helps around the house and she helps care for the children, although Mr. Hamrick takes issue with that and says basically he's the one that keeps the house up and cleans the house and so forth. But with all of the evidence in at this time, I am finding, Ms. Pogue, that you are a guest and that you were given a 30-day notice to be out well before now, and you're not. So I do grant the eviction to you. It's still Ms. Hamrick's home being maintained and managed by her son, Chris Hamrick. They allow some of the guests to stay. And I think that is apparent that it's because it involves the children and grandchildren. Were it not for the familial relationship and concern for the kids, I suspect that Marcius wouldn't be in the house as a guest either. But really, my standing here is my authority here is based strictly on the petition against Denisha Pogue. And I find that she has no authority to be in the house. Ms. Pogue, I'm sorry, I do have to grant the eviction. And so that will be what I will do. I will grant that. Mr. Hamrick, how long do you want to give her to get to, I should say Mr. Hamrick or Ms. Hamrick, how long do you want to give her to get out? Or if you want it to be forthwith, you've given her certainly notice.
What do you suggest, Christopher?
A week, maybe.
All right, Mr. Polk, you have 1 week from today to secure another residence, and that will be the order of the court. Of course, you have 14 days to file an appeal, Ms. Polk. If you think I have ruled in error of Kansas eviction law, you can certainly file that. The notice with the clerk, and then the action would be with the Kansas Court of Appeals.
Okay, thank you.
You're welcome. Anything from anyone else?
No, Your Honor.
No,
All right, thank you all very much. We'll be in recess.
thank you.
You're welcome.
Today, my friends, I have for you a hot mess of traffic court crazy. Of course, in Allegan County with Judge Norbreck. And we start with Mr. But can I explain?
All right. This is a citation that was issued on September 16th of this year on 118th Avenue, Ganges Township, Allegan County, state of Michigan. This is a speeding citation on an actual 81 and a 55. You are here, Mr. Emery, on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation to the court as to how or why this happened, or three, you wish to contest this citation. In other words, to fight the ticket at what we call informal hearing. What were you looking to do?
It's either one or two. I'm not sure.
Well, let's go this way. What are you looking for the outcome of this to be?
I would like to not have. So it's my belief. I don't know how fast.
I'm sorry, like to not have what?
It's my belief. I don't know how fast I was actually going that evening. And so that's why I can't say for sure that I'm admitting to, like, I can't admit to 81. Like, I don't believe I was going the speed. I'm not sure of that. So if I may, I would like to have the opportunity to explain maybe a few minutes prior to the officer pulling me over and before we lead to the citation.
All right, well, essentially then we should probably just have a hearing. Go ahead and raise your right hands, gentlemen. Swear affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. Mr. Emery, it makes a lot more sense for me to start with the deputy. He's got the burden to establish to me why he issued you the citation in the first place. But then after that, we'll give you an opportunity to either ask questions or testify on your own behalf, all right?
Yes, sir, thank you.
And with that, deputy, if you want to pick up the narrative somewhere it makes sense, explain the issuing of this citation.
Yes, sir. So on the date in question, 9/16/2023, I was traveling eastbound on 118th near 66th Street. I saw a vehicle coming westbound just past 66 at a visibly high speed coming over the hill. And so I activated my front radar approaching, and I had the driver at 81 in the 55 mph zone. When he began to pass me, he slowed down to 74 when passing me. So I flipped around, got behind him shortly after we turned northbound onto 66th Street. And once behind him, I turned my lights on, and he took quite some time to pull over. He stated that he was trying to get away from residents in the area so that they didn't get woken up by the lights, I'm guessing. When I issued the citation, he stated he didn't know how fast he was going, but when I issued the citation, he advised that he had just finished passing somebody and was trying to get away from that person's high beam lights because they didn't turn their high beams on. But with that being said, I did a 2-point turnaround when I turned around on him, and no car ever approached the rear of my patrol car when I was turning around. So that may be the case, but if that is the case, the car was quite a ways back because I never saw one coming up behind me.
All right. And Mr. Emery, what is it you'd like to tell me?
Okay, thank you, Your Honor. Good morning, Your Honor. Good morning, Officer Great Honest. I'd like to start. So when I was coming from the Allegan County Fair that evening, I had my daughters with me, and about 5 to 8 miles prior to 62nd Street, heading westbound on 118th, that was behind a vehicle that was going from 40 miles an hour up to 55, 58 miles an hour and back and forth. He had been up and down several times. He wasn't being considered driving. He or she was considered driving. And so I had no real open area that was safe to pass to get around that vehicle. And then before we approached the 62nd Street crossing, we came upon another vehicle. And so we were now behind that vehicle. And when that vehicle came to 62nd Street, that vehicle turned right on 62nd Street. At that point in time, we'd slowed down enough and had enough straightaway where I felt it was a good opportunity to safely pass that vehicle that was now in front of me that had been driving kind of erratically, in my opinion. And so when I passed that vehicle, I can't use assumptions. I'm going to assume at the point when the vehicle that made a right-hand turn left, this vehicle in front of me felt he could put on his high beams. Is the only thing I figured. Because as I was already in process of passing and I started to proceed in front of him, his high beams had came on. And so now I'm in front of this vehicle and his high beams are in my eyes. And so I have 3 decisions that I can make here. One is to continue to drive with a visual impairment with the high beams in my eyes, the same rate of speed we were headed for the next 4 miles that I needed to travel before I was going to turn on 66th Street, which would lead me to my house. Or the second option would be to pull right over off the road to the shoulder of the road, right in front of the gentleman person I just passed. And based on their driving performance, not reducing their high beams or the speeding up and slowing down, I didn't really know if that'd be safe because I don't know what this driver's thinking. I mean, he could have ran into me if I would have pulled off the shoulder of the road there. I really didn't feel that being a safe option. So for me, I did what I felt was a safe maneuver, controlling my vehicle. I accelerated to exceed the glare and the intensity of the high beams. And I have issued in some pictures for evidence there that I had taken from the locations to kind of demonstrate where the process had started and about how long it took, and to look past the field of view to see. I knew coming up there was a hill and some wooded area that would get me beyond them high beams. And that on the other side of that hill is then where Officer Great Honest was parked. And so once I hit that hill and the top of that hill and I was covered by the woods and the high beams were no longer an issue for me, I had decelerated at that point. I was also within a half mile now of the road that I needed to turn on at 66th Street. That was another reason for my deceleration. So leading up to that spot there, I didn't have in my vision to be looking at my speedometer. It was 10:30 at night. I was accelerating to get beyond the glare of these high beams in my eyes. I was focused on the road and paying attention to the details around me to be as safe as I could be to make that maneuver. So I felt I was just doing the most safest adult decision maneuver just in a normal driving circumstance. And so when I proceeded
I will say I disagree with you. That going that much over the speed limit is a more safe option than allowing this car that you made the decision to pass continue to have its high beams in your rear view mirror, I think that would be the second safest decision. But essentially, sir, essentially what you're doing is giving a reason why you were speeding. You're not necessarily contesting you were speeding. What I have to do is decide whether or not you were speeding. So essentially, this is tantamount to you, like you said in the beginning, admitting responsibility. You're just providing an explanation why.
Okay, may I please continue?
Sure, but if you mean to explain why you didn't pull over right away, you have no citation for that, or you're in no trouble for that. That's simply the deputy providing context. So I can let you testify as to that, but essentially the only testimony that's relevant for the decision I have to make is what you're saying in regards to your speed.
So,
and I think you've testified to that. So
if I may continue, I guess I just kind of wanted to demonstrate how I felt the rest of the stop went as to whether or not, I mean, I still don't believe I was at 81. If, I mean, I know I accelerated to, to pass a gentleman or the person. I know I accelerated to get beyond the headlights, but I don't know that I was at 81. And so at any rate, to go along with what the officer stated, he stated that he had seen me on 118th accelerating, and that I had to decelerate as soon as I see him, and he had to turn around. He was already parked alongside the shoulder of the road, and it was right by the corner of 66th Street. He was just past the stop sign. And so, yes, that's kind of what I wanted to explain is I was decelerating because that's the road that I needed anyway. Like that's where I was at. I had a half mile to decelerate. That's what I did. I was safely beyond the headlights now. And so when I made my turn there, within the time from the stop from me rounding the corner at 10 mile an hour until the time that I pulled over for the officer is only 3/8 of a mile. And the officer, like, I didn't know I was being pulled over by an officer. He had to make a complete turnaround and then make around the corner to come after me before he was able to light up his lights and his high beams in my eyes and so forth again. And so for me, heading home, I'm a mile from my house now at this point. It wasn't that I delayed pullover. I had 3/8 of a mile before he even got behind me. He lit up his lights, and then for me to see it in my mirror and respond only took 1/8 of a mile. I mean, I was already a quarter mile down the road before he even was on the road to flip on his lights. And it was, so the comment that I gave him about being in front of somebody's home is right where, if I would have stopped right as soon as I seen his lights slamming on my brakes, I was parked right in front of the house that I only passed by 20 feet. Like I just went up I just I didn't slam on my brakes as soon as I acknowledged, hey, my brain sees lights in my rear view mirror. Like it was all within 3/8 of a mile. There was no delay reaction there. It's my belief, based on the questioning and the investigation that the officer, had provided, I believe that he felt perhaps he had a DUI or offender, or perhaps maybe a more serious offender in his hands before he even approached my vehicle. And he was pretty much ready to, go to the fullest extent of his ability to kind of take care of that. And I wasn't.
Well, I kind of agree with that, because what he has is someone that's going 26 miles over the speed limit in a residential area. So you were going to get that speeding ticket regardless of how you handled yourself, would be sort of my guess. It wasn't like this was maybe you're just going to get a warning, but then he thought you took too long to pull over. I think you were going to get a ticket no matter how you handled the back end of the stop, sir. But for what I need to do here today is make a determination on your speed. Given the testimony from the deputy, testimony from yourself, I would find you responsible on this citation as it's written. Now, because you had a contested hearing, we let you do a hearing instead of admit responsibility. So that does trigger that you do have a right to say, I don't agree with what just happened there. I wish to go and take this matter further to formal hearing in front of the district court judges with the prosecutor's office involved. But to do that, you must do two things. One is you must ask for that within 7 days of today's date. That window of opportunity closes. And two, you must come in and do it in person, because you would need to post a bond. Do you understand your rights on appeal?
I do, sir. May I please finish? I still had some more I'd like to add to that. I wasn't fully explained kind of the rest of that traffic stop.
Okay.
Would it be okay if I finish that thought?
Sure.
Okay. So upon the questioning, I mean, there was 8 different, or I'm sorry, there was 4, at least 4 different occasions where, you know, he had said I was at 81. At first, he had said I was twice the speed limit. And then when I had acknowledged that I realized it's a 55 zone, then he acknowledged it was 81 over, or I was at 81. And so then I denied that I thought I was doing 81 at 4 different times. And there was no evidence or anything provided to me to demonstrate that. And so I don't really believe I was ever 81 miles an hour, which just puts me at an unsafe. I just don't believe I was at 81. And so I don't know what to do about that necessarily. I just really feel that, and he was pretty much.
Well, I will say this, because you say that thing I hear every once in a while was not provided any proof of the speed. The whole thing where an officer shows you some sort of receipt or some sort of paperwork that the radar told you 81, I don't know where people get that from. That's not a thing.
No, sir.
But
I didn't say for there was a thing. I'm just saying that, like, I don't know that I was doing that. I inquired with the officer 4 different times that I didn't believe I was doing that. I just feel that even based on his testimony here today, there was some inaccuracies to his statements today. And so I just don't feel like, I don't know why there couldn't have been a warning in the situation. It was in a rural zone. It wasn't a resident. There wasn't houses on the street where I was speed limit.
Well, I will give you an opinion, because we're sort of running over here. My opinion is, I'm not sure how many officers there are out there who would give you a warning on an 81 and a 55. I think you're almost in a, 10 out of 10 officers are going to give you that speeding citation. All right. But you have your rights on appeal. That's a decision for you to make. Otherwise, you would accept this finding and make arrangements with the court to pay the fines and costs. All right.
All right. Thank you for your time today, Your Honor and Officer Great Honest.
Thank you.
And next we have Mr. It's loud in my car.
All right, sir. This is a citation. It was issued on September 16th of this year on 58th Street there in Manlius Township, Allen County, state of Michigan. This is being on a device while driving. You have a citation for that. You have 3 options of what to do here. First is you could admit responsibility to the citation. 2, you could admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or 3, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
The last one.
All right. So the first thing I'll do is swear you both in. If you could go ahead and raise your right hands. You swear or affirm any testimony that you'd give here today would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yes.
All right, Mr. Orchakowski, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why he issued you this citation. But after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Okay.
And with that, deputy, if you want to pick up the narrative somewhere it makes sense and explain the issuing of this citation.
Yes, sir. So I was traveling southbound on 58th Street near 126th Avenue in Manlius Township. The vehicle in question was northbound on 58th Street. And when he passed me, I saw his phone in his hand and it was being held up near his ear. Therefore, I turned around, got behind the vehicle, and it was stopped near 128th Street. While I was following the vehicle, he did weave in his lane a little bit. He wasn't all over the road, but he was weaving in his lane and touched the center line several times. When I stopped the vehicle, I told him the reason for the stop, and the driver, Timothy, advised that he was attempting to get directions. Therefore, he was written the citation for the hands-free law that went into effect earlier this year.
Okay. And sir, what is it you'd like to tell me?
Me?
Yes.
Okay, sorry. Yeah. So, while it's true that I was holding my phone up to my ear, looking at chapter 257, section 602B, subsections 3 and 3C, it outlines that the use of a mobile electronic device is allowed. And what was happening was I was listening to my GPS for directions. And so,
Yeah.
um,
Sir, here's the rule. You can make a phone call if it's hands-free. You can use your GPS if it's dash mounted. You cannot have your phone in your hand doing anything on it.
I was just listening to the directions.
Okay, well then you would have been able to do that if the phone was laying on the seat with the speaker on, but not with it in your hand, sir.
It was loud in my car. I was just listening because it was recalculating.
I understand, sir, but there's a very specific reason why this law was passed, that there essentially are no more exemptions. It's simply do not use your phone while you're driving. The only way you can is hands-free, which you obviously aren't, or dash mounted, which you obviously aren't.
Okay, that was just not my understanding of how the law was written according
Sure.
to.
There's also an older version of this statute, sir, that says you're simply not allowed to text, but you can make phone calls on your phone. That's no longer the law.
No, I wasn't. That's not what I was doing. I was just listening to the GPS.
I know. What I'm saying is it used to be that you could have your phone in your hand as long as you weren't texting. But now the law is you can only use your phone hands-free and or dash mounted. So for purposes of this citation, sir, I would find you responsible on this. Because you had a contested hearing, you do have a right to say, I don't agree with what just happened there. I want to take this to formal hearing in front of the district court judges with the prosecutor's office. You have every right to do that, but to do that, you must ask for that within 7 days of today's date. That window of opportunity closes. You must also come in and ask for that in person because you have to post the bond. Do you understand your rights on appeal?
What does that last? What does it mean to ask it on bond?
In other words, to have formal hearing, you have to come in and you have to post the $200 that is the fines and costs. And then that's held essentially in escrow while you have your formal hearing. If you lose your formal hearing, they already have the fines and costs. If you were to be found not responsible at formal hearing, you would get that bond back.
Oh, okay.
All right. We're all set, sir. I'm going to go ahead and release you. Thank you.
Okay.
And for case number 3, I left this in as a warning to all. If you're driving and you feel a little weird, pull over and make sure that it's nothing before you keep driving.
All right, Deputy, you want to take yourself off? Okay, there we go. All right, this is a citation issued on September 21st of this year on 32nd Street there, Salem Township, Allegan County, State of Michigan. This is for disregard of stop sign. Mr. Chief, you are on this citation. You're here today to do one of 3 things. First is you could admit responsibility to the citation, or 2, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or 3, you wish to contest this citation. In other words, to fight the ticket at what we call informal hearing. What were you looking to do?
I was looking to admit responsibility with an explanation.
All right, and what is it you'd like to tell us?
So I'd like to just describe what happened and then use that as an explanation of that. So it was the day of the accident was the 16th, and I was heading over to Burnups to.
I'm sorry, sir. Did you say the day of the accident or the day of the incident?
The day of the accident was the 16th.
I just didn't have it marked that it was an accident. Go ahead.
Yeah, it was an accident. It was a car accident. The day of the car accident. Yeah. So I got the citation, I think you said the 21st. I think that's correct. But the accident was on the Saturday, the 16th. And so I went to, I was going to Burnups, a recycling center. And I went there and I dropped off my recycling. And as I was coming home on 30th Street, I noticed that there was a farm stand there with some corn, and I kind of wanted to pick up some corn, but I decided to go to Fantasy Twirl where the corn I normally get. And so I took a left onto 144th, drove down to 32nd Street where that stop sign is, took a left there, went down to Fantasy Twirl. They didn't have any corn there. So I went back around the country block, back down 142nd to 30th, took a left-hand turn again there at 30th and drove through to the farm stand, picked up the corn, and then as I took a left onto 144th and was heading west, I had a brief bout of vertigo, and it was something new for me. It lasted about 5 seconds, and it concerned me a little bit. I have a business partner that had that happen and was diagnosed with Meniere's disease, and he ended up getting in a really bad car accident. And I, in my brain, said, I'm not going to do what John did. I'm gonna pull over if this happens again. And the next thing I remember is a car coming out of what I thought was the cornfield and hitting my car. And I remember briefly thinking, what the heck? Where did this car come from? How did that happen? And I was spinning, and I ended up going into the ditch. And then when I gathered my senses and realized that that what happened is that I wasn't where I thought I was actually at that intersection. And so I don't recall seeing the stop sign. I don't recall anything. For me, it seemed like the car came out of the cornfield. And I suspect that I had some vertigo as I was approaching that stop sign and never saw it. So there is no doubt that I caused the accident. I know I ran through that stop sign, and I feel horrible about that.
Sir, I just want to pause you because this citation is dated 9/21 at 2:07 p.m.
Yes, the Officer Deckinga came to my house several days after the accident to give me my citation. I suspect that the citation was delayed because I was transferred to Holland Hospital with multiple injuries. It was a level 1 trauma. So he was.
Okay. So in other words, you were not issued a citation at the scene of the accident that happened on the 16th, and then this citation was delivered to you later.
Correct.
But is in reference to that accident.
It is.
Deputy, can you confirm that?
Yes, Your Honor. He was, first of all, I apologize for my MCT. I don't know why my video is not working, but yeah, he was transported by ambulance, so I wasn't able to give him a citation at the time. And then during one of my next shifts when I was available to make contact with him, I issued him a citation. But I dated it as at the 21st so that he had the full 3 to 10 days to get his citation taken care of.
Okay, all right. So essentially that, I just want to be clear, sir, that was just a benefit to you because you only have so many days to answer a citation before it's defaulted against you. And so the deputy is giving you sort of more time to decide what you want to do. However, to be clear, in other words, I was the one who was sort of out of the loop there. To be clear, this is for an incident that occurred on the 16th.
Correct.
All right. We should probably amend that on the face of the ticket here. But I did that. All right. So, sir, I do understand what you're saying. Were you able to? I mean, this is just a sort of. The only thing that happens to you here with court is the fines and costs on that citation, the $110. It wasn't even written because an accident they always charge you more. This is just a baseline for disregard of a stop sign. I'm just more curious than anything. You get any answers?
I did. And that's why I wanted to explain it, is that I went to the hospital and I had several injuries. I was very fortunate. I was blessed that it wasn't worse because seeing the cars it was quite a significant accident. I mean, I don't think the other driver even put their brakes on because for him, it probably looked like I came out of the cornfield because I know that corner. I drive by that corner all the time. I live 1.5 miles from that corner. I've told all my kids to be careful of that corner. This time of the year, the corner is so high, it's hard to see, and you got to inch forward. And I almost am embarrassed that I ran that stop sign despite me berating all my kids about that same spot. But I did. And I think it's from the vertigo, and I had vertigo after the accident for almost 2 weeks. Fortunately, I did go to physical therapy at Holland Hospital. They have a vestibular clinic, and it's kind of bizarre, but it was several maneuvers that they did to get this crystal to go out of my semicircular canals in my ear, and it solved it. It's kind of seemed kind of hokey at the time, but it hasn't bothered me at all since then. And so,
Okay, well, I'm just, essentially, it's sort of why I'm sort of going down the rabbit holes. That's what I want to make sure of, because normally if something like this happens, and it may even have already happened to you and you know what I'm talking about, but when you're involved in a situation like that, a lot of times the officers or later, they'll actually indicate that to Secretary of State that you might need to make sure that you're medically cleared to keep driving. But it does sound like you were able to sort of get past that, and now you're back to a place where this was hopefully just an isolated incident. All right.
Yep. So,
well, I will say this, a couple of things just to explain things to you, because you took the time to explain things to us. The only thing the court does on this is fines and costs. The Secretary of State is the one that will do what's called points on your license. Do you know what I'm talking about?
Yes.
And finally, we close out our stream with super nice Michigan guy.
There he is. All right, Mr. Burr, are you able to hear us?
Good morning. Little bit
All
of technical difficulties here. Hi.
You're here now. That's all that matters.
Officer.
All right.
Your Honor.
This is a citation. This was issued on September 21st of this year on US 131, Martin Township, Allen County, State of Michigan. This is failure to yield to the emergency vehicle. You are here, Mr. Burr, on this citation to do one of three things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened, or three, you wish to contest this citation. In other words, to fight this ticket at what we call informal hearing. What were you looking to do?
The second one, please. I'd like to accept responsibility and discuss the circumstances.
Okay, and what is it you'd like to tell me?
Basically that we were coming in from the airport in Seattle to Grand Rapids, and we had rented a car and gotten on the highway and was basically unfamiliar with the law, and drove past Officer Kelly, and he saw us and came after us and stopped us. And we had rented a car at the airport that had Georgia license plates, and it was basically a mistake, and I'm sorry I did it.
All right. Well, and sir, essentially, I understand this, what's happened here is essentially you're saying that law does not exist in your state, all right?
As far as I know, I've never observed it or needed to use it. I can
I will
benefit.
tell you this as far as Michigan. When this was first enacted, well, first of all, it was a misdemeanor. When it was first changed, it was a crime, not just a ticket like you have now. And it was because at that point, I think the last 5 state troopers in the state of Michigan that were injured during the line of duty were not shot by bad guys. They were hit on the side of the road there, just trying to perform traffic stops. So this was initiated as a misdemeanor. And then a few years ago, they downgraded it back to ticket. They just made it a very expensive ticket, as I'm sure you're aware if you saw the price tag on this.
Yeah.
So essentially that the word gets out, you need to move over when you see those emergency vehicles on the side of the road.
Yep.
I would have told you this. I would have said the whole thing, ignorance of the law is no defense. In other words, I'm sure you've heard that before. And I know that when you said, oh, we're not from Michigan or something, that the trooper explained to you, well, there's billboards when you enter this state, but essentially you flew in and rented the car somewhere. Here's what I'm going to do for you. You're admitting responsibility on the citation. What I'll do is cut that fine and cost down. I do have some discretion on that. So you are responsible on the citation. You're admitting that, but you're clearly showing remorse. You know the law now. I'm gonna cut it in half. So at the end of the day, it'll be a $245 fines and costs. You're gonna want to give this a little time before you call the district court to pay it, because they won't know that I changed the price until I essentially fixed all the tickets in the system later on this morning. So starting this afternoon, you'd be able to call back. When you make arrangements to pay that fines and costs, you'll notice the fines and costs went down. Do you understand why I did that and it makes sense to you?
I do. Thank you very much. I appreciate it.
All right. Are you still in Michigan?
No, sir. We're back home in Alaska.
All right, so make sure you take care of this, but I'm going to go ahead and release you. We're all set.
Have a good day.
I wasn't able to get you the information I wanted because the Kansas court website has been down all day, but I think this guy's middle name is Dahmer, but it might be Donner, but Jeffrey Dahmer? Donner? Browning? I don't know. Thought it was interesting. But his reason for wanting bond is interesting too. Let me know what you think. Is that a valid reason to let someone out on bond, or is that just, part of your punishment?
This is State of Kansas versus Jeffrey Dahmer Browning. Butler County case number 2023 CR 456. James Watts appearing as defense counsel. Defendant Browning appearing from the Butler County Jail's Zoom location. Darren DeVinny, county attorney, appears on behalf of the state. This matter appears to be before the court on a motion to modify bond filed by the defense. Mr. Watts, you may proceed further.
Thank you, Your Honor. Judge, I'm not going to expand any beyond the motion. I would ask, as I noted here, the bond at this point, as I understand it, is set at $7,500. That's what my client tells me. That doesn't sound like an unreasonable bond in and of itself, but it's one he's obviously unable to make because he still sits inside the jail. He would, it looks like at this point, we believe, be a C on the grid, although obviously we cannot know that with certainty prior to a PSI.
When he says C on the grid, he's talking about the sentencing guidelines that many states are developing. That's like a numeric system where you add up the numbers for your past crimes to determine what your sentence should be. If anybody's interested, I could probably compile it and go over a couple of them, but this is what Kansas looks like.
His most important problem, however, appears to be that he has been evicted by the property he was living at, and he has a limited amount of time, and I'm guessing at this point about a week to a week and a half, to remove his property from that residence. If he's not able to do that, it's likely he's going to lose that. And as he put it when I met him at the jail, everything he owns is in that residence. If he's not able to remove it by the time his deadline runs out to move out of that property, he's probably going to lose all that items and he'll end up with nothing when this is all over. He has no objection to electronic monitoring. If the court believes that's appropriate, he would be able to stay in Wichita with his mother. But we would ask the court to consider modifying his bond either to an OR bond in the amount that the court believes is appropriate, or a bond in the something he has the ability to make. I would guess somewhere in the $2,000 range rather than $7,500.
Your client doesn't have the mother, a sibling, a friend, or an acquaintance that could help him with moving his stuff out of a place?
It sounds like no, Your Honor.
What's the state's position regarding this request, Mr. DeVinny?
Well, Your Honor, he had a fiance, and that's the victim in the case that could have helped him. But I think the bond is extremely reasonable given the level of the charges, given the defendant's criminal history. And when I look at the bond factors that we would normally cause to determine what a bond recommendation or bond determination should be, looking at just the level of the charges, the nature of the charges, those types of factors, I think $7,500 cash or surety is extremely reasonable considering this defendant has had 2 failures to appear in 2022. He's had an arrest for failure to appear as recently as December 1st of 2022. So the state has a concern certainly about his ability to show up for court, that he will return to court. But again, the dollar amount isn't extremely significant. At $7,500, contacting a bondsman to see what, if any, this treasured property that we're trying to so desperately to hold on to could certainly potentially be the basis for a bondsman to take into consideration as collateral for a bond if he wants to negotiate that. But state's position is it's a reasonable bond at the level it's at and should continue. If in the alternative, if the court is interested in Mr. Watts's proposal of converting this to an OR bond and putting them on electronic monitoring, I think that would be at a minimum required. And certainly we want to make sure that there is a zone of protection around the victim at her residence as well. It sounds like the defendant's intention would be to move to Wichita to stay with someone there but at the same time, Judge, he's got a place to live in Wichita. I'm not sure if this same person couldn't help him dispose of his property, but property disposal and personal property moving, having it taken care of, this is not, honestly, it's not a bond factor. And his whether or not he's going to return to court is not dependent upon what happens to his personal property.
Well, so noted, Mr. Devaney. Court will take this motion under advisement for the moment. Mr. Watts, I do note that in looking at the notes from first appearance, that this case has been set out to November the 20th on a PHC docket. That's the next setting. That's a little bit troublesome for the court. I hate that it's so set so far out with a guy in custody. Have you talked to your client about whether he really wants a preliminary hearing or not?
Actually, Judge, when I went out and talked to the jail, he wrote me, and he wrote specifically about the bond. We haven't really discussed a whole lot preliminary hearing, although, so we have discussed it as to what we were likely to do. My inclination is that he's likely going to ask this case to be set for a preliminary hearing, but we have not finally made that decision.
Well, I'm going to go ahead and set it. I don't want the possibility that this case is set out to December or perhaps even January by the time we get to November 20th, given the current circumstances of this case. I'd rather get the case set while we have everybody here.
One moment, Your Honor. I noticed, Mr. Browning, did you have something to say to the court on that subject?
I do. My whole thing is I'm trying to get out there to be able to test with TFI so that way I can show some sort of effort so I don't lose my son next month, because I have a permanency hearing over my son this coming month. I'm trying to actually get out to be able to go to MERS treatment, inpatient treatment, where I can go there and also enter their reintegration program once I am completed with their 28-day program. I'm not going to be running nowhere. My son is my main priority, and if I run while on a monitor or run out period and don't show up for court, that's me also running out on my son and just abandoning him, and I can't do that to him. His mother is out there not doing what she needs to be doing to save our son. I need to be able to get out and be able to go out there to do what needs to be done so I don't lose my son.
Well, thank you for that information, Mr. Browning. Scheduling business first. Council, I will propose 3:00 p.m. on Thursday, November 9, for a preliminary hearing in the case. This would be an evidentiary setting. November 9, 3:00. Mr. Watts, your availability at that time?
Judge, it looks like I have a case starting in front of Judge Crum at 2:30 on the 9th.
What about earlier in the afternoon, Mr. Watts?
I have 1:30 in front of Judge Hart. That looks like that's a sentencing docket. I'm gonna have to get out of that one quickly.
Okay. I'm going to address my assistant. It looks like that maybe I could set this in the morning at 10:30.
I can
on
do that.
November 9. November 9, 10:30. Council,
Judge,
check your calendars for that.
Judge, on November 9 at 10:30, I'm in front of Judge Crum on a pretrial date with 1, 2, 3, 4, 5.
You're a busy guy, Mr. Watts.
It's a busy day on the 9th. Yes, sir. 7 cases.
Covering duty that day here at the courthouse. I could propose Tuesday, November 14. Your availability then, Mr. Watts?
Well, that will work, Judge, assuming I'm not in trial for any of those that are set for pretrial on the 9th. And
Yeah.
again, at
And
that
what's
point,
the
I don't
likelihood-
know.
You don't know? Okay.
I really don't know whether they're going to go.
Just trying to allow a little bit more than an hour. I might propose Monday, November 13 at 10:45 a.m.
Yes, sir.
Would that work?
Yes, sir.
Okay, Mr. Devaney, your office can make that work?
That's fine, Your Honor.
All right, I'm going to set an evidentiary preliminary hearing in this case for Mr. Browning for Monday, November 13 at 10:45. Should be sufficient time for presentation of evidence. 10:45, Monday, November 13, evidentiary preliminary hearing setting. I will note for the record that that is a date 7 days sooner than his preliminary hearing control was originally set in the case. So the court has tried to expedite that setting. That setting is done as a prelude to the court's ruling. I agree with Mr. Devaney. I think this bond is reasonably set where it is. One factor that the court must consider is what the very purposes of bond is to ensure appearance, but there's also a statutory provision which allows the court to consider public safety. This is a violent crime, Mr. Browning. Now, at this point, you've got a presumption of innocence, but the charge before the court is that you feloniously choked your domestic partner. It does appear that there may be issues regarding the safety of one or more individuals in our society should you be released. I'm not inclined to modify this bond. I think it is reasonably set. I regret you don't have the immediate financial resources to make an appropriate arrangement with the bondsman, but I'm going to leave bond where set at $7,500 cash or a professional surety required with the same restrictions as before. No contact with the victim, obviously, is the only thing that's listed on the docket sheet. No alcohol or drugs, obviously, if you do make bond, Mr. Browning. And I hope you can communicate with somebody in the outside world regarding this personal property issue, but I agree with Mr. Devaney. The fact that you may lose property as a result of the accused behavior and because of your current detained status is not really a factor for this court to consider. That's just an implication of what's happened in the case. So the request to modify bond at this time is denied. Preliminary hearing set November 13, 10:45 a.m. Mr. Devaney, is there anything else from your perspective that we still need to address?
No, Your Honor.
Mr. Watts, anything further at this time?
No, Your Honor. Thank you.
Very well. Then the Browning matter will currently be in recess at this time.
Your Honor?
Yes,
Will that be a Zoom hearing or in person?
the evidentiary prelim is contemplated to be by Zoom.
Yes, sir.
Okay, thank you. The matter is in recess. You may end the meeting for all, Mandy.
And on today's menu, I have a sampling of how court has become such an inconvenience to those that are entitled to so much better.
Mr. McCullers, what is it that you need? Because you keep sending messages. You're muted. I can't hear you. You're muted. You're muted.
So I had two questions. My battery is about to die. What do we do when our battery is about to die?
You don't have a charger, sir?
I don't have a charge. I have a car charger. I can't. I don't have it, and I'm at work right now. I can go buy
Mr. McCullers, Mr. McCullers, that is not the court's responsibility to make sure that you are ready to come to court, sir.
No, I am ready. My phone was at 65%.
Sir, you haven't been. Sir, court started at 9 at that is your responsibility, sir. We cannot make an exception for every person out there, sir.
Okay.
We
That's
have 40
fine, sir.
people out here.
That's fine.
Mr. Butler, you can take your mic off of mute. Mr. Butler, how are you doing?
I'm doing all right.
Now, Mr. Butler, last time that you were here, your attorney at the time, which was Todd LeBlanc, was granted his motion to withdraw you had signed the judge's explanation of rights of defendants without attorney. And on that document, you indicated that you wanted to waive your right to an attorney to represent yourself. You also signed a waiver of counsel in that case. Now, my question to you is, have you had an opportunity to set up an appointment with the district attorney's office to review the file?
I've tried, just transportation is very hard right now.
Okay. Now, if I'm not mistaken, you live in Louisiana?
Yeah, at the moment I have moved back home.
Okay.
I was staying in Texas.
All right. So what we're going to do is we're going to give you an opportunity to, now you're going to have to contact the district attorney's office to set up an appointment so that you can review the state's file, okay?
All right, and could I ask you something?
Okay.
Being that I haven't reviewed the file, could the file be played in? Could the file be played in court?
I don't think so. He was saying played in court. Now, there's some you have to set up an appointment. It's like having a private a conference with the district attorney's office, and so that's not public.
Yeah, so none of the evidence that I'm going to view.
It's not public. You have to view that in the district attorney's office.
So what I'm asking is, will that evidence, the evidence that I'm viewing, will that be used in court?
Oh, yeah, I'm sure it'll be used in trial if that's what you're asking.
Right, so I won't be able to view it in trial?
Okay, so I mean, only thing I'm saying is if you put it like this, if you, they're gonna give you an opportunity to review your case in advance of trial. Okay, so that you can prepare for trial. You won't be.
Yeah, but I haven't done anything, so I'm not worried about it.
Okay,
Like I said, I have reputation issues, and it's hard for me to make it to see that. So I'm asking that for a reason, because I don't mind it being played in court, and from there I can go along with what needs to be going on or needs to be said, because I can tell you honestly what happened. I do anything.
Okay, so
I have nothing to hide. I'm just trying to get this done with.
Mr. Butler, based on what you're saying, I think what you're saying is you want me to set this case for trial. Is that correct?
I've been saying this, Judge, ever since I've been coming up there. Yes, sir. That's why I don't want a lawyer. I've been asking for lawyers. No one trying to help me, and I have nothing to hide. I'm trying to get the case done with and get it put forward.
Okay, Mr. Elliott.
I have a child. She's 2.
Mr. Elliott.
Now, and I've been dealing with this case since she was 4 months.
Okay, Mr. Elliott. What we're going to do, state.
To the state. I understand what the council's arguing for. I mean, the defendant is arguing for, but he's got to come to court before we do anything. The state's gonna ask him to.
I have been coming.
For him to come, not over Zoom, unless he's sick or he's got COVID or he's in Alaska. We can't do anything for
Okay.
For the reason right now, like.
Just hold on. Now, Mr. Elliott, what the state is saying is that they want you to make it a personal appearance in court and to make your announcement for trial on that date. Okay?
What about the times I have done that? They're not going to tell me, say nothing about that.
What I want to do, Judge, is also.
It's been 2 years.
Hold on, Mr. Elliott. Mr. Butler, the prosecutor is talking. You can't, 2 people can't talk at the same time. Just let the prosecutor say what he has to say first. Okay, then we'll give you an opportunity to talk, and the prosecutor won't be talking while you're talking. Okay? Now, Mr. Hopper, what were we saying?
Well, the reason why I'm saying that, Judge, is that we could do it at that time. It won't be on for trial at that time, but an announcement. That way I can set an appointment for him to look at the evidence if he's a pro se defendant, so we can have an appointment to come look at his evidence. Therefore, he wouldn't be for trial, and they would try to rush that.
But
that's my only thing.
Okay.
That's why I'm saying that.
But I think what he's saying, and you could correct me if I'm wrong, Mr. Butler. Mr. Butler is saying that he don't want to look at the evidence before trial.
Right.
Caution.
Can I say something?
Wait. Mr. Hoffpower was talking. We'll let you say something, Mr. Butler.
Out of abundance of caution, and it's not against what the defendant wants to do, but for the state, if we do it wrong, it comes back. Therefore, and it's a pro se, the court knows there are a lot more things we need to make sure go right if it's a pro se defendant. Therefore, I'd just like to make sure we give an opportunity. It's on the record that we gave him an opportunity to go look at the evidence. All those things, we're just trying to make sure it's done properly with a pro se defendant. That's the only reason why I wanted to do an announcement first and then a jury.
Now, Mr. Butler, did you hear that?
Not clearly.
Okay. Hold on a minute. Okay, could you repeat?
The only thing, because it's a pro se, and as the court knows, that's a unique thing. It's okay, somebody can represent themselves, but the state's responsibility is to make sure it's a fair trial as well. And we also have to follow the steps to make sure he's got access to the discovery. Therefore, we need to put it on the record. We gave him an opportunity. He was in court, not on Zoom. He was in the court and he was instructed. He's got an opportunity. If he doesn't want to do that, that's fine. But the state has to follow these steps in order for it to be a fair trial. We believe it covers the state. Should the resolution come about and somehow they go back, so we didn't give them an opportunity to look at the discovery. That way we're covering our bases. It's out of the abundance of caution. It's not to punish the defendant or to delay the trial.
Now, Mr. Butler, did you hear that?
Yeah, I heard him.
Okay. So
I'm not understanding what he's trying to tell me. He's saying that I get what I heard him, but it's not making sense on why I have to if the video being played, if the evidence is being used in court, why I have to use it. Like, why do I have to go watch it if it's being used in court when it can still be played? Like, either way it go, like it's not making sense. It's really not making sense to me.
Okay, no, what he's saying is because okay, Mr. Butler, what he's saying is because you are representing yourself and you do not have an attorney to represent you, of the abundance of caution, they want to make sure that everything is done the way it's supposed to be done. In essence, you are not being railroaded, or no one is trying to trample on the rights that you have. And so they want to make sure that they do everything that they're required to do by law. That's what he's saying.
All right. So,
okay.
So what
we're gonna do, we're gonna give you we're gonna reset the case, give you an opportunity to come in person, and at that time, then you'll be able to either set up an appointment with the prosecutor to review the discovery, or you can have they may have a document saying that you were given an opportunity to review the discovery and you have decided to waive your right to review that discovery. All of this here is going to be documented. Okay. And so what we're going to do, we're going to reset this case.
So can I just waive the discovery?
Yeah, but you got to be here in person. We can't do it over the
all right.
So
why wouldn't I told this before? Like, why couldn't I be told this beforehand?
Because you said because at that time you was going to set up an appointment to do this, to view the discovery. And you said that you have made attempts, but you have not, I guess, you have not been able to talk to anyone in the DA's office to set up that appointment. And so what we're going to do is make sure that the next court setting that you'll be here, you'll have the opportunity. If you want to review it, you'll be allowed to review it. If you do not want to review it, then you'll sign a document stating that you had the opportunity to review discovery, and it was your decision that you made voluntarily and knowingly not to review or have access to the discovery. In essence, you'll be waiving your right. Okay. So what we're going to do is just reset this case. and give us a recent.
I'm going, so can I say so, Judge?
Okay, go ahead on.
I'm sorry, not to keep on talking. And then they, so I'm gonna keep being held for something I know I didn't done, and I do not mind the video be playing in court. So I'm gonna keep being held with, I gotta keep being held. My rights, I gotta keep being held with these folks knowing that I did nothing. And if they have a proof of me doing anything, I'll be in jail right now. They can take me right now. If they're supposed to have evidence. So while I'm out, I'm tired of this having to go back and forth, man.
Okay.
And my rights actually is being played with because it's not being respected.
Hold on, Mr. Butler, two things. You don't call me man.
Everybody.
That's one thing. And the other thing is you need to be here. The court has allowed you to appear by Zoom. However, you will not be allowed to appear by Zoom anymore. Okay, you need to be here in person.
All right, and if I can't, I'll just call y'all and let y'all know if I can't make it. That's all I can do. Because I've been coming and I've been showing up. And I'm sick of it now. And now y'all telling me this.
No, Mr. Butler, your history is that you've had an attorney. Okay.
I didn't have an attorney, Judge.
Why would the attorney withdraw if he was not your attorney?
That's the point. He didn't withdraw. I didn't even want him. I told you that before he been withdraw. I've been saying I didn't want him because he was not answering the calls. Been trying to get in touch with his judge. I mentioned that. I mentioned that when I came up there.
And he's no longer.
So if he withdraw, that's on him. I didn't want him before he withdraw.
Okay, well, Mr. Butler, you're gonna have to appear here in person. We're gonna give you a reset date. If you do not appear in person, absent any other reasons, but you need to be here in person. Okay, give us a reset date.
I try to make it that person. It just all right, because look, I'm definitely trying to make it that person because I'm sick of my time is being pulled upon this, and nobody want to understand that. And I'm not trying to upset nobody, not trying to upset you, Judge. But my time is being pulled across and be hold for something I know I didn't done. I didn't do it.
Now, Mr. Butler, what we're gonna do? We're gonna try to give you enough time to get your affairs in more order to try to get transportation. So we're going to reset this case. We're going to give you 60 days. We're going to reset it to December 13th. Okay.
December 13th. All right. That's cool.
All right. So this case is reset to December 13th, 2023. Stay in contact with your bondsman. Mr. Butler, you're free to go and you have a blessed day.
You too, man.
Thank you. Not man, it's Judge.
I'm sorry.
Okay.
I'm sorry, Judge. No,
all right. All right. We'll talk to you later.
All right.
This is a bond hearing in front of our beloved Judge Manning. The man attacked a nurse at Grady Hospital in Atlanta. The nurse was a male. I looked it up in the news and I couldn't find anything. And perhaps that's because it's a big city. I know where I am, that would definitely make the news. But then I started to wonder, is it because it was a male nurse and not a female? I'm not sure. But anyways, kind of messed up.
Investigator, or is it Sergeant? I'm sorry.
Sergeant.
Okay, Sergeant Jones, is that right?
Yes, ma'am.
And you're post certified?
Yes, ma'am.
And did you where do you work? Tell us that. Where do you work?
Atlanta Police Department.
And how long have you been in law enforcement?
22 years.
And how long have you been a sergeant?
Since 2019.
Okay, so about 4 years.
Yes, ma'am.
And so so you said you're post certified, that you said that?
Yes, ma'am.
Okay, and were you working an extra job at this incident?
Yes, ma'am.
And where were you working?
Grady Hospital.
And can you tell us the location of Grady Hospital?
It is Jester Hill Junior Drive, Southeast.
Is that
in Atlanta?
That's in Fulton County?
Yes, ma'am.
Okay. Can you tell us the date of this incident and what happened?
March the 17th, 2023, about 1:30 in the morning. So as stated, I worked my extra job down at Greater Hospital, been working there for about 7 years. But on the night in question, I was called back to the, what we call the Zone 2 area, or where they do emergency treatment. And when I got back there, the nurse was laying on the floor, and they immediately took the nurse to the trauma center for treatment.
So when you got there, the incident had already taken place.
It had just taken place. Yes, ma'am.
And so so I believe you said that you saw, so what did you see when you saw him falling, or what happened?
Right. As I was coming, he was falling to the floor.
And did you see the defendant there
Yes.
in his immediate vicinity?
Yes, ma'am.
And what is the nurse's name that was assaulted?
His name was Nurse.
Okay, and so he's a male nurse.
Male nurse, yes, ma'am.
And so let me see. Did you say it was March the 17th, or did you say
May the 17th?
Okay, May the 17th, and
Yes.
that was of this year?
Yes.
And so you witnessed
Right.
falling to the ground.
Right.
Did you investigate?
Yes, ma'am.
Go ahead.
Let me just tell you what happened. Later on, I investigated, and I got the statement from nurses back there, and then later on from Mr. Powell. But he said the defendant was in that area for treatment.
The nurse.
Right. He said the defendant, Mr. Terrell, was in that area. Edward was in the area for treatment, and he was walking through Zone 2, like wandering around. The nurse asked him, did he need any help? And he said, can you show me where the restroom is located? He pointed to the direction and showed him where the restroom was. He said, as he started walking to the restroom, he turned around and came back and went behind the nurse's station where another female nurse was working. She told the defendant, he cannot be back here. You need to get from behind the counter. He began to argue with her. Nurse Powell came over and intervened and said, sir, the restroom, once again, he pointed to where the restroom was. He said, all of a sudden, the defendant stated, I'm not gay, and with a closed fist, hit him in the face.
He said, I'm not gay.
Right, he said, I'm not gay. Then he hit the nurse in the face.
He used a closed fist?
Closed fist. And this from the nurses and statement said the force of the impact was so.
I'm sorry, let me cut you off. What was the other nurse's name who witnessed this incident?
They didn't give me no statement. Once I talked to nurse, I didn't get the information from them.
But you spoke to them, but
Yes,
you
ma'am.
didn't write their name down?
Right.
How many witnesses witnessed this besides?
All of us, at least 10 of them.
10, was they all nurses or were they just?
Nurses, staff.
Okay, so there was several people who witnessed this assault?
Yes, ma'am.
And so what happened after?
So-
Go ahead.
So when he hit him, again, he said the force of impact was so hard, it cracked his bottom right teeth. It knocked the crown off of one of his rear teeth. It broke his glasses. And as the nurse was falling backwards, he fell backwards. He bumped his head on the desk, which left his head bleeding and a visible laceration. And as the ground, he was knocked completely unconscious.
Unconscious?
He was unconscious.
Did I have to go to a higher level of care? Did he have to go to trauma or anything?
Right. Yeah, they immediately took him back to the trauma area and started to work on him. Greater security, of course, arrived shortly and they detained Mr. So I asked Mr. Why did you hit that nurse like that? And his statement was, I don't know, and I'm not gay. And I immediately detained him, took him down to the greater detention to get treatment for whatever he was at greater for. And after he got his treatment, he was transported to the Fulton County Jail.
So did you meet with any other witnesses? Like you said, you didn't take any statements, but did you talk to anybody else about what they may have seen that was not, done by, said by?
They pretty much said the same thing and backed up his story.
Okay, so they said that they overheard Mr. Excuse me, Mr. Everett saying that I'm not gay, and then I proceeded to assault Mr.
Yes, ma'am.
Do you know why he said that I'm not gay? I mean, was there any type of conversation about his sexuality or anything like that?
Yeah, I don't know. To this day, I don't know why he made that statement. And I asked, although I didn't list it in my report, I asked him why would he make that statement, and he didn't know either.
I don't want to get into too much of this gay statement, but is Mr. Powell gay? I mean, do you think?
Objection, Judge, relevance.
I'm trying to, well, it was relevant because your clients alleged to have said this statement. So I'm trying to figure out what made him say that, Judge.
I don't think he's gay or nothing, but I don't know.
You don't know for sure?
Yes, ma'am.
Okay. So you'd have no idea why?
I have no idea.
Okay. And, all right. So is there anything else? So you also charged, so you charged with aggravated battery. Is that for the teeth, the missing teeth?
Yes, ma'am.
And then also the unconsciousness?
So the Georgia aggravated battery statute requires maliciously causing bodily harm to another. Specifically, it requires rendering a member of his or her body. That makes me laugh. I don't know why. Member of their body. I understand it was written a long time ago, and that's probably some kind of, specific member of it. Just the terminology makes me laugh. Anyways, thanks to Kevin Fisher Legal, there's actually case law on these. So specifically, blurred vision, lost tooth, or part of tooth. There's a case for that. Temporarily broken nose, broken finger, severe bruising, memory lapses, and severe permanent damage has all been sustained on an aggravated battery conviction by the Georgia Appellate Court. So here is your links if you want to freeze this for those law nerds out there. And for everybody else, sorry for the interruption.
No, I charged him with aggravated battery and also charged him with hindering preventing a medical staff or technician from doing their job.
So, so what was the aggravated? I thought it was aggravated battery for also that him being unconscious as well.
No, I did the aggravated battery because he cracked that teeth in that crown.
So that
He eventually lost that teeth.
Oh, he lost it.
Yeah,
Okay.
He's still out as of today.
Did he ever get it fixed, or is he gonna about to get it fixed?
He's still going through the medical procedures part of it to get his mouth repaired.
Like workman's comp and things like that?
Yes, as far as I know, that's what he told me last night.
Okay, and so you charged him, Mr. Everett, also with hindering emergency professionals, is that right?
Yes, ma'am.
And the basis of that is for him just assaulting them while they're on their job?
No, well, that's part of it, but I figure if he's a nurse there serving other customers and he's laying on the floor with a knocked out teeth, damaged crown, and unconscious and bleeding from the head, I believe that hindered him from helping and working with other customers he had.
So the actual assault and the fact that he could not help other customers in the
Right.
hospital?
He prevented him from helping other customers.
Okay. And was there anything else that you would like to say that's pertinent to this case for the judge to know?
Other than that, one other thing was I didn't know at the time when he knocked him out, hit him, it broke his glasses too. Nurse Power wear glasses.
So it broke his glasses as well?
Yes, ma'am.
And was this incident captured on surveillance footage?
Grady Hospital has the surveillance footage of that area.
Did you review the footage? Have you had a chance to review it?
No, I didn't. And I just got when I got there, I got the footage on my body camera, but I didn't pull the footage from Grady, but they still have it.
Okay, so you have the footage of what footage do you have as far as
I just got it on my body cam, but the footage.
What's on the body cam? Because you said you weren't there to witness this.
Yeah, just me talking to him and I think talking to Nurse Pete.
And when did you have a chance to talk to Nurse? You call him Nurse Pete?
Right, well they call him Nurse Pete, but it's Nurse. I work there every Monday and Tuesday, so I'm familiar with.
He was unconscious, so I'm trying to figure out when we were able to talk to him.
After they brought him to late on that night. Why?
So after he was already came back to
Right.
consciousness?
Yes, ma'am.
Okay. And he was able to remember everything pretty clearly at that,
Yes.
by him being unconscious? Okay.
Yes, ma'am.
And he was able to identify Mr. Everett as the perpetrator,
Yes,
as the
ma'am.
one who assaulted him?
Yes.
Okay. And the other witnesses were able to identify Mr. Everett as well?
Yes, the other nurses and was able to identify. I mean, he stayed right there on scene. He didn't try to run off or nothing.
And so he never denied the fact that he assaulted Mr. Nurse, correct?
Right. He never denied it.
He just said, I don't know why I did that.
He just said, I don't know. I said, why did you hit the nurse like that? He said, I don't know, and I'm not gay. And I said, okay. And went on, put him on the arrest at that point.
Okay, and let me ask you another question. So, and the body camera is into evidence, is that right?
Yeah.
Okay.
I mean, on the body camera is not gonna capture him hitting him.
The actual assault, but you captured the witnesses and what they said.
Yes.
Okay. And you also captured nurse statement.
I'm pretty sure I still had it going.
And so Nurse Powell is the victim. And were there any other victims?
No, ma'am.
Okay. I think I asked you, but it's in Fulton County, correct?
Yes.
And you were able to talk to Mr. Everett before today?
Have I talked to him before
Yes,
today?
you talked to him before today when you spoke to him about whether or not he assaulted.
Right. That's the only time I talked to him was that night of the
And so are
incident.
you able to identify him today in court?
Yeah, he's sitting over by his defense attorney with the blue jumpsuit, the little short afro, black male.
Okay. Judge, let the record reflect that this officer, Sergeant Jones, has correctly identified the defendant, Mr. Everett, in this case.
All right, it's noted.
And that's all I have, your witness.
All right, Cross.
Thank you, Judge. Good afternoon, Sergeant Jones.
Good afternoon, ma'am. How you doing?
I'm well, thank you. You said that, I think I'm a little confused. Were you working at Grady on an extra job already?
Yes, ma'am. I work there every Monday night and Tuesday night.
Okay. And this incident, was it on like a regular floor of Grady?
No, it's on the main lobby floor, but it's in an area called Zone 2. It's like right across from the trauma center.
But that's not the Grady detention.
No, the Grady detention is in the basement.
And so to your knowledge, Mr. Everett was there just as a patient.
Right. He was back there for treatment.
Do you know what he was there for treatment for?
No, ma'am. I don't know.
Okay. And you didn't witness the alleged assault?
No, I didn't actually see him hit him.
Okay. And you mentioned there were other people present there at the time,
Yes, ma'am.
but you didn't get like written statements?
No,
from
I
them?
didn't get no written statements from him. I just got their verbal statements.
Okay. You testified on direct that the nurse was knocked unconscious. Do you know approximately how long he was down on the ground?
No, I don't know exactly, but I can just say while he was unconscious, they immediately took him to the trauma center. So he probably was down in less than 5 minutes.
And you mentioned on direct, he was able to, after he came to, he was able to recount the events and identify who hit him and all that.
Yes, ma'am.
Okay. You mentioned that he lost some teeth. Do you know how many?
On the bottom row, the center teeth, it was cracked that night, but he ended up losing it. And it broke a crown in the back of his mouth off one of his teeth.
Okay. That's all I have. Thank you for your time.
You're welcome.
Anything else from the state?
Nothing else from the state.
All right,
Judge.
thanks, Detective. Stay safe out there. Get some
Yes,
rest.
ma'am. Thank you, Your Honor.
All right, go ahead with the argument.
I'll allow Attorney Wood, is that correct, Attorney? Okay.
Thank you. Judge, I would ask that you not find probable cause on the aggravated battery, instead find probable cause for the lesser included of simple battery. I don't believe a damaged crown and a broken tooth and being on the ground for less than 5 minutes meets the standard of having a body part rendered useless. And he was able to recount his version of what happened after he was up off the ground. So I think our argument is that that would be a simple battery instead of aggravated battery.
Go ahead.
Judge, I know that the sergeant said that he only charged him with the aggravated battery for the teeth, but I believe it was also for the unconsciousness as well. So that would qualify for the fact that his brain was rendered useless for how many, if it was 5 minutes, 10 minutes, 30 minutes, he was still unconscious. And so also, it wasn't just his teeth was broken, the teeth were removed from his mouth. So at that time, that's also a member within his body that was dislocated from him, that you say he's still missing teeth at this time. So Judge, we suggest that the aggravated battery is substantiated based upon those two factors. And if a warrant does not reflect the unconscious, we would suggest that it did, because you heard Sergeant Jones testify to the fact that this officer, this nurse was rendered unconscious, and so his brain was rendered useless at that moment, and also the teeth were removed from his mouth. So I don't believe that Attorney Wood is contesting the second charge of the felony of hindering. Are you contesting that? Okay, so we hope that we pray that you bond that over as well.
All right, I'll find probable cause on both. He has a $15,000 good bond as of 9/15. We can address bond.
Judge, before you start that, if it's okay, I'm not going to ask for a bond reduction. He has a matter with me in Judge McBurney's courtroom. I'm trying to take care of everything.
Okay, so just leave it alone. Okay, and we don't need to. Thank you. Best of luck to you, sir.
Judge, that is all I have. May I be excused?
Yes, ma'am.
Most of the time when I'm commenting on these, I don't know what the ending's going to be. I kind of watch them and comment as they're going because I think it's more entertaining that way. So I was kind of surprised when this just ended. I was like, WTF, where's the bond? Anyways, so I looked it up, and the reason she's not asking for bond is because he has 2 charges that are in front of Judge McBurney, which are SE battery convictions, second or subsequent convictions that are felonies that he's being held on. It looks like there was a $20,000 cash bond. I could be wrong. I can't find it again at the moment. So that is in front of Judge McBurney. So he's not going anywhere on that. And so this doesn't really matter. So anyways, have a great day.
Stephen Herman. Mr. Herman, can you hear me?
Yes, sir, I can.
All right, we're having a court hearing and thousands of people are watching you eat. So you might want to conduct yourself as though you're actually in a court proceeding.
Last Friday, we met Lindsay. A friend let her crash at their place. It was supposed to be a short period of time, and months later, he's having to go through the whole court process to try and get her out of his house. He's had to move elsewhere. If you already saw this one, I'm going to skip forward, go to about 4.5 minutes.
Ms. Geib is here. I went through the advice of rights with her a few minutes ago. This is filed as a termination of tenancy. You guys are all in the same house at Depot Street in Constantine. Mr. Herman, your position is you want her to move out? I had you. Can you hear me? Now your microphone is on mute somehow. I had you better the first time.
Yeah, use this.
Can you hear me now?
Yeah, I can hear you now.
All right. Well, you got 2 things on, so we got a sound loop.
Okay. Okay. I've got you with just a cell phone.
Very good. So you want her to move? Correct?
Yes, I would like her to move out.
Ms. Guy, what's your position?
We're doing everything we can to find a place and move out.
Are you related?
No.
No, we were friends.
Well, let me advise both of you that the law requires that I continue this matter for 7 days. So I'm going to continue it to October 20th, 23 at 10:50. Now, Ms. Guy, if they get what they asked for, you would have 7 days from that day to move out, or you would be subject to being evicted. So that would be till October 30th. But he's trying to do this the right way. Some people say, I'm gonna throw your stuff out in the street. Well, you can't, you're a tenant. And he's been trying to get you out since July. The notice to quit was filed in July. We're gonna be almost to November. So the truth of the matter is they'd never move unless there was a legal process to force it. So, and the Supreme Court now says you get an additional 7 days before your 10 days. So, that's just what it is. So if you're not out by the 30th and he gets what he asked for, the sheriff could come put your stuff out. You say we, who else is there with you?
My 2 boys.
How old are they?
9 and 4.
All right. Mr. Herman, anything else you wish to say?
Your Honor, I technically have not been living in that house since the 9th of July. I have actually been forced out due to the fact that I felt unsafe in that house with her being there. I have been forced out since the 9th of July.
All right. Well, that does not seem fair. You're living in his house and not paying any rent and not being very active about trying to move. So you got 7 days and we'll address it, and then you'll have 10 days from then. This is not about money damages. It's about possession. Now, if you do move, you need to turn in the keys and give your forwarding address in writing within 4 days of your moving, but he wants his house back. And so let's see what we can accomplish. Ms. Guy, do you have any questions?
No, Your Honor.
All right, I'll see you next Friday at 10:50. If you move before then, you don't need to show up. But if you're still
Do I
there,
use the same meeting ID next Friday?
correct. We'll send you a new notice, but it's the same address. You were here early, which I appreciate, and you had a good signal. So I'll see you next Friday the same way.
All right. Thank you.
All right, thank you. All right.
1 week later, they're back. And no, she hasn't moved. And yes, she has some complaints about the conditions.
All right, we're on the home stretch here. All right, our next matter is Stephen Herman versus Lindsay Geib. File number is 231182. We were here last week. This is a similar circumstance. Mr. Herman wishes to terminate the tenancy. There is no lease. Ms. Geib is there. He's not being able to be in his own home, and he wants it back. And he's following the lawful steps to do that. Is that correct, Mr. Herman? You still wish your premises back?
Yes, sir.
Ms. Geib, what's your position?
I have apartment applications out for apartments. The shelter says they're full and they're offering me resources I haven't got yet. We're trying to get out the best we can. It would be nice if he could turn the heat back on for the remainder of this process. I don't think that was probably the nicest thing to do in this situation.
All right, what's the circumstance there?
What do you mean, sir?
He turned the heat off?
Yeah, to the house.
What's the story on that, Mr. Herman?
Well, I don't understand that. I mean, I was over there probably a few weeks ago and I thought the temperature was up a bit high, so I turned it down. And last time I was there, the thermostat said the heat was at 67 degrees. But the actual temperature in the room was even higher because she has a space heater in the room. So the heat from the space heater is reacting with the thermostat to the furnace, possibly not causing the furnace to turn on.
All
Sir,
right, well,
Not
stop.
moved in 1 week. The meter.
What's that?
on the meter on the Semco thing, the reader, the meter, the numbers, they have not moved in 1 week. I had somebody look at the furnace. The furnace is fine. It is very cold in there without that space heater on. It gets
You
down to
believe
about
you
59.
believe the gas is shut off?
Yes, sir, I do. I didn't until 2 nights ago when I realized that the numbers hadn't moved. And he come in Sunday and he saw and he felt how cold it was. He was in the upstairs where it's got to be cold.
Is there a gas stove or gas water heater?
No, just the heat is run on the gas.
Who is paying the Semco bill?
I am, Your Honor.
So he has to pay your gas bill while you live in his house?
I'd offer if he'd asked, but he hasn't asked.
Well, to shut off the heat violates the lockout law. So if there is no heat, you need to turn it back on. But you have 10 days to move out. You have 10 days from today, which is October 30th. No money judgment is entered here. Proper payment, or that's it. You have until 10:30 to appeal it. That's 10:30. You shall restore heat.
Yes, Your Honor. I will look at that situation and find out what happened and make sure that heat is restored.
She's got 10 days to vacate or you get your house back. She does not vacate, you can bring $15 to the court and ask for a writ of eviction. Ms. Geib, when you do move, you need to turn in your keys. And give your forwarding address in writing within 4 days. Mr. Herman, have you got a shut-off notice?
I don't believe so. No, I haven't seen one.
Have you seen one, Ms. Geib?
No, sir. I've not gotten anything on the door either. Like, I don't know if they still do that, but they used to.
No, they're supposed to. At any rate, you've got 10 days to vacate, and he's got to make sure there's heat in the house in the meantime.
Thank you.
All right, hopefully you can get out and he can get his premises back and you can go your separate ways. If there is going to be a claim for money damages, it would be in some subsequent hearing, like a small claims proceeding. All right, you're both free to go.
Last week, we saw the case of the couple who was trying to get the woman who had shacked up in an RV on their property and was trashing the place off their property. And it wasn't working. But they're back this week. Things are a little different. But first, we'll rewatch last week. If you don't want to rewatch last week, jump ahead to about 10 minutes.
All right, Ms. Schemenauer, can you hear me?
Yes, sir. Yes, sir.
All right, several issues. I want you to stop drinking and smoking while we're on the feed here. And you're right in front of a window, so I can't see you very well. All right, that's a little better. Thank you. This is file 231216. LT. This is a termination of tenancy. Tim and Sally Jackson are here. They indicate that you've got a camper parked behind their mobile home and you're living in it, and the township isn't gonna let you do that. And they want you to move. Am I correct, Mr. and Mrs. Jackson? She has a camper parked on your property on Balk Road?
Yes.
How did it come to be there?
Well, she didn't have a place to stay, and I was trying to help her. I give her the choice of living in our home. I told her if she lived in our home, she didn't have to pay any electric or anything, but I couldn't afford for her to live in that camper and pay for her electric and things. And no, she insisted that she wanted to be in that camper, and now I'm paying for her electric. And then she's got trash all over and clothes all over. I told her I didn't want her in, that she would have to be happy in that camper only. That I did not want her in that mobile home or shed.
All right, well, slow down. Does she pay any rent?
No, nothing. We're paying. We tried to turn the electric off and locked the mobile home, and she broke in and got back on our electric.
Well, you can't do that. That violates the landlord-tenant lockout law. So you're going through the lawful process to have her move. Now, also the township isn't, I think that's Sherman Township. They are gonna let you have someone living in a camper on your property. So there are some zoning issues also, but we haven't gotten to that point yet. Ms. Schemenauer, they want you and your trailer to move. What's your position?
I just need a little bit of time to find to get someone to move it and to take it somewhere. And it was hard for me to get things moved because they kept saying that they were going to call the police on me if I were out there, and they shut my electric and my water off. So that's made it more difficult for me to go, but I just need a little bit of time and I will go.
All right, is your electric and water off now?
No.
No, it's been going for a while. We've been paying for it for the last few months now.
I had
All right, they've asked you to move since July, and you haven't had any luck. It would have been a lot easier to do this in the summertime.
Well, they kept changing their mind. They didn't say in July, like for sure for me.
All right, what do you have for bathroom facilities?
There's a bathroom in my camper.
Are you having it pumped?
No, it goes in a
holding tank.
Yeah.
Yeah, which must be about full. So at this point, I'm going to continue this matter until 11 a.m. next Friday. That'll be 10/20/23 at 11 a.m. We got a lot of cases next Friday also. And then if they get what they asked for, you would have 10 days from that date to move, or you would be subject to being evicted. This goes under the category of no good deed goes unpunished. So they let you move in there. Now they're paying your electricity. You're not getting any rent, and they're on the bad side of the township for having an unlawful residency on their property. So you should make every effort to move and the trailer. So you would actually get 10 days from October 20th, which would be October 30th, to move everything out, you and the trailer. So have you made any effort to find a place to go?
I have I had a friend that says that I could stay, but of course he's male, and me being female, it's not so easy.
Well, what type of trailer is this?
It's a camper.
It's just
It's
a How big is
Yes.
it?
Probably 30 foot.
Do you have something to tow it with?
That's another problem, finding someone to move it for me. And I know that if I leave without my camper, they will, I'll lose it. And I don't have anything
All right, well,
else.
does it have air in the tires? Could somebody back up and pull it out of there?
Yeah, it's just finding someone with a vehicle that's able to tow it.
Well, they've asked you to do that since July, and now it's more imminent than it was. We're gonna continue this for 7 days, then you'd have 10 days from that. So you have 17 days to get it out of there, or the sheriff will come haul it out of there, and that won't be good for anybody. So see what you can accomplish. At this point, they're not asking for money, they're just asking you to move. They could file a small claims action or something later for money, but this is just about possession. All right, do you have any questions?
No, sir.
Mr. and Mrs. Jackson, we always are open and live, so if you wish to come in next week, like you did this morning, that's fine with me. I leave people in the conference room in case I need to put them in a separate breakout space. But Ms. Schemenauer, you did a good job of logging in. Remember, don't smoke or drink when you're in a court proceeding, but I will see you next Friday unless you move. And if not, we'll address it further next Friday at 11 a.m. Does
Okay.
anybody have any questions?
I do.
Yes.
She has a truck pulled in there. And I don't know if she has a title to it or what, and it's been sitting there, just sitting there. Looks like they've been working on it, but it's been sitting there for a long time and not moving.
All right, well, if we have an eviction, you can have that truck removed also. So if she gets her stuff out of there, if she doesn't, you come back to the court on October 31st with $15 and we'll get her rid of eviction. So Ms. Schemenauer, you should be making every effort to get out of there, at least within the next 17 days.
Yes, sir.
Okay, very good. I'll see you all next.
Everyone's back this week. The camper hasn't been moved, and plot twist, that's her parents.
Ms. Schemenauer, can you hear me?
Yes, sir.
Timothy and Sally Jackson are here. Mr. Jackson, I don't know if you remember me. When you were a kid, didn't you live on 4th Avenue? In Three Rivers?
I think at one time we did live on 4th Avenue, and then for the rest of the time growing up, it was on West Street.
Yes. That was a long time ago,
Long time
about
ago.
60 years ago, but I remember when you were a kid and I was a kid. Ms. Schemenauer, can you hear me?
Yes, yes, Judge.
All right. We were here last week and they want you to get you and your camper out of their property. Have you made any progress?
I have, see, anything that I leave here, I know that I will lose, and I got help from the church to get, because my truck was broke down, and I have put in a head gasket, a new radiator, and right when it was almost finished, I lost the key. So I had a key made on Monday, and it looks like there's some water leaking underneath it, so I think it needs a water pump, and the church said to find out for sure what it is, and they would pay for that part, and it would be a lot easier for me to move if I had a vehicle, and my camper is very large. I plan on moving. I'm not sure where I'm moving to, but I plan on moving. I just wanted to see if there's any way I could get a little more time, because it's a lot. It's a 30-foot camper, and it's a truck, and I have everything in the shed. I've been giving away most of my things and then throwing out others, and I just need a little more time.
All right, well, he's under the gun from the township to get this trailer out of there also.
I understand. I
Um,
figured I wouldn't know unless I asked, but I
okay,
do
well,
know
are
they
you
won't
willing to
be.
give her any more time? They indicate no, Miss Jackson. Now, let me explain a little further. The date for the writ is 10 days from today, which is October 30th. They can do the eviction, but I can tell you, it's gonna be a lot easier for you to move this than for them to hire somebody and just haul it somewhere. So they don't have to evict you on October 30th. Mr. and Mrs. Jackson, you have 56 days from today to ask for the writ.
We don't get rent, sir.
The writ of eviction.
Oh, excuse me.
You don't have to evict her on October 30th. Sergeant Morse could come out as the sheriff and move her. But you're gonna have to hire somebody to haul the trailer out of there, move all of her stuff. And it frankly would be easier to let her move it herself. But by the letter of the law, on or after October 30th,
I'll be back in a little
you can
bit.
ask for a writ of eviction to have her removed. Now, you have to ask for that writ within 56 days.
Okay.
So I certainly would, whatever you do, you should do it by Thanksgiving. But it's about to get very cold. You're gonna have a hard time finding a place to put this. They're under pressure from the township because they aren't supposed to have this on their property. You wish to move, but you're having difficulties doing it. The order I just entered says you have until October 30th to move or you're subject to being evicted.
So what does that
Mr. and
mean?
Mrs. It means if you don't move by October 30th, they can call the sheriff and have him come put your stuff out. But they have to pay for that. So they would have to pay someone to come haul your trailer out of there and then give you the bill, which will be very difficult to collect on. So they have some discretion in the matter, but at some point their patience is wearing out. And as I mentioned, they're under the threat from the township. So my point is you should make every effort to get that out of there and get your possessions out of there within the next 10 days. If you can't get your truck fixed, maybe you can hire somebody to come pull it out of there. Then move your truck. But if push comes to shove and it's not out of there, they can have it removed and put who knows where. So my advice is the same. Make every effort to get it out of there. This is another tenant. We had several of these today where somebody tried to help out somebody else and it just didn't work out for either side. All right, Mr. and Mrs. Jackson, if you go out to the counter, we'll give you a copy of the order. All right, let me repeat this. You have until the 30th of October to move or you're subject to being evicted. You don't have to evict her on October 30th. You have 56 days from today to ask for the writ of eviction, which would be sometime in early December. And if you do it, it's going to cost you to get her property out of there. The sheriff doesn't pay it. Then you can sue her for the money, but you're going to have difficulty collecting any money from her. So as a practical matter, it's probably easier to wait for her to get it out of there. But those are your options. Yes?
If I am no longer residing here, if I don't stay the night here anymore, wouldn't my parents be willing to give me more time to move the camper?
Well, that's between you and them. But they're still under the gun from the township. If no one's living in there and it's properly licensed, I believe you can store it, but I'm not sure what this property looks like. If no one's living in it, you can have a camper trailer on your property as long as it's plated. You can't have a camper trailer on your property and have someone live in it. At least not in most townships here in St. Joe County. All right, you ought to be able to speak to each other, your mother and father and daughter, but at some point you need to get this out of there. All right.
Ask a question?
Yes,
How much does it cost to have the sheriff haul it out of there?
hundreds of dollars. The sheriff doesn't do it. They would get a contractor and they'd come do it and they'd have to hire somebody to do it. So I can't answer that. Sergeant Morse may be able to answer it.
Yeah, because meanwhile, we're paying for electric.
I understand. All right, if you go out to the counter, you'll get a copy of this, and Ms. Schemenauer, I hope you can find a place to move this to.
Yes, sir. Thank you.
Okay. All right, the clerk will give you a copy of this. You got some tough choices to make. But I'm gonna give you what you asked for. She has 10 days to move or she's subject to being evicted. Okay.
That carries out, that could go out beyond that to a point.
Up to 56 days.
Okay.
All right.
So this is a dog bite case that gets pretty interesting. It's been going on for more than a year and has some interesting legal entanglements that have been tying it up, as well as a demand for a jury trial. So this is Miss McSwain, our defendant. She shows up for a second, then disappears and lets her attorney handle everything, which is good because she missed several hearings in the past. At least she showed up for this one. She likes dogs, but she doesn't like following the rules regarding her dogs. This dates back to June of 2022, when she received citations from the city of Detroit for allowing a dog to stray in a public-private property without a leash, failure to vaccinate, and not having a license for her animal. Then, on 10/13 of 2022, failure to register the animal, failure to vaccinate, and failure to prevent the animal from engaging in nuisance or menacing behavior, which generally means that the dog was aggressive towards someone. Several days later, on the 20th, she received citations for harboring a vicious animal, 2 of those, failure to surrender an animal for rabies observation after a bite, and harboring 2 or more animals over the age of 4 months. Those October citations are what we are here for. As you can see, there have been quite a few hearings on this case already, and there is actually a jury trial scheduled for February of next year. But we have 2 motion hearings before that, so here we go.
Attorney Darrell, where this is the most, where are we?
Judge, we'll take your February jury trial date.
February jury trial date. All right.
So are we still having a motion hearing on the 26th?
Yeah, I'm sure we are. We're still all set for the 26th for the motion, correct?
Correct.
I don't understand what the motion would be. My client gets a hearing and we're setting it for the February date. I don't understand what would be.
Actually, I thought there were some things that wanted to be worked out with regard to your client testifying or speaking at the hearing prior to trial, and that whatever he testified to at that hearing, he would not be held against him at a trial, or some things that we were discussing earlier. So I'm not sure where we are now. If you said,
well, okay, Judge, I'm sorry. This is how I understood it. That Miss Rogers and I would work out an order. I suggested the language in the civil forfeiture MCL 75050. If we can't work that language out, we have enough time to file a motion to have you resolve it or settle that order or that issue. And then we would just need new witness list, exhibit list, exchange dates. She's getting her hearing
to euthanize the dog, it would be in February in front of a jury.
But no, counsel. So this is it's a motion, it's an evidentiary hearing. It's a question of law. If it's risen to a dangerous dog level, that should be determined by a judge. There's no right to a jury and for this. We're looking if the dog is dangerous and if it should be euthanized. Of course, the underlining criminal matters that are all misdemeanors, of course, there's a right to a jury on that, and we can do that in February. But the hearing regarding the dog being dangerous, there's no right to a jury on that. The judge needs to decide that per the ordinance.
Well, this is the problem, Judge, is the way the city does these is they don't file a civil action. They're doing them within criminal cases. And this is a criminal case. It's in a criminal case number. My client gets a right to a jury.
So there's two different
motion.
things. Hold on. No, there's two different things. Your client has a right to a trial regarding her criminality. She does not have a right to make a determination if the dog should be euthanized. That is not a criminal case there. The criminal case, she has a right to a trial for. The determination if the dog is dangerous is not a criminal matter. That is a hearing that's going to make a determination where I get to make a determination if the dog is dangerous or not. The dog doesn't have a right to a jury trial.
Okay, then Your Honor, then the 26th would be the evidentiary hearing or trial of whether the dog should be deemed dangerous.
Yes.
Okay.
Yes. And then, and your jury, wait a minute. So, okay, now I'm getting my dates confused because we're bouncing around here. So, all right. The evidentiary hearing was going to be on what date, Madam Prosecutor? And we'll see if we agree with that based on, this is, the evidentiary hearing was what date we talked about?
October 26th, Your Honor, in person.
Yes, October 26th. And then we talked about a jury date on February the 29th for Ms. McSwain, correct?
Correct, Judge.
Yes. All right. Now, are we clear what we're doing on each date?
It is, Your Honor. I just want to make the record clear then, just for any appellate purposes, that when I said you're right on the February jury trial date, I was requesting that my client have a jury trial for the dangerous dog determination, and you've ruled no. You're going to do it.
Well, those are two different determinations because that is not a jury trial.
Okay, understood. I just want to make sure that I was clear. I wasn't agreeing with you, with all due respect.
Okay, all right. Now, with our jury trial date, we always have a week before that jury trial date, a pre-trial date of February the 22nd. And we do that to make sure that everything is set. The jury has been notified. We're going to be here and we're going to be ready. So that's just a final check to make sure that on jury trial date, we don't have a snafu and juries aren't going to be here and things like that, or we don't have enough jurors or something of that nature. So we do that the week before at 9 or 8:30, Madam Clerk.
Final pretrial is at 9 o'clock.
At 9 o'clock. So on February the 22nd, we'll have our final pretrial, which is the pretrial before a jury trial date at 9 o'clock. And that's just to ensure we're all set.
Okay, got it, Judge.
On Zoom.
What'd you say, Madam Clerk?
Final trial is on Zoom.
Oh, yeah. Yeah, our jury trial is going to be obviously in person. The final pretrial is on Zoom, just to ensure that we're all set.
Thank you, Judge.
Thank you.
Yes, thank you, Judge. See everyone on the 26th.
All right. All right, this matter is adjourned.
Thank you. And Ms. Rogers, are you around this afternoon for us to coordinate maybe some language or even?
I am. Feel free to give me a call anytime after 1:30.
Perfect. Thank you. Thank you, Your Honor. Thank you, Ms. Clark.
Thank you.
And then we come to our most recent hearing, and this is where things get interesting.
So, do I have these? All right. I guess I am totally confused with this defendant India McSwain case. Is this?
Your reporter might need a break before you get started. I'm fine, thank you.
Oh, I know. We got. All right. This is parties are joining. Okay. All right, let's see what we have today. Well, let's call this case. This is case number V128818220M. City of Detroit. Wait a minute, is Miss Rogers? Yes, Miss Rogers is out here. The City of Detroit is the plaintiff. Defendant is India McSwain, who is represented by Miss Celeste Dunn, Esquire. Then I have something else that just came before us. Intervening party motion. This is obviously the same case number. We now have the attorney, an intervening party attorney. Is that David Draper?
That's right, Your Honor. I'm David Draper. I represent the proposed intervener. His name is Author Jackson. There might be a misspelling there, but it's Author as traditionally spelled, I believe, A-U-T-H-O-R, Jackson. He's not here today. Go ahead, I'm sorry.
All right. Yeah, he has an additional R in it. He has
Sorry about that.
A-U-R-T-R. That's not a problem. A-U-T-H-O-R. Okay.
So, Judge, I know it's a little confusing. If you want to let me go, I'll talk. If you have questions, whatever your pleasure.
Oh, I need you to definitely talk, and because yes, I am very confused at this point.
Okay. So essentially what we've got dog Crunch. Crunch is the dog. There's a criminal case with wife.
Hold on, counsel.
Yeah.
I do need your appearance and P number on the record.
Sorry, David Draper, P43750. I'm representing proposed intervener or Author Jackson with his consent.
Okay, just so I understand, it's Author Jackson, who was somebody who claims to be a co-owner of the dog Crunch?
You've got it. I don't think it's gonna be that confusing, Judge. He's
still
the
gonna be that
husband.
confusing because this has been ongoing now for months and months, and
I
now
know.
I'm hearing there's somebody else who has an interest in this case and the dog. So
Right. So he's married to India McSwain, and she's the lead, or the only defendant in City of Detroit versus India McSwain, the case we're here under. So essentially, this has to do with a bite by dog Crunch. The parties are married. The proposed party, that's Author Jackson and India McSwain, are married, have been married for many years. They own jointly Crunch under the Detroit Municipal Code's definition of owner, which is section 6-1-2. They are both owners of Crunch. So India McSwain comes here on a criminal case to have Crunch put down or euthanized. My client is interested in regards to, as the state would perform something like this, the civil forfeiture, because Crunch is property. And in this case, the city is attempting to take that property or euthanize Crunch. So Author Jackson's argument is, I'm an owner of Crunch. I hadn't been notified of this. I haven't been a party to either proceeding. So in order to euthanize, there's got to be two incidents with a dog bite. In this type of case, there was a prior incident that Author Jackson was not party to, and in order to euthanize, there's got to be both. So I know it's confusing, but the argument on behalf of Jackson is, hey, I'm an owner. I'm sorry. Go ahead. I'm sorry.
well, it's not confusing what you're stating. What's confusing to me is a case that's probably going on a year at now in an interested party. Suddenly, the dog hasn't lived with him. He hasn't been, because I know the dog was taken to a facility someplace, I don't know where, for someone who is capable and skilled in handling dogs that have shown a propensity for being dangerous. And so if he and the initial defendant are married, and I'm just wondering, where has he been for the last number of months?
Oh, Your Honor, if I could briefly address that. I did highlight to the court and tried to bring him in through Miss McSwain, and the court denied that. That was roughly in March of 2023. So he's been there, and I've highlighted that to the city on numerous occasions, but they've fought me on that. And I think it's because they don't have the first administrative hearing against him. There's other issues there, but just to remind the court, Your Honor.
To break that down real quick, in the past, Ms. McSwain received some kind of violation for the dog biting someone. It went through the court process. It was documented. It was only under her name. In order to have a dog euthanized, you have to have 2 documented incidents under that owner's name. They're trying to find a loophole that says, well, if we bring this other person in, he doesn't have that first documented incident. So there's only one, so you can't euthanize him.
Okay, this has been going on for a long time, and I certainly don't remember at this time that there was somebody else who was coming in to be claiming to be an owner, and I would have denied that. But if you say that's what occurred, I'm not going to argue that. So certainly we are where we are today. So.
So the court, I think, sees you see the issues, and he's just asking to have his due process rights, that he would have in this property. And it's our understanding under the law that all parties that own property must be notified, must be part of the proceedings. He isn't, or hasn't been, and now wants to be. And I think he should be. But I also think,
which means he also opens himself up for any lawsuits that might be claimed for any injury that his dog has provided. I certainly don't have a problem with it, but I certainly kind of question why somebody would be putting themselves in a position that we're not there, where somebody who's suing the dog owner for a bite and for medical injury or distress or anything else someone might come up with for a reason to claim a dog owner.
And I think that just goes to show, Judge, how much he loves and cherishes the dog and wants to be part of this, regardless of potential civil liability. So he's an owner. He wants to be seen as an owner and wants whatever he can do to protect the dog.
Interestingly, on 10/14, the same day that Miss McSwain received her citations, Mr. McSwain also received quite a few citations, 7 to be exact, 4 tether violations, failure to vaccinate, failure to register, and an animal cruelty for failure to provide water, shelter, sanitation, medical, or food for the animal. Sounds like a loving owner.
All right, Attorney Rogers.
Yes, thank you. The city is objecting to Mr. Jackson being added as a party to this matter. As the court has said, this matter has been going on for a long time. I filed my motion for the dangerous dog hearing and to euthanize the dog over a year ago at this point. The motion has been pending this whole time because defense had motions. We transported the dog. There's been a lot of procedures going on in between. Mr. Jackson had that entire time to intervene. And also, Mr. Jackson has never asserted himself to Detroit Animal Care and Control as the owner of this dog. Only Miss McSwan ever has. That's why she is the named defendant here. And that is why she's the only one included on this. In June of 2020, there was a dangerous dog checklist that only Miss McSwan signed, saying that she understood the conditions that Crunch had to live under to be at the home after the first bite. No other owner is on that. At one point, she did attempt to get the dog license. It's only under her name. And then when the dog was deemed dangerous in October of 2022, once again, it was only addressed to Miss McSwan, and she was the only one that signed for it. The city was not aware of Mr. Jackson asserting himself as the owner of Crunch in particular. Mr. Jackson does have his own criminal cases also involving dogs, but these were different dogs. Same property, but different location or different dogs. He made assertions to Detroit Animal Care and Control that he did not own Crunch. And that is why only Ms. McSwan is the named person here. And also, we aren't dealing with a civil forfeiture. This is a criminal case under a criminal case number. And this is a motion that is being heard under that criminal case number to euthanize a dog per the City of Detroit ordinances that allow that. We ask that this hearing move forward on October 26th to hear testimony if Crunch should be euthanized per the city's motion that has been pending for almost a year.
Okay. So, Attorney Draper, tell me why I should do anything today that might delay or anything involved in this case where we cannot say your client did not know about this. I can only say the only people that did not know it is the City of Detroit and the prosecution. There has been nothing that has come up. Certainly, there would have been nothing that would have stopped your client from coming forward at any point saying, "Hey, I am a owner of the dog." There is nothing that he's come forward and saying, "Here's some paperwork where I purchased the dog." Simply saying, "Well, by virtue of Ms. McSwain being my wife, therefore I am the part owner of the dog." I don't know that is just going to fly with this kind of, where there's notice for over a year or at least a year that this case has been going on, but there's been no effort to claim any type of part of it. Quite frankly, I'm not sure why that would even is being done. And I think your client has slept on this too long, sir, and I see no reason to allow him to intervene and be a party of this case at this point.
Thank you, Your Honor. I understand the delay argument, and I apologize. It's not the intent to slow down the process or justice. And I appreciate the court's position and understand that argument of the city and the court, of course. So is that a ruling, or how should I, whatever the court?
Rule. So if he had some reason where he wanted to be heard on this case, like I said, this is not like, oh, somebody else was involved. This is my wife. I've not heard anything today that said that they were separated and this information was kept for him, and he's now aware of it and he wants to be a part, and he wants to be part of the fight to protect his property. I have nothing that just says, well, I'm not doing anything until the 12th hour, and I'm going to want to intervene as a party in this case. No, this is late. People had no notice of it, and I'm not sure exactly what the purpose and how it went, but I'm not going to allow him to join in at this point in time.
Thank you, Your Honor. And I'm not going to make representations to the court that I don't know to be true. I can't do that, obviously. So I would accept. Thank you for the court's ruling.
Thank you.
Okay, if I could just add to the record, Your Honor, I included, the city had absolute notice. Mr. Jackson is on the police reports. And I, on my motion dated December 9th, 2022, informed them of author Jackson's ownership. And the reason they fought it, and it's just for the record, Your Honor, last point, is they fought it is because they have no administrative determination, which is time barred by the statute of limitations, against Mr. Jackson. And the records replete, they knew he was an owner. Thank you, Judge.
Ms. Rogers?
The city was aware of Mr. Jackson, that he was at the property, owned dogs at the property, but the city was not aware that Mr. Jackson owned Crunch. He asserted himself as the owner of, I believe, 4 other dogs at the property, not Crunch. Ms. McSwan only inserted herself as the owner of Crunch.
Your Honor, the records don't reflect that, but.
All right. I've ruled on that matter. So,
Thank you very much, Your Honor. Thank you, counsel. Everyone have an excellent day.
Thank you.
Thank you, Judge.
No, just additional on the record, we've been to court maybe 6 times on this matter, and this is the first I've heard of Mr. Arthur Jackson. So, all right. Court ruling stands now.
Thank you, Your Honor.
Your Honor,
right.
last thing, if we can have a moment, this is not on the motion. Miss Rogers and I got her witness exhibit list yesterday. She'll have mine today. They're due today. I also had in a note that you may want a trial brief, but Miss Rogers wasn't sure, and I wanted to make sure. I may have misunderstood. Did the court want us to file trial briefs as well?
That would be helpful, yes.
Okay, and when would the court like the trial briefs?
Do we have a trial date yet?
That's 2
I don't
weeks.
remember.
Well,
Yeah.
so we do have a trial date, I believe it's in February, but we have a dangerous dog motion hearing on October 26th.
That's a trial, Judge. This is a civil forfeiture action.
It is not a civil forfeiture action, it's a motion hearing. This is a criminal case.
It has to be Judge, the process is a civil forfeiture, but it's neither here nor there. We have it for the 26th.
All right, the 26th of
October.
Okay. I need how much time do you need to submit the brief?
I mean, I could do it next week, Judge, if that works for Ms. Rogers, maybe by next Thursday, so that it would give the court a week, if that's enough time for the court.
Actually, unless it's 400 pages, I just need it the day before.
Okay. It won't be, mine won't.
Oh.
If I could have mine in the week of the 23rd, I start a jury trial next week. So next week I'm going to be a little jammed up.
And that would be fine with me, Judge, just so.
That's fine. I don't want to stress you. Long as I have it a day or two before you're going to be arguing, that's all I really need. So
I do have a question on what the issue that needs to be briefed.
Counsel, if quite frankly, I think I pretty much know the case, so I'm not really sure that I actually need a brief. But if sometimes the attorneys like to submit one so they can outline their argument clearly and then just kind of refer to that when they're doing their argument, as opposed to just doing it all in before the court. That's kind of up to you. I'm kind of flexible.
Okay, the people have essentially already done that in our motion hearing, our filed motion that wasn't heard yet. So I believe the people will not need to brief anything additional.
There's nothing additional that needs to be said, counsel. That's kind of up to you now. If there's something that you want to highlight and, put in red, bold, with stars around it for me to see, that's kind of up to you.
Okay, Your Honor. So optional, and then if I'll file it on October the 24th, 2 days before the hearing, if I decide to do that.
That would be fine, because then if Ms. Rogers wants to look at it and say, hey, you know what, I kind of want to respond to this, you'll have time to do so.
Okay.
Great, thank you.
Thank you, Your Honor.
And I have one more question. Is this a Zoom hearing or in person on the 26th?
I'm requesting an in-person, Your Honor.
Okay, I couldn't remember.
You're requesting in person, we certainly will do that. You have that right to do so.
Thank you, Judge.
Thank you, Your Honor.
Thank you, counsel. Madam Clerk, we're gonna have this in person on, do you know what our 26 looks like?
Your Honor, can I exit with all due respect since I'm not party? Is that okay?
Yes, sir.
Okay. Thank you so much, and thanks to your staff.
All right.
It's already scheduled for the 26th. I just don't remember whether I have to check it now and see what that originally scheduled for in person. I don't know if that's what we originally agreed upon, but I'm about to check it.
But the docket is a big that day. So
no, I mean it was
no,
already
that's
open.
fine. I'll let them do it now in person.
Yeah, it's scheduled for the first part. Well, no, wait. The motion hearing wasn't, but that's fine.
And that's a Thursday.
Yeah.
Okay. All right. We're good. We can do this in person on the 26th.
Okay.
And what
not a
time is
concern.
it at?
That's
Let's do 10 o'clock, because hopefully we'll be finished with our morning docket by then.
10 a.m.
Works for the
That good?
people.
Yep, 10
That good
a.m.
with you?
Sorry.
Thank you. Well, I'll get to see you in person, Council, so we'll see you on that date.
Sounds good. Thank you very much.
All right. See everyone on the 26th. I'm sure I'll talk to you before then, Miss Dunn.
Okay, sounds good, Ms.
All right. Thank you.
All right, thank you, everybody. Have a good day.
All right. See you guys. Have a good one. See you tomorrow.
On the supplemental, People versus Devin Martinez, 23-626 FH, 23-635 FH.
Travel last for the people.
Hi, Ms. Martinez.
Hi there.
Okay, so we are here today for pretrial. And bond violation hearing.
That's correct, Your Honor.
City.
I'm going to ask to adjourn the pretrial and address the issue of bond.
Okay, go ahead.
So, Your Honor, I did have an opportunity to meet with Ms. Martinez yesterday at the jail. There are a number of things that she's very concerned about. First of all, when she was arrested on this warrant, she indicated to me that her car and the vehicle belonging to her and her boyfriend was impounded. All of their worldly possessions are in that car. That is their source of internet. Without that, both she and her boyfriend are in serious jeopardy. So she is very, very anxious to secure her release so that she can work towards recovering that vehicle and their possessions. Additionally, her grandmother had her gallbladder taken out very recently, and Ms. Martinez has been informed that her family needs her home to help provide care for her grandmother. Finally, on September 18th, she indicated that she called the public defender's office. She was asking for the Zoom information. She indicated she was told that there was no Zoom information because it was an in-person hearing, so she was not able to appear. She does accept her responsibility for missing court on that date, but she did at least call our office and make an attempt to appear by Zoom. She was arrested on the warrant because she had gone to a friend's house very early in the morning to ask for a ride to come and turn herself in. But because it was so early, she was just waiting on the porch because she knows her friend wakes up around 7 and will come out to have a cigarette. Someone saw her sitting on the porch. They called for a wellness check. The police appeared. She was arrested and the car was impounded. She indicated to me she's seeing a new therapist through CMH she's been referred to. She's also had contact with an outreach worker. She has support in the area. She's not a flight risk. She's trying to get back to work. She was working as a personal assistant at a chauffeur company called Azo Party. So she did have employment. She'll be residing in Ypsilanti. She's provided me with the contact information that she has. So I would ask the court to consider releasing her on a personal recognizance so that she can work on the things that she needs to work on because they are very urgent.
As well as rent, if I may just add, I'm sorry.
As well as her rent, Your Honor.
Mr. Prosecutor.
Yeah, I'm seeing multiple failures to appear throughout the history of these cases. I just want to point that out for the court. I think some level of assurances that she appears necessary. So I'd leave it to the court.
You have a resident she can
She's provided an address, Your Honor, so,
Yes.
Your Honor, may counsel approach?
Ms. Martinez, come back.
Yeah.
How much time do you want?
Judge, I'm going to need 2 to 3 weeks. I anticipate a social work referral. I need to confer with our juvenile attorneys to get some background information, as well as to talk to Mr. Chavalowski about how to proceed. And then I'm going to need some meetings with Ms. Martinez.
Ms. Martinez, I'm going to schedule your pretrial for November 6th at 1:30 p.m. You're going to stay remanded. You have too many failures to appear.
No,
Last
Your Honor,
time that-
Your Honor.
No, last time that you were in front of me, I'm like, I talked to you about coming in and you're like, yeah, no problem. And it was really
No, it
dismissive
wasn't
about
a
it.
problem
And
then.
then you didn't, you didn't show up at all. And
It certainly
I'm
wasn't.
not confident that you're going to come back. You have a multitude between this court and district court of failures to appear. You don't come when you're ordered to come. So why would I think this would change now?
Your Honor, because there
So
are a number
on
of.
11/6 of 2023 at 1:30 p.m., you'll be back for your court date. Thank you.
Really, there's nothing I can say.
Mr. Overwater, your client.
Ms. Martinez, I don't recommend you saying anything else. I don't think it's going to change the court's mind. The court's made its ruling. I will come see you. I'll have a social worker come see you. We'll work on getting you out, but you're not going to help yourself if you say anything else.
Seriously, there's nothing I can say on account of I have a job to get back to. I have bills to pay. I also have a car to unimpound, and there's nobody else who can do it except for me. And
Ms. Martinez, you would have had that opportunity had you had just come to court.
Yes, Your Honor, I understand.
At any of the number of times, the handful, the dozens of times that you were supposed to come and you didn't come before. And if it had just been one failure to appear, I would not have thought it was much to worry about. But there's more than one. You're done. We're done today. Thank you.
Okay.
Number 29.
When I first watched this hearing, I thought, some interesting motions. Then I realized the backstory was way more interesting. So this is BJ Brown. He lived in New Orleans with his on-again, off-again girlfriend, Cassandra Jones. She's shown here, beautiful woman with her 3 beautiful daughters. They had a tumultuous relationship. She filed a restraining order in the past, but didn't show up to court to finalize it.
Fox 8 has obtained a copy of the 25-page temporary restraining order Jones filed in May. It alleges Brown punched, choked, shoved, kicked, threatened, intimidated, and sexually abused her, along with mental, emotional, and financial abuse. It details an early morning incident, April 27th, around 3:30, when Brown allegedly came over and they began to fight. Jones says she told him to get out, and he hit her with a belt several times, bruising her. 911 was called, and Jones says Brown punched her and threw her to the ground, stomping on her. Once police arrived, she says Brown jumped off of her upstairs balcony to escape. After the officers left, she says he got back into her apartment where they continued to fight, and he tried to smother her with a pillow. She also alleged there was another occasion where she confronted him about cheating on her, and he punched her, knocking her teeth out. However, Jones never showed up to court to follow through with the restraining order.
She worked for the clerk of courts, and the story of how she got the job is pretty awesome.
First City Court Clerk Austin Baudon hired Jones about a year ago. He met her when she was seeking emergency rental assistance, but what she really wanted was a job, and he saw her potential.
We sat and we talked, and she had the attributes that I was looking for. She had the computer skills, she had people skills, and I saw somebody who was looking not for a handout, they wanted to work.
The morning of the incident, Cassandra was in the parking lot near her car getting ready to leave for work. Around the same time, a resident in a second-floor apartment heard what he thought was a gunshot. He looked out the window and saw a man walking across the parking lot with a gun in his hand. He started filming on his cell phone. He saw the man walk across the parking lot to a woman who was lying on the ground, already shot in the back, and shoot her 2 more times. I'm not sure if he called the police immediately, but he uploaded the video to social media, and of course, it went viral.
Right now, the search continues for a man New Orleans police say shot and killed a woman on Iberville Street, then drove to Middle Tennessee.
After the incident, Jones traveled from New Orleans straight up to Tennessee, about 500 miles away. It was there that an officer tried to pull him over.
Then Monday night, that's when Brown was pulled over just off 149 here in Aaron for a traffic stop. Now, we obtained this surveillance video where you can see Brown firing several shots at an Aaron police officer while the officer was still in his patrol car. The officer also firing back shots as Brown runs away with his handgun. That's the last time we saw him on camera.
So then the manhunt ensued across the state of Tennessee.
We will not rest until he's captured, justice is served, whether it be by a jury or Jesus.
This is the first time we've experienced this within our department. We're a 6-man department.
Aaron Police Chief Mark Moore said Brown ran into the woods after the shooting. A 30-plus hour statewide manhunt led to Brown's arrest early Wednesday morning in Tennessee.
I'm overjoyed.
And I'm not surprised he would open fire on a police officer.
Brown is no stranger to St. John the Baptist Parish Sheriff Mike Trigg. He says since 2010, his deputies have arrested Brown more than 15 times for crimes involving drugs, weapons, and high-speed pursuit.
This hearing that we're going to look at, Jones is facing the attempted murder charge of the police officer. They're trying to rush the hearing and get it done as soon as possible so that they can transport him back to New Orleans so he can answer for his crimes there. And the family of Cassandra Jones can finally get justice.
Said in a statement, Cassandra was a vibrant lady who was loved by many people. She had a personality that would definitely light up a room. Our hearts have been ripped apart. She meant the world to us.
So this is the motion hearing in the B.J. Brown case in front of Judge David Wolf.
All right, this is the state of Tennessee versus B.J. Brown. It is a Houston County case originating in the Circuit Court of Houston County, wherein the defendant is charged with attempted first-degree murder. The parties, by agreement, have transferred venue to Dixon County, Tennessee, and we are now set for trial on Thursday of this week. And the defense has filed a number of different motions. So, Mr. Spratt, we're going to let you take them up in the order that you filed them.
Yes, sir.
I think some of these are not contested from what I understand.
Right, Judge, which would probably necessitate me going a little bit out of order.
That's right.
Motion number 5, I filed motions 4, 5, 6, 7, and 8. Motion number 5 is a motion to have the case declared extended and complex. The state has no issue with that motion. I would just ask that the court allow me, based on the allegations in the motion, to submit an order of finding of undue hardship and extended complex under the rule for funding on that.
I don't have a problem with declaring it extended and complex.
Okay. So that would take care of number 5. Number 6, right. Number 6, Judge, when we litigate motion number 4 shortly, motions 6 and 7 were filed in a direct response to the motion number 4 with the PowerPoint, but the state has said again that they do not plan to call any witnesses from the U.S. Marshals or the New Orleans Police Department in this case. There's a standing order from this court that was agreed to by the state to not reference anything that happened in New Orleans. So when I got the piece of what they call evidence that triggered me to file motion number 4, I then filed motions 6 and 7.
And your motions were based upon the fact that the PowerPoint presentation that was presented to you by the state had reference to events occurring in Louisiana and the defendant's location, and it also referenced a crime scene there, where I think the defendant was maybe charged or is at least accused of a murder in Louisiana.
That's correct, Your Honor. And from my understanding, they're agreeing to motions 6 and 7.
I want to clarify that obviously if they're using a PowerPoint showing his movements, then I want to hear from the state about what their intentions are. I mean, I understand they're not intending to use the evidence of witnesses or police department, but if they're going to use the PowerPoint, we need to kind of figure out what we're going to do about that. So let me hear from Mr. Crouch or Mr. Turnbow about that particular point.
Judge, if I may briefly say something about that before they respond. That does say crime scene right there in the middle of the PowerPoint, but I don't understand the relevance of his movements up until the time of the events that are alleged to have occurred in Houston County, just under a general relevance objection, as well as a potential 403. The venue's been moved in this case once. I think any reference to another state is just asking to make it hard to pick a jury or have an impartial jury. So
wait a minute, you think just the evidence that he was coming from another state would make it hard to get an impartial jury?
Well, I just don't, I mean, there was some news coverage of this case, and I don't see the relevance to it at all. This is alleged to have occurred as a traffic stop. A traffic stop in Houston County. It went about a quarter of a mile, maybe a half a mile, I'm not sure. But that's when everything that he stands accused of in this indictment occurred right there in Houston County. And one of the slides in the PowerPoint triangulates a cell phone as to being at that scene. I certainly think that would be fair game. But I just don't see any need to track that. He's not accused of anything criminally in this state that backs up any farther than that. So I just don't see the relevance in it and the danger of unfair prejudice. I mean, it could easily trigger some memories of news coverage of the case and potentially cause a mistrial or any number of things. So it's not necessary. It's not relevant to any element of any offense that he's charged with here. It's not even remotely relevant to any of it. So
you're arguing your motion without me hearing from the state as to whether or not they agree with you on everything.
They don't agree with me on motion 4. I'm fairly certain. So I'll yield.
Mr. Crouch.
Judge, which motion am I arguing? There's several here. I'm going to start with number 4 because that addresses the PowerPoint specifically. What the state intends to offer is a PowerPoint that charts the pings on the defendant's cell phone as he leaves New Orleans and drives to Aaron, Tennessee. Now, Mr. Spratt was correct. When Agent Valley initially prepared the PowerPoint, he did identify a location in New Orleans as, quote, crime scene. We have removed that from the PowerPoint. We do not intend to have the words crime scene in New Orleans. It's simply a charted plot of all the locations of Mr. Brown as he was driving to Houston County. Here's why that's important and relevant. One, Mr. Spratt said this was simply a traffic stop. But that's not exactly how it went down. There was a traffic stop and then a 2-day manhunt for an unknown person because he was driving in a car that was registered and owned by somebody else. So we didn't have the identity of the person that shot Officer Tiber during the actual manhunt and directly after the shooting. So one, it goes to the identity of the defendant, the person responsible for this crime. 2, it goes to his location and apprehension. I mean, they charted this cell phone to see where he was is at the time and where he might be going. And then finally, it goes to the corroboration of his confession, of parts of his confession, and also to show some of the lies that he told in his confession. So it's, all of the legal issues that Mr. Spratt raises, 401, 402, and 403, are satisfied based on what we intend to show at trial. That is the PowerPoint issue. But let me show the court, if I may, in part of my argument, the video that Mr. Spratt is referring to.
May I ask to clarify which video he's asking to show?
So Mr. Spratt is referring to a crime scene location, and we're going to show the video that he mentions in his motion of this homicide that occurred in New Orleans.
Judge,
it's a 10-second clip.
Judge, I object to this if this needs to be taken off YouTube if we're going to do this. I object. If he's going to show what I think he's going to show.
Well, that's the point of this hearing, Judge.
He can show whatever I allow him to show. But what I don't know is what is this particular thing. And number two, this is a public proceeding, and that's the reason that we live stream these things. Anyone who is called as a juror in this case will be questioned about whether they have read or seen or heard anything about this case prior to the time they're called as a juror. And as a result of that, I don't think there is any basis for, we hear pretrial motions all the time. The different courts handle it differently. What exactly is the video you're wanting to show?
This is a video that is obtained by a cell phone of a resident of a location on Iberville Street in New Orleans. He is on the second or third floor in his apartment, and he films the defendant walking down a sidewalk wearing a pair of orange tennis shoes that are recovered in Houston County, in Aaron, Tennessee, in a shed, and a rifle that appears to be, and after testing is confirmed to be, the same rifle that was located in Houston County. And Mr. Brown in this video walks up to his ex-girlfriend and shoots her with this rifle.
And that is shown on the video?
It's shown on the video, but Judge, when Mr. Spratt is arguing prejudicial, this video is already on the internet. This video went to the internet before it went to law enforcement in Louisiana. This man was filming from his apartment and posted it on Instagram or TikTok or something. So anybody that wanted to watch this video can certainly already watch it. The public is not going to be learning anything new here, but we want to give Your Honor some context as to these upcoming motions, 5, 6, 7, and 8, as to how things are relevant to the investigation in this case. And I think this video, when you see the other additional proof, will be apparent.
Mr. Spratt, I'm going to allow the playing of the video, and I'm not going to stop the live stream from it because of the simple fact that it is a public proceeding, and any potential juror that would have seen anything about this would be disqualified anyway. So we will proceed with that. And
Judge, I'd ask to have the video authenticated then before it's played.
Authenticated?
Yes.
Well, it's not being introduced as evidence at this point. It's being introduced as a basis for, if before it would come before a jury, then yes, I would agree with you. But as far as authenticating it for the purposes of this hearing, I will rule your objection and allow it to be played. I need to turn the live screen.
Bro, the lady just got fucking shot outside my crib, bro. Oh my fucking God, bro.
All right, thank you. Turn the lights back on. So, Judge, this video has nothing to do with the PowerPoint that we're showing. This video ultimately is going to what Mr. Spratt is arguing under the enhancement issues. What you have just seen is a first-degree murder in New Orleans. As corroboration of that, this rifle was recovered in Houston County and ballistics testing was compared. So we have the same weapon that was used to commit a murder on June 27th of 2022 in New Orleans, and then an attempted first-degree murder in Houston County on the same day, June 27th of 2022. Same weapon, and those orange shoes that you saw in New Orleans on the feet of the man in the video were recovered in a shed in Houston County. So again, arguing one of these motions, specifically the enhancement motion, the state has never offered any plea in this case, except to the maximum possible punishment. And now the court knows why. Because the man committed a murder.
That's my motion that he's arguing before I've even had a chance to argue that one.
Well, and I would have to agree with Mr. Spratt there, General, that what we're essentially dealing with at the moment is the number 6, I think it was, that we were on, and that's the use of the barring evidence from U.S. Marshals and New Orleans Police Department.
Okay.
So the question that I have in regards to what, there was a prior order that went down that said that we're not going to get into your case in chief as to the basis for, or that the crime committed in Louisiana in your case in chief in this case.
That's correct, and we're not.
Okay.
We're not going to show this video.
What relevance then would this video have in your case in chief, if any?
Only in rebuttal.
Right. So we would have in rebuttal and go to the notice of enhancement.
Yes.
And those are the only basis for it?
Yes. That is the crime scene, though, that's reflected in the PowerPoint. Right. That's what I was trying to provide the court with some context, is that was the original pin that was dropped on Mr. Brown's phone, was on that sidewalk where he can be seen with this rifle. So, and that's kind of why I asked which motions am I arguing when I first stood up, because these are all kind of interwoven and blended the way that Mr. Spratt has drafted them. Well, I'm going to be making essentially the same argument in all of them, but I can wait and argue the enhancement.
I don't want to cut him off from making his argument.
But going specifically to motion number 4, I've already argued that as to why it's relevant and should not be barred. The PowerPoint will have no reference to a crime or a homicide in Louisiana. It will simply show the triangulation of points that Mr. Brown covered in about a 12-hour period, which is very relevant. I mean, for the identification of the defendant in this case, where he just say, well, I was in Louisiana all day. I mean, there's so many reasons why this is relevant. But then going to number 5, we agreed already to that the case is extended and complex. In motion number 6, the state will agree, we're not calling any witnesses from the U.S. Marshal's Office or the New Orleans Police Department in our case in chief. So number 5, essentially, we are agreeing to that. I think it specifically asked to bar the testimony of any U.S. Marshal or New Orleans Police Department witness. And we're agreeing to that in our case in chief.
All right, well, let's go back. Let me hear from Mr. Spratt about number 4 on the PowerPoint. We had kind of skipped over that. I think we'd gone to number 5. You were essentially telling me what you had thought was agreed upon. And number 5 was, everybody agrees on that. Number 4 is the PowerPoint presentation. And do you have any additional argument other than the fact that it shows he was from out of state?
I do, Judge, because I've filed other motions in anticipation. He agreed to that. And they have no intentions of abiding by that court order. It's clear. I'm not even on any notice when we get into motion 7 here in a minute. I'm on no notice, Judge, that he intended to use that as an enhancement. And now it would be my assertion that he's played that to this court to try to wedge into the enhancement motion that I filed. That's a clear breach of a court order. And he did. They talked in their response about that, about how they didn't make a plea offer other than the max. Your Honor.
Well, the court order says that the state shall not introduce proof of the defendant's prior bad acts regarding an alleged second-degree murder in Louisiana in their case in chief. And what he has just stated is he doesn't intend to introduce it in his case in chief. He has demonstrated this video for purposes of showing why the PowerPoint presentation showing that is important. I have questions about, for example, how are you going to exclude evidence of the fact that the defendant was identified by Louisiana authorities?
Judge, he said he had other identifying, he has other ways to identify that the defendant was in that vehicle. It's cumulative presentation and the danger of unfair prejudice. Now we've sent that interview out on our YouTube channel to the entire jury pool, and there was no need in that.
The entire jury pool does not watch. If you wanted to come down and with me when I address the jury that's coming in Thursday morning, you will find that there's probably not one of them that has watched the YouTube. So trust me, I'm not as popular as you might think.
Well, you are at my house, Judge.
But you may watch it because it's your life and the kind of things that we do, but not everyone else does.
Well,
I understand what you're saying, and again, that's no different than having an article in the newspaper, which we've dealt with for generations, and an article on television, which we've dealt with in substantially the same form. There's no difference between that. If someone has watched a YouTube channel and seen something about a case, then they can be questioned about that, and that will be a necessary question for jurors who are coming in. And the way we handle it will be no different than any other pretrial publicity. Have you read or seen anything about that, including any broadcast on the YouTube channel about this case? If you have, don't repeat what you have said. Just tell me, has that caused you to form an opinion one way or the other about the defendant's guilt? And frankly, if they've seen this video, then I would excuse them from the jury more likely than not, because I think it would be highly prejudicial. But at this point, the fact that it was played is not, in my opinion, anything that creates havoc in your case or creates any sort of problem. The question that I have is that why, if the state intends, and again, you can't limit the state on what they want to do unless it somehow prejudices your client. Your client is not from Houston County originally, is that correct?
He is not, Your Honor.
Then obviously it's going to become known at some point that he's not from Houston County. And at that point, then the fact that he's identified as leaving Louisiana, coming up without any reference to any criminal activity is, in my opinion, not anything more than an explanation of how he ended up in Houston County.
Well, Your Honor,
I don't see how it prejudices your client.
well, respectfully, Your Honor, when the agreed order was entered, I get this PowerPoint that they intended to use that in their case in chief. And now they've backed off of that. So I had to file a motion. So that triggered me to file motions for 6 and 7. I just don't, the general said something about it being relevant to Mr. Brown's location. They can do that without backing up all the way to Louisiana. And the defendant's credibility, I would understand that if I put the defendant on the stand, which is a determination that the defendant and I would have to make.
I don't think they're talking about the so-called confession that corroborates his confession.
Well, I think the state has enough evidence if they want to establish his identity without doing that. And I would just ask that Your Honor, the state's purpose is to try to establish judicial facts for a court in Louisiana. And that is their bigger concern in this case. That's why.
Repeat that.
I believe the state's purpose is to try to establish judicial facts in Tennessee that can later be used in a courtroom in Louisiana. And there's no relevance to that. There's no relevance for that at all. It's cumulative presentation of evidence when they can do that other ways. He just got through telling you they're trying to link a gun to here and this and that and the other. And why? Why? He stands accused of crimes that occurred in Houston County. It can be tried. But all of this other stuff going into Louisiana, it's clear that they have no intentions of abiding by the court order that they agreed to.
Is this being introduced in their case in chief?
Yes.
How?
The cell phone.
The PowerPoint, yes.
Yes.
But that is not evidence of bad acts. That, from what I'm told, is that the PowerPoint is simply going to demonstrate his location in Louisiana and where he went from that point and ended in Houston County. And so number one, I don't see how it prejudices your client because of the simple fact that it's clear he's not a resident of Houston County. So he's got to come from somewhere. There's no indication if that crime scene is removed. There's no indication of where that is. It's no different than tracking someone's location, especially since there was a manhunt for the defendant. My opinion is that this PowerPoint presentation with the redaction of the alleged crime scene, and if there's no reference to a criminal investigation in Louisiana in that PowerPoint, then there's nothing that prejudices your client any more than having an officer testify that he later said he was from New Orleans or wherever and was found in Houston County. I just don't see the prejudice to it. And as a criminal defense lawyer and my history of being that, I would like many times to try to limit the state's proof on what I'd like for them to be able to show and not show, but it only rises to the level of prejudice to your client that allows us to exclude something that is otherwise their tactics or their procedure that they want to do. I do not find, as a matter of law, that this PowerPoint presentation with the removal of the crime scene location, that a simple PowerPoint presentation of the location of the defendant in Louisiana and tracing his movements to end up in the spot where the case took place is prejudicial to a client. I find it to be relevant because of the fact that there was apparently left the scene, and that my understanding was a manhunt, and although there was a supposed statement whatsoever, it goes to show the identity of the defendant as being moving from that point to this point and where the crime scene occurred.
Judge, briefly, I do believe that may be a misunderstanding. He didn't have those cell phones after this crime allegedly occurred. Law enforcement's had those the whole time. So there's not going to be any evidence that shows him moving around during this manhunt with these cell phones. There is none of that. So I don't know if that changes the court's opinion. And I would say that I'm sorry.
It doesn't.
Okay.
All right. So number 4, we've ruled on that the PowerPoint is admissible with a simple removal of the crime scene, and there'll be no reference to criminal activity, but rather it's just simply showing his movements. Number 5 was agreed upon. Number 6 and number 7, which is what you were about to argue, I think, when General Crouch, at my request, stepped up and started arguing about it. And there was some indication that what Mr. Crouch is saying is they will not call any witnesses to testify. Anyone from the U.S. Marshal's office or from the New Orleans Police Department will not be called during the case in chief, but would only be reserved for rebuttal. And number 7 is the motion to bar testimony of Aaron Hatfield, which obviously is a different matter, but you want to address anything else about number 6?
No, Your Honor. I believe as stated in the email and listed on the docket notes, I think we can enter an order on 6 and 7.
6 and 7, they're not intending to call a witness from the police department in New Orleans or from the U.S. Marshal's office in their case in chief, but are reserving the right to call them in rebuttal if necessary. They're not calling Aaron Hatfield as a witness in their case in chief, but are reserving the right to call him in rebuttal if that was necessary. Is that correct?
That's correct, Judge.
Then we now have it of record. So that moves us then to number 8, which is the motion to bar the state from seeking an enhanced punishment or in the alternative to continue the trial.
That's correct, Your Honor. Your Honor, I don't know if the court's had a chance to familiarize itself with the motion. Judge, interestingly enough, in the state's response, as the court had time to review the state's response,
I've read that
it was
too.
filed yesterday.
And
My motion says that I don't take notice with the timeliness of the motion. That may have been misstated in my motion because I'm saying that the motion they filed put him on no notice at all. Simple generic terms like possession of methamphetamine, possession of marijuana, those don't comply with the statute at all. So to this moment, I would say that the time requirement hasn't been met. So perhaps that motion was or perhaps that issue was misstated in my written motion. There was a document filed. Since the filing of that document, the state has provided me with some records just yesterday from Louisiana. I only see one document in here that's signed by a judge, and that would be a plea form potentially of some sort to a domestic assault conviction. But the bigger issue I have here is that if we're ready to go to trial, I don't think they should be able to range him up based on that notice that they sent me at a sentencing hearing. And if so, I think I have to. It was incumbent upon me, or I would waive the issue to file this motion. I think State versus Benham, I've had the defendant's criminal record. I don't know if the court's had a chance to review Benham.
I've read Benham.
Okay. But it places an affirmative burden on the state to expressly notify the defendant of its intentions regarding sentencing. I knew of nothing about a range up until last week, and that was, I can't recall if it was General Turnbow or General Crouch that I talked to, but I knew nothing about any intention like that, of them to do that. And then they filed a completely defective document, which is outlined, that doesn't comply with the statute. And now they say, well, we've pulled a 51-year plea offer. Well, that's great, Judge, because they can't get 51 years out of him. We all agree on that. They're asking me to try to commit malpractice. He's entitled to be noted. He's entitled to notice of what he's facing. It affects trial strategy. That's what Benham says. It affects everything. He could change his plea. I don't know. Can't do it now if you don't know what you're doing. So General Crouch sent me a plea offer by email, August the 30th, that was dated May the 26th. May the 17th. I get that by email on August the 30th. Now, Your Honor, as of Friday, my understanding is the state doesn't have a conviction that can even support count 6 of the indictment. So I don't know how in the world, I believe he has an absolute right to know what he's facing. So one, based on the general's statements to me, I'd ask that count 6 be dismissed. And two, either we go to trial and we go to trial Thursday at range 1, or I want a continuance. And if I get if it's a continuance, I believe ethically I had to do that. I filed one motion only in this. Well, I filed a motion to change venue, a motion for a forensic evaluation, and a motion regarding New Orleans. Simple case. The state set on this stuff. These documents that they requested in the court, they weren't even requested until September 18th by somebody. That I just, if it's continued, Judge, I would ask that it be continued until March to take into account counsel's professional livelihood, personal livelihood, and everything else. Because I feel like all we've done in this case is play games with New Orleans instead of try a case in Houston County. So he's not on any kind of notice. So I do think the timeliness, whether I misstated it in my motion or not, I still don't think I'm properly on notice in compliance with the statute. So whether or not that relates back to a Rule 12B error on their part, I would say that it does, because even the notice that was shot down in Benham and the sentence is returned and resentenced at range 1 on all counts, that was more effective than what I've got. I don't have anything. I have one document signed by a judge, and it's a plea form. So I can't tell him what he's facing unless we go at range 1 or we continue. And so I would ask the court to make a ruling on that. I am prepared to go to trial Thursday, but if the state's going to be allowed to range him up, Judge, then I would object.
The range goes to sentencing.
It does, Your Honor.
It doesn't go to the guilt or innocence phase.
It does, Your Honor, but the Benham case says that it goes directly into potentially trial strategy.
Right.
Like I said, had I taken one of the pleas that he offered, I'd be up there in front of the board in trouble. So I mean, I don't think they can get what they've asked for. And I don't think it's fair for Mr. Brown could change his plea and not know what he's done. So I think he's got a right to at least be put on some sort of proper notice. In simple terms that don't comply with the statute, some of those things don't even have dates on them. I could be walking into a hornet's nest at a sentencing hearing. That's a complete denial of due process, Judge. And I'd ask if we go, and I am ready to go. If we go, I would ask that we go at range 1 or we continue to the court's March docket. And that I would ask the court to choose one of those options or let the general choose one of those options. It doesn't matter to me, but I just think that one of those options needs to be the outcome of that motion.
Judge, first of all, the state has never offered anything to Mr. Brown except the maximum punishment, whatever that may be. And we wouldn't know what the maximum punishment was until we get to the sentencing phase. The state is required to do our best job at noticing the defendant that we intend to seek an enhanced range or enhanced punishment within a range. And that's what we've done. And our pleadings and filings more than meet those requirements. But let me give the court some context. The initial offer of 51 years was extended, and 51 years in May of this year was the maximum punishment we calculated that could be given as a sentence to the defendant. And that assumes that the court were to employ consecutive sentencing. I mean, that's up to the court. So again, we noticed him or sent an offer of 51 years. We did change that offer because in our research of Mr. Brown's prior felony convictions out of the state of Louisiana, we had to compare the elements of crimes in Louisiana to the elements of crimes in Tennessee.
This has actually come up in several trials in the past. When you have charges that have the same name, but they have different meanings or different requirements to meet those charges. And when you're trying to bring things over and compare them one for one, especially when you're doing sentencing guidelines, when you have that big chart and numbers and everything, it gets all confusing, and it's quite a bit of work to figure out whether the prior charges meet the guidelines for your charges in your state. And then one state will have assault and battery, another state doesn't have assault, it only has battery, it only has assault, and they both mean the same thing, and it gets super confusing.
So right out of the gate, we knew that one of the prior felony convictions would not meet the requirement for count 4, which we had charged. So we dismissed count 4 already. Now, Mr. Spratt is alleging that we can't meet count 6, but Mr. Spratt already knows is that I am dismissing count 6 because the prior felonies in Louisiana are not the requisite prior felonies required in the elements of proving count 6. So count 6 will be dismissed, and he already knows that. Now, 45 years is the current offer, and we went through the prior felony convictions from Louisiana, and that is our best guess at the maximum that Mr. Brown can be sentenced to. And that's assuming that the court runs things consecutive, which we don't know if he will or not, if he's even convicted. Point being is there's been plenty of notice given to the defendant. First of all, one, if you look at our actual notice of impeachment and range of punishment, it is very detailed. Some of the things that are missing are conviction dates, which we have tried to amend. We literally went to Louisiana, traveled to Louisiana and went to multiple parishes, Orleans Parish, St. James Parish, and St. John's Parish, to get certified copies of these judgments. And I can put on proof through investigator Etheridge if the court wants, their judgments are different than the judgments in Tennessee. They're called Boykin pleas. And we can talk about the legals of that, but big picture, that's up to the court at the sentencing hearing to determine whether we have met our burden of ranging him up on each specific count. That's the defendant is asking you to essentially tell him what your decision will be at sentencing if he's convicted. I mean, the cart is way ahead of the horse on this thing, way ahead of it. We have provided Mr. Spratt with certified judgments of prior felony convictions that we obtained from the state of Louisiana. There is no more proof that we can put on as to what we anticipate his maximum punishment can be. We've done all we can possibly do.
Can I briefly respond again? And I believe, and if I misspoke earlier, I'm sorry, but I mean, I do understand that they're going to dismiss count 6. But that's concerning that you'd indict something that you didn't have the proof for. He's been sitting here indicted. That was a Class B felony, and now they're saying, uh-oh, we don't have any proof. That concerns me, and what concerns me is looking into this, some things, there could be some more. Judge, I feel pretty strongly that notice does not even come close to complying with that statute. It does not say what the nature of those convictions are. There are some that are missing dates. There are several that don't have court dates. I have some things that at one point I spoke to them last week. They thought there might be a felony marijuana charge. Well, I get that. It's whatever that is. It appears to me to be certified copies of docket minutes from the court. None signed by a judge other than a plea sheet that I've seen. But last Friday, just as early as last Friday, they thought there was a felony marijuana conviction, and that says clearly 14 grams or less, which is not a felony here in Tennessee. So, I mean, I just feel like that statute was just not even close to complied with. So, I mean, we just asked if he were to decide, this goes deep into trial strategy. And he's entitled to be put on notice of what he's facing. I realize you might not be able to change that at a sentencing hearing, and they've got to get a conviction first. I understand that too. But for me to go into a trial and not be able to tell him what he's facing, that begs the question as to whether or not I'm competent to represent him. And it begs the question as to whether or not he's got post-conviction relief issues if there is a conviction when it's over with. So, I mean, I would strongly request the court to either we go at range 1 or we continue it. I don't think there's any other way that I can effectively represent Mr. Brown.
Judge, ma'am.
I'll give you both sides. It's Mr. Spratt's motion, so he'll have the last say, but you certainly can address it.
I just want to respond to one thing. For example, count 6. Based on our research and the criminal history of Mr. Brown, we thought we could prove that element of the crime in count 6 and 4. Again, we met with an assistant district attorney in Louisiana to get an interpretation of their statutes.
Louisiana is under the Napoleonic Code. Their entire legal system is different than ours. So it's not surprising that there could be some differences in the I say they're under the Napoleonic Code. That's the basis upon which their system is different than ours.
And that's what I wanted the court to know. We didn't indict him in bad faith. We literally had to get legal advice on the interpretation of the Louisiana law. I'm not obviously not licensed to practice law in Louisiana. So we had a lawyer, a prosecutor licensed in Louisiana to help us interpret and show the equivalence to our crimes. And therefore we dismissed count 4 and we'll be dismissing count 6.
Mr. Spratt?
He doesn't have a lawyer in Louisiana. I'm certainly not one. So if they've had the opportunity to do that, then why shouldn't he get the opportunity to have a Louisiana lawyer or at least consult with somebody? I mean, I don't know when they had time to do that, but if they had time to do that, certainly they could have put me on some sort of proper notice.
The question that I'm dealing with here is basically whether or not the state's notice of enhancement complies with 4035-202 of the Tennessee Code, which is basically the section that requires the notice of enhancement. Let me make sure that has it. All right. And that section provides notice of intent to seek enhanced punishment, statement of enhancement and mitigating factors. So first part under subsection A says this: if the district attorney general believes that a defendant should be sentenced as a multiple, persistent, or career offender, the district attorney general shall file a statement thereof with the court and defense counsel not less than 10 days before trial or acceptance of a guilty plea, provided that notice may be waived by the defendant in writing with the consent of the District Attorney General and the court accepting the plea. The statement, which shall not be made known to the jury determining the guilt or innocence of the defendant on the primary offense, must set forth the nature of the prior felony convictions, the dates of the convictions, and the identity of the courts of the convictions. The original and certified copy of the court record of any prior felony conviction bearing the same name as that by which the defendant is charged in the primary offense is prima facie evidence that the defendant named in the record is the same as the defendant before the court, and is prima facie evidence of the facts set out in the record. It does not require that a certified copy of the convictions be attached to the notice. The notice that is set forth is only requiring 3 elements. 1, it must set forth the nature of the prior felony conviction, the date of the conviction, and the identity of the courts for the conviction. In the Benham case that Mr. Spratt has referred to and relies upon, the Supreme Court in 2003 found that the notice or purported notice that the District Attorney's Office gave was insufficient because of the fact that it was not formed in a separate pleading, but rather in discovery. And in the discovery, if I recall the statement of it, that the discovery said, well, with the defendant's the defendant, based on his overall record, is a career offender. That was it. That was what the District Attorney's Office said. The state then attached to the discovery response a photostatic copy of the defendant's record of criminal offenses. The record contains the charges, the identity of the courts where the conviction occurred, and dates of disposition. But it doesn't give any sort of indication as to the nature of the convictions. So by statute, the District Attorney General notifying a defendant of intention to seek enhanced punishment must set forth 3 items. This is from the Supreme Court: nature of the conviction, the date of the conviction, identity of the courts of the conviction. And that is what was there. Although the Court of Criminal Appeals stated that it appeared to contemplate the filing of a separate notice, it went on to say that that was sufficient. The Supreme Court said, no, we think they have to file a separate notice, and that separate notice has to be formed or has to be identified that it is a notice of impeachment or range of punishment. So as opposed to the Benham case, in this case, 10 days prior to the trial, the state has filed a notice of impeachment and range of punishment. It was timely filed. The defendant even acknowledges that. And in it is styled a notice of impeachment and range of punishment. It then goes on to list 16 prior convictions of the defendant. It does go on to give in the first 11 of those convictions gives the nature of the offense, what it was, the court or the area where it was located, and the date of the conviction or the date of committed. And those 11 comply with this court's opinion with the statement that the statute provides, as well as what the Supreme Court in Benham said is must be given. Number 12 says he was convicted of the offense of resisting an officer in St. John the Baptist Parish, Louisiana, in a case number, but it doesn't have the date. Neither does number 13, number 14, number 15, and number 16. None of those have an actual date unless you count the date number, the date somehow being the case number, which this court finds is not sufficient. So this court's of the opinion that the 11, 1 through 11 of those prior records on the notice of enhancement and impeachment, rather, and range of punishment would be in fact complying with the statute, and therefore would be timely filed. It would be evidence that it complies with the statute. And for that reason, the defendant's motion to exclude that and proceed as arranged 1 is denied. He's, number 1, he's going to trial on Thursday. I'm not going to continue the case. It will go to trial on Thursday. Mr. Spratt has done an admirable job in getting this case ready. He is very obviously impassioned in his defense of the defendant, and I expect nothing less than that. Mr. Pratt's a very capable attorney, and the fact that he may disagree with this court's ruling, he may disagree with the state's position in the case, but it does not change the fact that he is prepared for trial. Those prior convictions are admissible under both State versus Benham and the state statute or notice of impeachment and enhancement. And as a result of that, the motion on rule number 8, I guess it was, is respectfully denied. Is there anything further on this case? If we are ready for trial on Thursday, we will begin jury selection at 9 o'clock. Thank you.
All rise. The Circuit Court of Dixon County is now in session. The Honorable Judge David will preside it. All you had visit before this court, draw nigh and you shall be heard. God bless the United States, this state, and this court. You may be seated.
All right. We are ready to take up the issue of the State versus B.J. Brown. We're going to bring up Mr. Brown. All right, this is was scheduled to be the trial date on the attempted first-degree murder charge. As of late yesterday afternoon, the case was continued by agreement with the state and the defense based upon some information that had just been delivered, not made aware of, but I think it was information that is salient to the defense that needed more time to try to resolve the issues. So we are now looking at trying to set a new trial date. Our next term of court is in March of 2024, and unfortunately, we have pretty well already filled the month of March here in Dixon County with significant trials. We have the 30th and the 30th and the 1st, I'm sorry, the 29th and the 1st of February, 29th of February and the 1st day of March. We have set criminal trials here in Dixon County. On the 4th, we have the circuit civil docket call. On the 5th of March, we start Ricky Allen Hughes, attempted first-degree murder. That's with Mr. Flanagan and General Allen. Then we have on the 6th, Haley Brown, a vehicular homicide case. That's your case, correct? And that's scheduled to potentially go through the end of the week. And on the 8th, I think is General Arnold may have some additional cases. On the 11th, 12th, we have a criminal docket call. The 13th, we have State versus Pollard, which is a rape trial. Is that Ms. Smith's case, if I understand it correctly, that we had motions on? And it's been continued a number of times, so it's going to have to go. And then Friday the 15th is the DUI day, if I recall correctly. The 18th is Chancery Day, then the 19th through the 21st is supposed to be the Judicial Conference in Murfreesboro. I'm not really supposed to say where it's supposed to be, but in any event.
We'll be there. Thanks for the invitation, Judge.
22nd is the Howard Hogan drug case. Then we go to the 25th and we have criminal trials, Robert Capes and some others that are set behind it. And then we have VOP Day on the 26th, 27th. 28th is Chancery, 29th is Good Friday, and that is it. We have filled up a lot of the month of April that would normally be in Humphreys County with criminal trials here in Dixon. The circuit civil docket call on the first day of Humphreys County, first day of April is a Humphreys County circuit civil docket call. And then I have a will contest set on the 2nd here in Dixon County. Then we have Chancery on the 3rd and 4th and 5th in different counties. Then I have a criminal docket in Waverly on the 8th, and we start the 9th through the 12th criminal trials in Waverly. And then we have Paul Garrett starting here in Dixon on the 15th, and backing that up starting on the 18th and 19th is the State versus Travieso, which is
second-degree murder case that was continued from Tuesday of next week. And then we have criminal trials in Dixon again on the 22nd and 23rd. Then I have Humphreys County violation of probation on the 24th. Then I have the 25th and 26th as Chancery, and the 29th and the 30th, we said again, criminal trials, and that one is Watson Thomas, an aggravated rape case. So, anybody have any suggestions?
Yeah. Your Honor, as the court is aware, this case originated in Houston County. Venue has been transferred to Dixon County, but I think it would be appropriate to use a Houston County trial date for this case. I know the folks in Houston County, prosecutor and the sheriff and all would be happy to move some of their criminal cases and let this case take its place.
Well, I have December the 12th through the 14th as criminal trial dates in Houston County.
And the state would be ready to go by December the 12th.
There's a logic to that, Mr. Spratt.
There is, Your Honor, other than I have, and I'm not sure the exact amount, but I believe I have 10 cases set for trial with Judge Wallace in December. Some of those are very serious. Some of those have age on them that I need to address those. So, I mean, December's there's
what
a rape trial that's set on a retained client that's about 6 years old, maybe 7.
When is that set?
It's set December 7th, I believe. I'm sorry. Set right now, December 8th. I have sentencing hearings set in Houston County. I have trials set the following week in December in Humphreys County. I have an aggravated sexual battery set on December the 12th in Humphreys County.
And who is the judge in Humphreys County?
It'll be Judge Wallace in December.
I think I can help you with that situation. This case, in my opinion, would take precedence over any of your other cases. And if I can, we'll take a break and I'll contact Judge Wallace and see if there's any problem with that. I do think it is important to try to get this case heard and decided, and I don't mind giving the continuance yesterday as we discussed for the basis for it. Turnbow?
Yes, Your Honor.
Stewart County is your bailiwick. What are we looking like for trials in Stewart County in the month of November, starting through, say, the 14th through the 17th? I'm showing our trial dates.
It is, Your Honor. Let me pull up the trial schedule right quick. I mean, we do have some cases that are a little older, Judge, that need to be tried, but no one that I'm seeing is incarcerated. We have some cases that are a little older that need to be tried, but I'm not seeing anyone who's incarcerated on older cases, so.
All right, well, let me see the counsel in the jury room across the hall. I'd like to bring your calendar and let's see what we can figure out.
All rise.
Well, I thought there's a head down there, and I know it's not, I didn't think it was Pam Billingsley, but I thought she was on the screen here, so wanted to know whose head I was looking at.
She come in to do that, so I wouldn't have to run around.
Good.
Can you just say the very tip top of my head? Yeah.
All right, after a thorough conference with lawyers involved in this case, we are going to, instead of trying to move this case to March, we're going to expedite it and move it to January the 23rd through the 26th
will now be the new trial date. It will be here in Dixon County in this courtroom. In addition to that, we are now setting some additional motion days. A status day or a motion day will be on the 9th of November here in this courtroom. That will be after the Paul Garrett rape motions on the 8th. We also have a sentencing hearing on State versus Tomlin that day. But Mr. Brown's motions will be heard on the 9th at 9 o'clock. We're going to have Mr. Brown transported on the 8th so that he can be here and meet with his lawyer in advance of those motions, and have him here on the 8th and 9th for those motions. In addition, then, in the month of December, when I would normally, this is originated in Houston County, and my Houston County docket is going to be on the 11th. So at 1:30, I have a status on the State versus Stephen Wiggins regarding the motion for new trial. We're going to set a status day in this case for the 11th of December. All of this, Mr. Brown, for your information, is designed to try to expedite and make sure that everything that needs to be done in your case to get ready for your trial in January is being done, and that there aren't any glitches like we've had this time, okay? So all we're trying to do is to make sure that we keep it on track and that it will not be continued from that January trial date. So we're going to trial on the 23rd of January. With that being the case, then, so we have 3 new dates. The 9th of November, and I'm sorry, we're going to need to transport him, I believe we said on the 8th of December, and have him held through the 11th. And then on the trial, we're going to need to have him transported from the Department of Corrections on the 18th, and then hold him through the trial at that point. And we're going to do an order for the Captain Davis. We're going to do an order that will reflect all of those days we need him transported. But that's all in an effort to expedite and assist Mr. Spratt in trying to communicate with Mr. Brown and make sure that everything's being done accordingly. Anything else then, with that having been announced on the record?
Just briefly, the motions from Tuesday, the orders for those, do those need to be, I guess since I've stood up and raised the issue, I'm kind of volunteering that I'm going to have to draft those.
Well, I know you've got a full plate with some other things. Is there any reason that those motions couldn't be done by the state, or the order on those motions couldn't be done by the state, Mr.
We'll be happy to draft orders on Mr. Spratt's motions.
Well, if they're your motions, then logically they would be an order that you would need to draw. So.
We can do them, Judge.
Well, you two talk. I don't care who does it. I just want to do it. Being in private practice by himself, or even if he's in Baker Law Group, it is a situation where he doesn't quite have the same advantages that perhaps your office has. So y'all talk about it. I don't care who does it. I just want to make sure they get done. I do think a written order reflecting that ruling is clear for the record, and it's an advantage. Then is there anything else with this case then before we adjourn? Pardon?
The December 11th date, when do you want him transported?
On the December date, we need him transported on the 8th to have him housed here in, is that correct, the 8th?
Yes.
All right. 8th of December will be the day we need him transported here so that Mr. Spratt can talk to him that afternoon and be ready for the hearing on the 11th. And then he'll be transported from the Dixon County Jail to the Houston County Courthouse, where that hearing will take place at 1:30 on the 11th. All right, anything else?
It's all from defense, Judge.
All right, then we'll hopefully, everything will be now in place to carry this on through and have it tried in January, and we'll be adjourned for the day. Thank you. We have
all rise.
Do you know how they say never loan money to family? Add never rent them a bedroom to that list too.
This is file 231199LT. This is a strange circumstance. Shanette Huffman is the plaintiff. The defendant is Kyle Aiken. They actually live at the same house, which is 11581 Floating Bridge Road. The defendant rents a bedroom. There does not appear to be a lease. The place is a mess. You included pictures. He looks like a hoarder. Who is Mr. Kyle Aiken to you?
He is my nephew.
Is he still there?
He has not been here since August 2nd.
All right. Six. I was looking at the proof of service, and it looked like they gave the proof of service to you. It says it was served on co-tenant. Let me see if I can find it again. Wednesday, September 22nd, it was served on co-plaintiff Derek Nee. So I think he called it attachment. That was September 27th, and he would have already been gone. So I don't have service. So I have to continue this. Do you know where he is?
I have no idea. Last I heard, he is couch surfing with friends and getting kicked out of their houses too.
Did he just leave all of his stuff there?
Yes, Your Honor. Including a dog.
How is he your nephew?
He's my sister's son.
Where is his mother?
She's in Comstock, but they have a very estranged relationship. He did have mail from the court sent here. I got it to her. She got it to him when he dropped his kid off. But as far as any communications about it, I'm not sure.
Which court was that from? Kalamazoo County?
No, it would be from St. Joe County, sir.
Regarding landlord stuff or something else?
For this.
Okay. Well, he doesn't seem to have anything pending in my court. All right, well, the law requires that I'm gonna have to adjourn this for 7 days. And then to make it even more convoluted, he gets 10 more days from that to move out. At which time you can throw all of his stuff out. Except the dog, I'm not sure what you'll do with him. But that's.
I was already in contact with animal control regarding the dog.
Okay, well, you can't do anything yet. I'm gonna continue this to 1:40 next Friday. Excuse me. I don't need to cram that in. Let's set it for 9:20 next Friday, October 13th.
Okay.
All right, so I want you to log in by Zoom again next Friday morning, October 13th at 9:20 a.m.
Okay.
He would then get 10 days from that day to move out. It sounds like he just left. Did he have a car?
There is a car here. It no longer works. He left that as well.
Was he employed anywhere?
He was, and then he lost his job late last year. And then instead of being a responsible adult and going out and getting another job, he sat in the room and didn't do anything until I want to say May or June of this year. And
Well, the
had
reason I
made-
asked, I wonder if he was employed somewhere, he could get a notice there, but you don't know if he's working anywhere?
I don't know. The last known job that he was working was Scapes, is it Scapes Lawn Care Service or landscaping? And this is hearsay, but I had heard that he is no longer employed by them. So I
Well, it sounds
don't have-
like a sad circumstance, but we have to follow the law. So
Correct.
we will address this further next Friday, October 13th at 9:20 a.m. I'm sure you'd probably like to get your whole house back.
Absolutely.
All right, I'll see you then. Thank you.
All right, thank you.
Are here. And the defendant, Kyle Aiken, this matter is set for 9:20. We were here last week. The file number is 231199. We learned from Ms. Huffman and Mr. Nee that the defendant, Kyle Aiken, is her nephew. There is no lease. He was paying for a room and has left the place in a mess and left where they did not get personal service on him. So we had to continue the matter for 7 days. Ms. Huffman, have you heard anything from Mr. Aiken?
I have not.
Everything is just as it was last week?
Yes, sir.
I find by default, the plaintiff has a right to possession of the premises on or after 10 days from today, which would be October 23rd. No money judgment is entered. The appeal date is also October 23rd. Ms. Huffman, what I would suggest, don't throw his stuff out, but put it somewhere. You certainly have a right to, at the end of 10 days, to clean that room out. I wouldn't dispose of his property. I just set it somewhere. So if he hasn't moved in 10 days, you can get the actual writ of eviction and take possession of that room back. So after 10 days, you have to come to the courthouse and bring $15 to get the writ of eviction. Then you can just execute it yourself by moving his stuff out of that room.
Okay.
Do you have any other questions?
Am I responsible, like, if we move the stuff out of the room and put it outside in his car or by his car?
I would put maybe in his car. I wouldn't put it outdoors. Now, do you still have that dog?
No, sir. I was with contact with animal control shortly after August 2nd. I want to say maybe the 3rd or 4th, asking them what my options were. They advised me to hang on to it for 10 days to per the law, which I did. And then we found a foster for him, and I'm not sure where it's at from there.
All right.
I did not have the resources available to take care of his dog plus my animals. I budgeted for my animals for the month.
Well, I'm not being critical. I just wanted to know
Yeah.
what happened to it.
As far as
right.
I know, it's at the foster.
Okay. 10 days from today, October 23rd, you can get the writ and you can move all his property. Now, you also stuck with his car on your property.
Yes.
And it's, does the car run?
Nope. It is disabled.
It runs, it just has engine issues.
When was the last time it was started though?
It's probably a dead battery now.
Well, at some point, you could move the car off of there. But he's your nephew. Where are his parents?
Comstock.
No, that's what you said last week.
Mhm.
But with the writ of eviction, you would also have the right to move his car off of there. But perhaps the wiser course might be to find a place to dump it on a relative or something, but we'll cross
She
that bridge when
won't.
we get to
I was gonna say, she doesn't want anything to do with this.
All right, well, let's see what develops. All right, October 23rd, 10 days from today. Thank you.